until hearing. Plus, right, back to level 4.
Good morning. Before we proceed, Mr. Chanona, we saw 2 logins with your name. Can you confirm who the other party is using your login?
Mr. Laban, Tony, I don't know using my login name. Yes, so Mr. Laban is at our head office in a conference room, and I'm in a different location.
So no problem. So for the time being, we will not admit the witnesses. So we will remove Mr. Laban and we will admit it at the appropriate time.
Okay, understood.
Should I leave the room then?
Well, if you're in the same room, yes.
No, we're not in the same room. We're totally far apart.
No, well, you can stay in the room, but we'll take you off the link and admit you when we are ready for you.
Sure.
Oh, Mr. Laban, perhaps it may be better that you leave. Mr. Chanona, can you ask the parties at your office to leave the link entirely, because we're not certain which one it is to demit from the hearing room.
Okay, I'll do that now.
Thank you very much.
Okay, it will be done shortly. Someone's coming to turn it off.
Oh, thank you. In the meanwhile, can I confirm everyone is hearing me, or the other attendees in the hearing room?
Legal representatives for NHR are hearing you.
Thank you very much.
We are hearing you, Mom.
Thank you very much, Ms. Speak. In the event there are any other witnesses from any of the other parties, perhaps you can ask them to leave the hearing room at this time. The hearing room, as well as the rooms that you all are in.
Well, I am based in St. Lucia, so quite a distance away from you. Is it that I'm required to leave also because it's a public hearing? So I'm here as a public.
Yes, Mr. Peters, and you are a representative of which party?
I am with NH International, but not as a witness.
Okay, great. So we will. That's fine, Mr. Peters. You may proceed.
All right. Okay.
We're going to call the matter now.
In the matter of CP 2025-2, Kee Chanona Limited against Urban Development Corporation of Trinidad and Tobago, and CP 2025-3, NH International Caribbean Limited against Urban Development Corporation of Trinidad and Tobago.
Good morning again, everyone. I am Sparkle Salmon. I'm presiding this morning over today's panel. The other members of the panel are Ms. Barry Kelsett and Mr. Robbie Bowler. Is the applicant for CP 2025-2, Kee Chanona, present? Could you give your name for the record?
Yes, Thomas Chanona is present for Kee Chanona Limited.
Thank you very much, sir. Is the applicant for CP 2025-3, NH International, present?
Yes, I am Jason Mutu. I represent the interests of NH International Caribbean Limited. And with me is Mr. Mara Tulsi to my immediate right. And also in the room is Mr. Cavan Byrne, who is instructing attorney in this matter. As Mr. Peters indicated, he is the client representative, and he is also on the link this morning and visible to the panel.
Thank you very much, Mr. Mutu, and the representative for the respondent.
Good morning, Madam Chairman. My name is Deborah Peak. I appear for the respondent to the two applications. With me is Mr. Ravi Hefesdoon, and we're instructed by Ms. Carla Williams, who is on the link, who is also the client's representative.
Thank you very much, Ms. Peak. So before we proceed to today's hearing, we'll just go over some of the ground rules. I know the parties should be familiar because we went through them on the last occasion, but just to recap, parties are asked to speak clearly into the microphones to avoid disruptions and, for example, the rumbling of paper in the background. To mute your microphone when you're not speaking. Parties are asked to seek the leave of the panel if they're required to leave the room or if they want to admit someone else to the room or actually leave the sight of the camera. Parties are asked to desist from interruptions. If you would like to intervene when your friend is speaking, you can indicate via the raise hand signal or communicate it in the chat. And if for any reason we lose connection, you can connect or contact the hearing secretary, 627-4677, and the extension today is 1156. You should also send an email copying all parties in the proceedings, indicating exactly when you lost connection. Also, set the volume at set your volumes at a tone that would prevent feedback or reduce feedback, I should say. So today we are supposed to commence proceedings in accordance with Part 5 of the Act, the Challenge Proceedings Rules and Regulations, and Part 5 of the Hearing Rules and Procedure. Before we proceed, I would like to find out if there are any preliminary issues that the parties would like to raise. We'll start with Mr. Chanona.
No, Madam Chairman.
Thank you very much, Mr. Chanona. Mr. Mutu?
There is one matter. Yesterday, the tribunal issued an order requiring UDeCOTT to disclose to the parties the unredacted evaluation report for the procurement proceedings on or before 4 p.m. yesterday. That followed on an earlier order made on the 13th of February, which set out an obligation to disclose subject to an application for redaction having been made by 10 a.m. In respect of both of those orders, there has been non-disclosure to us. I don't know if the tribunal has received it, but the failure to disclose that document has adversely affected the case that my client is running today. And I wish to inquire through the tribunal as to whether the report in an unredacted form has in fact been disclosed to the tribunal by UDeCOTT.
So, Mr. Mutu, we are not yet in receipt of same, but I will let your friend Ms. Peak respond.
Thank you, Madam Chairman. The panel ought to have seen an email that we sent yesterday afternoon after receipt of the order. And can I say that we were rather troubled, and our client was rather troubled when we had receipt of that order yesterday. Now, as we'd indicate, well, first of all, has the panel seen the email that was sent yesterday that indicated opposition?
No, please.
Okay, so this was sent, it was sent at 3:54 p.m. But basically, we pointed out that the order that was sent following the hearing on the 13th of February that had certain deadlines, including a 10 a.m. deadline on the 14th, was received after that deadline had passed. So, and I can say that after we left the hearing on the 13th, the impression I had is that what we were required to disclose was in compliance with the record regulations 4G, which we had a discussion about, which was the summary of the evaluation of the submission. So that is what we had set about preparing. And then we received the order on the 14th. Now, NH was pressing for the disclosure of that report, and we did our best, and we did disclose the redacted report on the understanding that we had already raised with the panel on the 13th the issues we had relating to confidentiality. So we did the best that we could to redact information that related to the other bidders, but redacted nothing that related to the applicants that are before the panel, with the intention of making an application at the hearing today for the leave of the panel to file the redacted evaluation report, because by that time the panel will have seen the redacted report, which was filed on the day set out in the order, which I believe was the 14th. What has happened since then, of course, is that in compliance with the order of the panel, witness statements have been filed in compliance with the order of the panel, and submissions have been filed in compliance with the order of the panel. And therefore, so far as we are concerned, no complaint was raised by any party, whether Kee Chanona or NH, with regard to the redacted document. And in fact, both applicants have referred to the redacted evaluation report in their witness statements and in their submission. So in our respectful submission, I'm surprised that my learned friend, Mr. Mutu, says today that his client is adversely affected. Certainly nothing like that has been said in the witness statements or the submissions which have been filed. Now, the order that was received yesterday, Madam Chairman, refers to Rule 8.3 of the hearing rules, which is not a rule that requires the respondent to serve a document on the other party. It is requiring the respondent, in compliance with Section 55, as it says, to require the respondent to provide the panel with access to documents in its possession. And in that email, which unfortunately you have not seen, what we said is that we are prepared to disclose the unredacted report to the panel for the panel to satisfy itself that nothing relevant to the two applications has been redacted. And in our respectful submission, that is in fact in compliance with Part 8.3, Section 55, and the section that we had addressed you on, which is Section 52, which says quite clearly in the Principal Act that no information shall be disclosed in challenge proceedings if it would prejudice the legitimate commercial interests of the suppliers or contractors. And what we said in the email, which you have not seen, is that we have not redacted anything relating to these bidders or anything relating to the other bidders, which is relevant to the issues raised in the two applications for review and the disclosure of the scores of the other parties. Now, in fact, the parties did get the scores of fides in the letters which followed the intent award. And the information, the disclosure of the scores of the other parties and their information, we see, has a strong tendency to compromise the confidentiality of the information and the integrity of the procurement process, and may compromise the fairness and integrity of any future procurement process for this process in the event it has to be repeated as it happened in the past. Now, part of the RFP, which both applicants signed on to, says that and requires UDeCOTT, subject to the requirements of the Freedom of Information Act, to keep all confidential and proprietary information submitted by the proponents in the strictest confidence. So in our respectful submission, when you read 8.3, which is what is cited in the order that we received, section 5010-52, we are prepared, if the panel requires it, to disclose the unredacted report to the panel for the panel to satisfy itself that we have not indiscriminately redacted. But I take it that by now the panel will have looked at the report, and you will see that nothing relevant to these two applicants has been redacted. What we've redacted is the information relating to the other bidders. And in any event, the part 8, which relates to disclosure, talks about disclosing documents required to prove the party's case. And it says that where there is a failure to disclose documents, the consequence is that you cannot refer to the document or introduce it in evidence at the hearing without leave of the hearing panel, which of course is quite different from disclosure requirements in the rules of the Supreme Court. So in our respectful submission, we are asking for leave to file that redacted evaluation report, which was filed on the 14th of February, and for the parties to have use of same. And if the panel requires it, we will produce to the panel the unredacted evaluation report. That's our respectful submission.
Thank you, Ms.
And application, sorry.
Thank you, Ms. P. So at the same date and time, oh, Mr. Mutu, sorry. Yes, Mr. Mutu?
Yes, I would like to respond to that if the panel will permit me leave.
Yes, Mr. Mutu.
Yes.
Check your email.
It is very, very concerning that at this stage, there are 2 orders made against UDeCOTT, which it has failed to comply with. That and continues to fail to comply with. That's point 1. 2, the evaluation report goes to the heart of certain issues in this case, because one of the grounds upon which NH is mounting its challenge is the failure of UDeCOTT to apply its stated criteria in the scoring process. That's clearly set out. The evaluation report is a document which will show, it is the best evidence, contemporaneous evidence, to show how UDeCOTT scored all of the proponents in this process. Thirdly, irrespective of the order itself, UDeCOTT is under an ongoing duty of disclosure to disclose to the office, the procurement office, all documents in its possession relating to the procurement proceedings, access to those documents. And that is clearly set out in section 55 of the Act. Fourthly, this process of reduction which has taken place is contrary to how reduction ought to take place. It is well established by the Court of Appeal that where a party is redacting a document, it is not for the party themselves to do so. The document must be submitted in an unredacted form to the court, and then the parties can make submissions in relation to that. That is clearly set out in Civil Appeal number P16 of 2018 between Ravin Ramkisoon, the Estate Management and Business Development Company Limited, and others. And we can supply a copy of that judgment to the panel if necessary.
Please do so, Mr. Mutu.
Yes, I will cite from paragraph 27. It says this. However, it seems to us that the applicant is correct in principle in asserting that the making of reductions or the extent of such reductions should be made by the court and should not be left to the discretion of instructing attorney for the party applying for the order. The correct procedure, we suggest, is that the court which makes the order should direct which parts of the order ought properly to be redacted to protect the identity of a third party and the confidentiality of the information from that party to be served with the order. The obvious point here is that UDeCOTT in these proceedings, challenge proceedings, their process is under inquiry, but they are policing themselves, and that, with respect, is an entirely untenable submission or position, rather. Further, I heard counsel for UDeCOTT submit that we made no submission that we were prejudiced by the failure to disclose the unredacted version of the report. That, in our respectful submission, is entirely surprising, because on the first day of this hearing at the case management conference, we pressed for it. And as far as we understood the direction of the panel, UDeCOTT was to disclose it, subject to UDeCOTT having a right to make an application to withhold or redact certain parts of the report. So there's no ambiguity there. And the question of prejudice has always been on the table. It is an issue frontally raised by us. And with the greatest of respect, it cannot be for UDeCOTT to be running these proceedings. As far as we are concerned and consistent with the rule of law, it is this hearing panel that makes the orders and directions, and that UDeCOTT has been in flagrant breach of it. We will address the panel at the appropriate time for with respect to the consequences that flow from that non-disclosure. But I heard UDeCOTT this morning to be indicating that they are now prepared to disclose the report to the panel. If that be the case, I would ask, I know the hearing is fixed for today, I would ask that UDeCOTT be directed to now immediately disclose it to the panel and to the parties, so that we can make what use we can, if any, of the report during the course of these proceedings. Those are my respectful submissions, Chairman.
Okay. Thank you very much, Mr. Mutu. So, Ms. Speaker, at the CMC, at which all parties were present, the panel indicated that by 10 a.m. on the 14th, UDeCOTT was to indicate whether or not they wanted any parts of the report redacted. And it was at that stage we were expecting you to send the entire report and let us know the grounds on which you wanted certain parts redacted. At that stage, the tribunal would consider, or the panel would consider, the entire report and determine whether or not we agree with you that certain parts will breach confidentiality, right? The directions for doing so were given on the same date as the witness statement. So I understand that we did not get the order until just after the deadline. However, the order was given on the 14th. The actual order was sent to the parties on the 14th. It was sent before the deadline to file the redacted version, or file the actual, or disclose the actual report, right? So perhaps what we can do now is that you can send us the entire report. We can stand down, we can look at it, and then we can determine if, based on your submissions now, we will allow the redaction, or we would ask that you serve the entire report. Would you be positioned to send it to us?
As we said in the email yesterday, which was sent before 4 p.m. yesterday, we said we are prepared to disclose the unredacted report to the panel, for the panel to satisfy itself that nothing relevant to the two applications has been redacted. But let me just deal with something that my learned friend Mr. Mutu said.
Yes.
The complaint that NH made is in relation to how its bid was scored. Challenge proceedings are not an opportunity for proponents to reopen the entire evaluation process. In any proceedings, any tribunal which has a power to order disclosure is required to first ascertain and determine whether disclosure is relevant to the issues before the panel. In our respectful submission, I mean, NH is the only one who's making complaint, but their grounds of challenge in their application for review by which they are bound relates to how UDeCOTT scored or determine their application for review. And if the panel has had sight of the redacted document, you will see that we have redacted nothing in there that is relevant to NH. The same applies to Kee Chanona. And therefore, in our respectful submission, nothing in the Act or the rules requires any procuring entity that has challenge proceedings filed against it to submit the entire evaluation report to the committee. And the chairman just said something of which it takes us by surprise, because we are now being told that the expectation of the panel was that we should send the entire report to the panel, and then the panel would somehow do some kind of review and then determine the question of redaction. Well, that was not said at the hearing, and it was not reflected in the report. So you will forgive us if we did not comply with any such requirement. So
before I proceed, the actual order was that if you want to have any parts of the report redacted, you should make that application. Our expectation is that the application will be accompanied by the entire report, so we would know which part you need, whether or not the basis of redaction were valid. So to first consider it, we needed the entire report.
Well, with respect, it doesn't necessarily follow, because our application for redaction might have said that we propose to redact only the information that relates to the bidders other than the applicants that are before the panel. That would have been a perfectly acceptable an approach to take. And if the panel required other information, then of course it would have been supplied. But I mean, we've gone past that because we know we did not meet the 10 a.m. deadline. And that is why we're making the application today for proper housekeeping. We are prepared to disclose the unredacted report to the panel in compliance with the provisions of the Act that requires the procuring entity to provide the OPR with access to it. But we are respectfully objecting to the unredacted report being submitted to any of the parties in these proceedings for the reasons which we have articulated. And we want to make it clear that disclosure to the panel is on the premise, on the basis that it shall not be disclosed to the other parties. And those are very firm instructions. We do not think that it is appropriate to set a precedent that where an applicant for on a challenge comes before a panel of the OPR, that it follows as a matter of course that the entire evaluation report has to be submitted to the parties. We are here the hearing in very, very abbreviated timelines where the decision of the panel has to be delivered on Thursday. And we come here today on the expectation that we are going to have a hearing at which the witnesses who have already given evidence will be cross-examined today. We're not here now looking at further evidence in our respectful submission. So in compliance with the order of the panel, we will, and in keeping with the undertaking which we gave, we will disclose the unredacted report to the panel, and the panel is entitled to look at it and make any conclusions that it wishes to make. That is our respectful submission. And as we understand it, the sanction in the rules by which the panel and the parties are bound is that if you do not disclose a document in compliance with the part, the sanction is that you are not entitled to rely on it. That is the sanction. And we would respectfully ask the panel to observe the requirements of the rules, just as we are required to observe the requirements of the rules. So I will have my instructing attorney send to the hearing secretary the unredacted copy of the evaluation report.
Thank you, please. I see your hand, Mr. Mutu, but in interest of time, when we first consider the unredacted report, and then we get back to the parties as it relates to further submissions, if necessary.
Yes.
Ms. P, the thing is, any redaction is a tampering of a document. Any document that you submit to the court should be original, or serve on the other party should be original and untampered. And if you require to change the document in any format, this is where we require the application. That is what was ordered on the last occasion. So in interest of time, we will await With the unredacted report, Mr. Mutu, and Ms. Pick, and Mr. Chanona, we will stand on the matter for about 15 minutes. That should give us enough time.
I would just like to make two brief points.
Yes,
it seems that we are being drawn into a realm of considering whether reduction is appropriate. Orders have been made and those orders have not been set aside. And no application has been made to set aside those orders. So the avenue which UDeCOTT is asking you to embark upon, it is our respectful submission, is not open to them. No such application having been made. That's the first point. The second point is that insofar as the panel comes to consider the redacted report, we respectfully invite the panel to look at our letter dated 13th of February 2025, which attaches the case of Amarales, and various sections of that case are set out. The third and final point I wish to make is when you look at UDeCOTT's pleaded case at paragraph 14 of the pleaded case, as well as paragraph 14 of the witness statement of Mr. Gurja Tiwari. Forgive me, it's paragraph 19 of the pleaded case. What is advanced in both instances is a comparison between what NH did and what other proponents did. So clearly, UDeCOTT is inviting the panel to consider differing positions. And that comparison cannot be undertaken unless we actually see how the report dealt with the other parties. And allied to that is that both NH and FIDES were awarded a score of 6 out of 10 on the sub-criterion amenities user brief compliance. So what we have there where FIDES is now being considered for the purposes of award, and NH has the same points. We're entitled to look at it because one of our grounds, and I said this at the outset, is a failure to properly apply the published criteria. I won't detain the panel any further on this issue.
Yes, Mr. Mutu, I understand your position saying that the application is belated. However, you indicated at the start that your clients are prejudiced by not having the document. So we believe that it would be in the best interest of all parties for us to examine it at this stage, albeit it's late, and determine whether or not we require the entire report for these proceedings. So we'll stand on the matter for 15 minutes. The panel will look at it, and if we'll come back and we'll hear the both parties based on our determination.
I'm guided, thank you.
Sorry, ma'am, do I take it then that you will ask to be addressed for the issues that are raised by NH in particular that require those unredacted parts to be disclosed? Because we haven't heard that. We've had our position, and insofar as you make reference to a party is not allowed to submit unredacted. In fact, the rules permit it. The rules actually speak about redacted documents, part 8. So I'm surprised that this approach is being taken. But what I would respectfully invite the panel to do is when you've seen the document, I would respectfully ask you to have regard to the grounds of challenge raised by NH to determine whether the disclosure of the unredacted parts is relevant to any of NH's grounds of challenge, because that is a determination that has to be made if an order for, in this case, specific disclosure is going to be made, even though it's not required. And I would also invite the panel to have regard to the sanctions set out in the rules for failure to disclose to other parties, which is an obligation on us. So even if the panel looks at it and forms a certain view, we are the party that is required to disclose it on pain of not being able to use it. That is how these rules are to be construed, and not any different. And my learned friend referred to that EMBD case. That was a case in which the parties filed the redacted documents, and then there was an application by a party for the unredacted document to be supplied. So that is the application that he referred to in the excerpt that he gave. That is not the situation that we are in now. So what does the panel require us to do? Deliver it to you, and you will stand the matter down for how many minutes, ma'am?
15 minutes.
Much obliged.
Unredacted, and we have sight of that as well as the email you sent yesterday.
Thank you very much, ma'am. We shall do that now.
So we return in 15 minutes. It's now 10:37 a.m. Good morning again. All the parties, are you hearing me? Thank you very much. So the panel has reviewed the entire evaluation report. We have compared it with the redacted version, and we find that the redacted parts are not necessary for the full and satisfactory understanding of the issues before the panel in today's proceedings. Having regard to section 52D and E factors in the Act, leave is thereby granted for the respondent to file the redacted evaluation report. We do note that the respondent's failure to make this application in a timely manner as directed by the panel, and we will address this fully in our decision. But we are prepared to proceed today with the redacted version of the evaluation report.
Much obliged, ma'am.
Ms. Peak, the issue of the redacted report was raised by Mr. Mutu. We will now hear you on whether or not there are any preliminary issues you would like to raise.
No, there are no preliminary issues that we would wish to raise, ma'am. Just to confirm that, well, I imagine this is something that you would address, but in relation to the order in which the witnesses would be heard, we imagine this being consolidated proceedings. You would hear the Kee Chanona witness the NH witness, and then the respondent's witnesses. Is that the order that the panel proposes? So we would just ask that the panel confirm that no witness who is going to be given evidence other than Mr. Chanona, I expect, is present and hearing the proceedings, because I think that was the intention of the panel this morning when you asked Mr. Laban to leave. So can we just have that confirmation before we start, please?
Yes, we were about to do that. We just want to confirm that, so as Ms. Peak said, we will start with Kee Chanona's witnesses, then we will proceed to NH's witnesses, and then the respondent's witnesses. So we're confirming that Kee Chanona has two witnesses, Mr. Chanona and Mr. Laban. That's correct, Mr. Chanona?
Yes, that is correct, ma'am.
Both of you are available today. NH, you have one witness.
Yes, that's correct.
Right. Could you pronounce the name?
Conan.
Conan, right. And for the respondent, we have Cely and Ms. Tiwari.
Gurjot Tiwari, ma'am.
Yes, please. Right. So just to confirm that other than the attorneys and the representative being as in Mr. Chanona, he's the representative and he's representing himself. No one else is in the room. We also ask that you encourage your witnesses to desist from going online or consulting with other witnesses while these proceedings are pending.
I can confirm both, ma'am.
Yes. Right. So, Mr. Chanona, after you give your evidence, we'll have to make contact with Mr. Laban, right? So are you able to easily do so?
Yes, I will contact my assistant to go in the room, put back on the recording, and get him in the room.
Okay, great. So we will proceed pursuant to Part 10 of the hearing rules with today's proceedings. I will invite the parties to make, if necessary or if required, brief opening submission addresses, no more than 3 minutes though. So we would start with Mr. Chanona. Do you want to make an opening address?
Yes, I do.
Yes, please. So no more than 3 minutes, please, Mr. Chanona. You may proceed.
I'm going to set the timer. All right. Okay. We sought review from the Office of Procurement Regulations of the respondent's intent to award the contract of the NLCB project, as we deemed that there were breaches in the procurement proceedings with regards to Section 5 of the Act. The respondent had not followed the evaluation and negotiation process as published in the solicitation document with respect to the following: the introduction by the respondent of an additional overriding unpublished condition to the evaluation process. The respondent stated at the debriefing meeting that negotiations with the applicant were unsuccessful as we were unable to achieve a cost that was below the end user's budget. At the negotiation meeting, we were advised at the onset that the purpose of the meeting was to seek a possible reduction for more efficient costing closer to their budget. The respondent also stated that our fee proposal was above their budget and sought a reduction of about 6 to 7%. The contention is not that the respondent did not disclose the exact budget, but that they introduced a new pass-fail criterion requiring us to achieve a cost below a drop-dead figure. This was not published in the solicitation document as a part of the evaluation criteria and should not be used by the respondent to determine the success of our bid. The respondent therefore acted without accountability and transparency in keeping to Section 5.1 of the Act. Sorry. The applicant was not afforded the 2-week allocation maximum as stated in the solicitation document for the negotiation process, but instead it was truncated by the respondent to a 5-day period. During the 2-week timeline of the negotiation process, we submitted 2 revised tenders. The first reduced the fee proposal by 4.2%, and the second by 6.5% cumulatively. We were advised that our second revised tender submission was received but not reviewed. The respondent in both their skeleton statement and the witness statement of Ms. Cely have stated that they chose to abort the negotiation process with KCL on the grounds that it was not likely to reach an agreement with us. It is instructive to note that the abortion of the negotiation process only became known to us during the start of these review proceedings. In preparation of our revised tender submission, we considered the areas as disclosed at the negotiation meeting, which include a cost closer to the client's budget. The determined factors that led the respondent to conclude that they were unable to reach an agreement with KCL and abort the process within 7 days after the start is therefore, in KCL's opinion, unclear and needs to explain in detail. Given the long period between the negotiation meeting of 19 April 2024 and the letter of intent 27 June 2025, 9 months, it appears that there was not a contract to be urgently awarded and therefore deemed that the respondent acted unfairly and without transparency as required by Section 5.1 of the Act by truncating the negotiation process period and prematurely aborting the process without consideration of our second revised offer, which in fact was, if considered, have provided the price reduction they sought. Our estimating team has spent many hours to carefully prepare our tender submission to ensure that the requirements of the solicitation documents were holistically met. The results of the respondent's tender evaluation based on the criteria set out in Section 4.4 of the solicitation document show that this effort was indeed fruitful and KCL was ranked as the top proponent. We consider that UDeCOTT as a procuring entity decided and acted contrary to the Act, and if they had proceeded with this contract award with the breaches of Section 5 of the Act of Fairness and Transparency, the potential economic loss to KCL would be highly unjust. We are hopeful that this hearing will allow for the respondent under Section 30 and 6.1 of the Act to revisit the process and award the contract to the highest ranked proponent. Thank you, my lady.
Thank you very much, Mr. Chanona. We will proceed to Mr. Mutu.
We have no opening submissions to make.
Thank you, Mr. Mutu. Ms. B.
Thank you very much, ma'am. What we would respectfully urge the panel to do, as it hears the evidence, is to have regard to the grounds of challenge, which is what gives the panel jurisdiction. In relation to Kee Chanona, first of all, we would direct the panel to have regard to paragraph 3 of the application for review, which sets out the grounds. And basically what 3B says is that after the negotiation meeting, They were told that they failed to meet the end user requirements, and to use their words, subsequent to this meeting, no details were provided as to why KCL did not meet the end user requirement. But when you go to paragraph 8, that statement there is contradicted, and in fact is contradicted by the opening statement that Mr. Chanona made, because they were told quite clearly that there was a budget, one internal estimate, which they had not met, and they would have to reduce costs, and they were told what was the quantum of the cost they would have to reduce it by. So quite unlike or opposite of them saying they were not told why they did not meet the end user requirement, they were. And I heard Mr. Chanona refer to a document that is not in evidence, because what we have as part of the application for review and part of the evidence is the response to that meeting, the negotiation meeting, and we have it, and we will refer to it in the course of the cross-examination, in which a revised tender was submitted, and that was considered. And part of the complaint that he makes is that subsequently, some other document, which is not before the panel, was submitted. And according to him, it was done within the 2-week period, and it ought to have been considered. But when you look at paragraph 451 of the RFP, it doesn't give a minimum of 2 weeks. It gives a maximum of 2 weeks for the negotiation. And it also says that UDeCOTT may abort the negotiations at any time if it determines that it is not likely to reach an agreement with the proponent. And in the evidence, you will see what the letters show with regard to the deadline that was given. In relation to NH's application, we would invite the panel again to have regard to the grounds which have been set out in the application, which we have identified as 3 areas of complaint. The first is the criterion cost, which says cost in comparison to the internal estimate. There is a second complaint in relation to a loss of 0.2 of a point in relation to human resources. And it's a very, very narrow area of contention that we used a particular project to determine the experience of the architect. And their contention is we should have used another project. And we see when you apply the criteria in the RFP, whether we had used the project that they wanted us to use, which was the Caranash Police Station, or the Malabar Housing, not Mahogany Housing Project and HTC Development, the score would have been the same. In relation, the last issue relates to their scoring in relation to debt ratio and liquidity ratio, where there was a maximum of 2 points and they lost 1 point under each. And the ground of challenge is very specific. And it relates to that we disregarded or ignored international standards and or best practices and arbitrarily deducted points. And in our respectful submission, we complied with what those definitions mean in accounting terms. And we will demonstrate in the evidence that we have already provided, and the witness will give evidence that that is in accordance with international standards. And it's rather striking that in support of that ground of complaint, Mr. Conan has produced a page from a website called Ready Ratios to substantiate the allegation that what we did was not in compliance with international standards. In our respectful submission, when you hear the evidence in support of the grounds and you hear the evidence on behalf of the respondent, none of the grounds of complaint raised in either of the applications has any merit, and we would at the end of the day be inviting the panel respectfully to dismiss the applications. Those are respectful opening statements in relation to both applications.
Thank you very much, Ms. P. and Mr. Chanona. As Mr. mentioned the documents, I omitted to mention that we've already filed, but for future, when filing witness statements, there's no need to annex all the documents if they're already attached to the Form 8 and Form 9 and they were filed previously. Okay, so we will proceed. We will start off with Mr. Chanona. Mr. Chanona, the hearing secretary will administer an oath for you to take, and then we'll go into your evidence. Chief.
Okay.
Before we proceed, Can I take it that parties will be relying on their file witness statements as their evidence in chief and we can tender them?
Yes, that is the intention, ma'am.
Thank you, Mr. Speaker. Mr.
We
Mutu?
agree. Yes, we agree.
Yes, please, Mr.
Yes,
Chanona.
yes, ma'am.
Right.
Yes.
Good morning, Mr. Chanona. Could you indicate if you'll be swearing or affirming this morning?
Sorry, could you repeat, please?
Could you indicate, sir, if you would be swearing or affirming?
Well,
Well,
I
Mr.
guess
Chief,
well, is it the same thing? I swear and I'll swear.
Okay, sir. So repeat after me. I,
I,
please state your name,
Charles Chanona,
solemnly swear
solemnly swear
that the evidence
that the evidence
I shall give to the hearing panel
I shall give to the hearing panel
in this case
in this case
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
thank you, Mr. Chanona. You could place your hand down. Mr. Chanona, you would have filed a witness statement dated the 17th of February 2025.
Yes, correct.
Contents of which you claim are true and correct.
Yes, your madam.
Right, and could you tender that as your evidence in chief? That you'll be relying on that as your evidence, right?
Am I required to read it?
No, you're not required to read it. Once you're relying on it, we're going to tender it, and the other attorneys will be allowed to cross-examine you on the matter.
Yes, madam.
Yes. So we will tender unless there are objections, Mr. Chanona's witness statement as TC. Right. So Mr. Chanona, we will now invite the other attorneys. We can start with Mr. Mutu. Do you have any questions for Mr. Chanona?
No, ma'am. Well, at least not at this stage, but I anticipated that UDeCOTT will go first.
Yes. Okay, we'll go on to Ms. Speak then. Ms. Speak, you may proceed.
Much obliged, ma'am. Good morning, Mr. Chanona.
Good morning.
Now, you signed the application for review, not so?
That is correct.
And we've looked at your witness statement. It would be true to say that you did not attend the negotiation meeting that was held on the 19th of April 2024 with UDeCOTT?
That is correct.
But I take it that the attendees at that meeting reported to you what had transpired?
We got a recording of the negotiation meeting, ma'am, and that's what I relied on.
No. I think you told the panel that you required a recording. Did you have a recording of the meeting before?
Not before I sent the witness statement in, ma'am.
Oh, okay, no. So I'm asking, after the 19th of April 2024 meeting that you did not attend, did the Kee Chanona representatives report to you what had transpired at the meeting?
Yes, I relied on a report from the team.
And you understood that Kee Chanona was told that your proposal, was over the budget, correct?
That is clear. Yes, that was told.
And Kee Chanona was asked to look at cost reductions of the order of 6% to 7% to meet the client's budget, correct?
That is correct, ma'am.
In other words, those were the end users' requirements that were communicated to Kee Chanona.
No, that was a statement made to Kee Chanona.
Yeah, but did you understand that to be, and I'm using this language because this is what you used in your application, that was the end user's requirement, the budget?
No, what we understood was that we were first ranked and we needed to get in line with the team budget, and we were with the order of 6 to 7%. We were not told that you must be below 6 or 7%. We were told that we were above the budget by 6 to 7%. And the purpose of the negotiation meeting was to discuss areas that would achieve getting that price down without compromising the what you call the scope of work. So we weren't going to interfere with the tender
Good.
process, but look at this thing. That's
Okay,
what was
now,
reported to me. Sorry.
okay, now, Mr. Chanona, this is a cross-examination, and I just want you to answer the question that you are asked. We have your
Okay.
witness statement, so the panel has your evidence. So just try and direct yourself to the question that you're asked. So nobody at that meeting objected to those discussions to try and reduce Kee Chanona's proposal of the order of 6 to 7%. There was no objection to that approach.
It was the whole point of the negotiation meeting, ma'am.
Thank you. All right. And there was a deadline. I take it what was reported to you, and now UDeCOTT has produced the recording for you. Did you see that at that meeting, your representatives committed to submitting the revised proposal using Forms 1 and 2 by the 23rd of April, 2024? Yes or no? Because we have another witness who attended the meeting and will be able to assist us. Do you have that recollection, either from what they told you or from you listening to the recording? Yes or no?
You want me to answer what I was told or what I heard from the recording?
No, answer my question. Did you
using what I was told a year ago in April, or what I heard in the recording? What answer do you want me to give?
Well, either one. Did you understand?
Yes, I understand
that there was
from the meeting.
The deadline of the 23rd of April 2024 was given by the Kee Chanona representatives, who said they would be able to submit the revised proposal by the 23rd of April 2024. That's the question.
The answer to the question, we were asked, how soon can we submit? And we suggested the 23rd of April. This was a Friday. We said we could do it by Tuesday. They said, thank you very much. And we kept to that deadline. We did submit a revised proposal.
Thank you very much, Mr.
No, ma'am, by the requested date, not by a deadline date, by a requested date. Can you submit by
a date was requested? A date was requested, and Kee Chanona gave the date of the 23rd of April. Is that correct?
That is correct, ma'am.
Good, thank you. And you are aware that, in fact, Kee Chanona submitted revised Forms 1 and 2 on the 23rd of April, 2024, not so?
As requested, yes, ma'am.
And in fact, can I just refer you? Do you have your trial bundle, Mr. Chanona?
Yes, ma'am.
Now, because they were submitted late, you'll forgive me if I don't have. Mama, is the panel using the trial bundle or the original application for review that was submitted?
We can, if you indicate the page on the trial bundle, we can perhaps project it on the screen so he can look on the screen.
All right. 121, I believe, of the trial bundle has the letter, the Form 1. You have it, Mr. Chanona? Or do you require it to be put up on it?
Put it on the screen, please, yes.
Yes, this is the revised Form 1 that Kee Chanona submitted, not so?
Yes, yes, ma'am.
And if we go to the preceding page, which is page 120, you will see the date as the 23rd of April, 2024.
Correct.
Now, it would be correct to say, Mr. Chanona, that revised letter of tender did not reduce Kee Chanona's bid in the order of 6 to 7%.
No, ma'am, it was closer to 4%.
Thank you. And can I take you to page, the RFP, which is attached to your application, the trial bundle, sorry, it's page 41. And I see you've helpfully highlighted a maximum of 2 weeks. So this is the negotiation clause in the RFP, correct?
That's correct.
And if we look at the highlighted passage, it says a maximum of 2 weeks has been allocated for this activity. UDeCOTT may abort negotiations at any time if it determines that it is not likely to reach an agreement with the proponent involved.
Very clear on that too, ma'am.
So that could happen within the 2-week maximum period, not
That's
so,
correct.
Mr. Chanona?
That's very correct.
So I'm suggesting to you, Mr. Chanona, can that be taken off the screen, please?
Yes.
That Kee Chanona was well aware from the negotiation meeting of the 19th of April 2024 what Kee Chanona needed to do in order to meet the client budget. Isn't that correct? Okay. Thank you, Mr. Chanona. You say that you weren't aware, so that's matter for submissions. Now, isn't it correct that...
Ma'am, I mean, I'm not a lawyer, right? So please allow me to try express it as best as I can now, because I feel like a blue crab on a Sunday color now. I need to be able to explain what I'm saying. I mean, if you put in, you're putting words in my mouth, but you're trying to tie me up, man, you know?
Mr. Chanona, the panel will guide you, but this is cross-examination. Your evidence in chief is before the panel. So we know exactly, and the panel knows exactly what your evidence is on this point. This is cross-examination where I am trying to elicit certain answers to specific questions. Yes, you're not at liberty to volunteer information outside of the questions that I'm asking. Do you understand? You will have an opportunity to address.
No, ma'am. I clearly understand, but the question is couched in such a way. We were asked to meet as close as possible to the end user's budget, and we were 6 to 7% above it. We weren't asked to match the end user's budget. We weren't asked to reduce it by 7%. We were told we were 7% high. We looked at areas where it can be reduced. And if the debriefing clearly says at the opening that we need you to come as close to the client's budget as possible. You're 6 to 7% above it. So yes, we're asked to reduce our price, not to the client's budget, but reduce our price in relation to the client's budget. So that's the answer to the question you're asking me.
Well, it wasn't only to reduce it in relation to the client's budget, Mr. Chanona. You were told 6 to 7%. You were over the budget and you needed to reduce it by 6 to 7%. Is that not what the recording says?
No, that's not what the recording says. And we can play back the recording. I hope the panel will listen to it. This is the introduction. The very first 2 minutes is when you could say what the panel said.
Well, we will address the panel on the recording, Mr. Chanona.
Okay, ma'am.
Mr. Chanona, we would like that you listen to Ms. Peak's questions. You would get an opportunity in your submissions to expand on anything that you think you may have missed out, but the answers must be related to what Ms. Peak has asked of you.
I'll try, madam. I'll try because. Yes, ma'am. I've heard you. Yes, fine.
Mr. Chanona, can I? Sorry.
No, I'm saying if you have additional information, right? We have your evidence. You can always deal with it in your submissions, but answer the question that counsel is asking. Right?
Yes, ma'am.
Thank you, Mr. Chanona.
No, Mr. Chanona, you received a letter and you have it annexed to your trial bundle at page 119. And that says, UDeCOTT hereby confirms further to said meeting, that's a negotiation meeting, you are to submit the revised Form 1 letter of tender and revised Form 2 tender breakdown. And it says your response must be submitted to the Office of the Chief Procurement Officer by 4 p.m. on April 23rd, 2024. Remember receiving that letter?
Very clearly, ma'am.
And then on the 23rd of April, you submitted a letter together with the revised Form 1 and Form 2, and you said to the extent to which, you gave the extent to which Kee Chanona was prepared to revise their tender sum, correct?
That is correct.
And in that letter, you did not reserve the right to make any further submission or indicate to UDeCOTT that you intended to make any further submission. Is that correct?
That's correct.
So is your case that there is something in the RFP that required UDeCOTT to do more than it did when it communicated to you by letter of the 22nd of May 2024 that said to you that you had submitted subsequent correspondence dated the 29th of April 2024, which was received after the negotiation process ended on the 23rd of April, which was the deadline given for your post-negotiation response, and as such was not reviewed. Remember getting that letter?
Yes, ma'am.
Good. So since the 22nd of May 2024, you knew that the subsequent communication that you sent to UDeCOTT, which is not part of these papers that Kee Chanona has put before the panel, was not reviewed. You knew that then, not so?
Yes, ma'am.
So long before you got the letter in January 2025 telling you that the contract, there was an intent to award the contract to someone else, you knew, one, that your revised proposal submitted on the 23rd of April 2024 was not accepted, correct?
That's correct.
You knew that it was not 6 to 7% a reduction on the previous proposal, correct?
I'd agree with that, yes.
And therefore, there should have been no surprise when Kee Chanona received that letter in January 2025 saying that there was an intent to award the contract to another bidder.
Completely dumbfounded when I got that letter, madam.
Even though you got a letter on the 22nd of May 2024 which says your company's bid was not successful?
Yes, I received the letter. The letter was never acknowledged because it's outside of the whole RFP process of advising proponents. Received the letter and we didn't respond to it.
No, but you got the letter because you
Got the
annexed it
letter.
to your application.
Yes,
Good.
I
So,
got it.
yeah, and you read the letter. So
Of course.
since the 22nd of May 2024, you knew that your company's bid was not successful.
We were told that, oh, yes, ma'am, that's what the letter says.
Good. And there was nothing in the RFP, Mr. Chanona, that committed UDeCOTT to awarding the contract to the top ranked proponent, was there?
No, they said it could be revisited based on the negotiation process that will sort of follow.
Thank you very much, Mr. Chanona. I have no further questions for you.
Thank you, Ms. Dick.
Thank you.
Mr. Mutu.
No, I have no questions, ma'am. Can I just be relieved from the hearing for 2 minutes, please, with your permission?
Yes, please.
Thank you.
In the interim, Mr. Chanona, can you contact your other witness? And we'll start as soon as Mr. Mutu returns.
Madam, they will get the witness in shortly.
Thank you. Mr. Chanona?
Yes, Mr. Laban is in the.
Yes.
Sorry.
We are going to have to ask you to ask Mr. Laban to leave again. We do have some questions for you from the panel, so we have to complete that quiz. So, Mr. Laban, we shouldn't be long. If you can log out and step out for a few minutes.
Okay, thanks.
You turn off the computer. Turn off the.
Yes. All right, thank you. All right, so Mr. Chanona, you're still under oath. The panel has a few questions for you before we proceed to the next witness.
Okay.
Hand over to panel member.
Hi, good morning, Mr. Trinidad. I note in your statement you indicated that your understanding of the submission of your revised tender, it was not to compromise the scope of works. Is that correct?
That's correct, ma'am.
Okay, so what prompted the second submission of an additional reduction? And did you understand that the negotiation process was still open?
Yes, we were right. So answer the second question, we were of the opinion that the negotiation process was ongoing. And the same, if you read the letter of the 29th of April, it develops further what we did in our 23rd April submission. When we met with the panel and the auditor said the suggested areas that we could possibly have reduction, and at each step and the briefing, the negotiating tapes would confirm it, that if we were going to suggest a reduction area, we asked if that would be an acceptable adjustment. And at each stage of the thing, we were told yes, yes, yes. And we did a first pass. We had the hearing on Friday, and we needed to respond by Tuesday. And so we did that. We looked primarily at areas directly within our scope as contractors. The subsequent letter included our design team, where we could look at value engineering options that could get a further reduction. So we did, the first pass was obvious. There's a rentable area that was finished because the architect was under the impression that to get a completion certificate, you had to have a ceiling, and to have the ceiling, you had to have the air conditioning trunking inside, you had to have the lights, you had to have the sprinklers, you had to have a number of things, right? So when the thing said that, no, we believe we can get a completion certificate without a finished ceiling in the rentable area, because the areas will be rented to tenants who would have their own layout and designs. And on that basis, we removed a significant amount of cost that would have been not aborted, but wasted, because the rented space would be configured to suit whoever the other person was, right? That was our first submission on the 23rd. Subsequent to that, those are obvious, straightforward, contractor type of adjustments, right? Subsequent to that, we engage our design team, as our letter of 29 says, do some value engineering exercises in how we could get this thing down closer to the budget. And that resulted in a further submission, which we submitted. I hope that answers the question.
Yeah, yes, it does. So, but between the 23rd and the 29th, did you have any communication with the negotiation team?
No.
So there was no indication to them that you just submitted the letter with there's no indication, verbal or otherwise, that you were going to attempt further.
All right, so the thing says negotiation will be a maximum of 2 weeks, right? The negotiation commenced on the 19th of April. Or 2 weeks thereafter, this commenced on Friday, the 19th of April. 2 weeks thereafter is Thursday, the 2nd of May. As far as we're concerned, a negotiation process. It's a process, it's not a negotiation date or day. We were engaged for the first time as to what to do. We looked at things, and over a weekend we decided, all right, we could do these obvious things and drop the price. We engaged the design team, and so as far as we were, on the 3rd of May, the day after the thing, we wrote saying, well, any feedback on what we sent you all? That was not acknowledged until the 22nd of May. Yes, we got it, but we never reviewed. But we considered a process to be ongoing that would conclude no later than the 2nd of May. The client, UDeCOTT was at their thing to say, I want to abort it, I want to stop it, or trunk it, whatever. That was their privilege. If they felt the negotiations was going nowhere, we weren't under the impression that the negotiations were going nowhere. You know, it wasn't. This is it, that the negotiation period will come to an end on the 23rd. So you got one shot at this. It's not, So we were unaware why,
So you said on the 3rd you communicated inquiring what the status was. Was that by email or letter?
That was a letter that was sent, and which was acknowledged by UDeCOTT in that same letter that Mrs. Peak referred to. When you wrote us the 22nd of May, they acknowledged our letter. Both letters, our letter of the 29th and our letter of the 3rd of May, and said that both were received outside of the negotiation period. So they were not they were received but not reviewed.
Okay, thank you.
Yes. Good morning, Mr. Chanona. The submission made on the 29th of April 2024, was it included within your trial bundle?
Yes, sir. Well, I'm not quite sure where it is. I'll have to. Could I call? Can I call someone for him to tell me where it is?
Let's see if we can find it.
Ma'am, while Mr. Chanona is looking for that, can I just point out, because I'm not sure whether it is in the trial bundle, but it does not form part of the application for review. and there are no annexures to either of the witness statements filed by either of the Kee Chanona witnesses. So in the event that it is in the trial bundle, we would respectfully submit that it is inadmissible. And just for the record, of course, this is without prejudice to any question that any member of the panel may raise, but the questions and the answers elicited from the witness have nothing to do with the grounds of challenge set out in the application for review. So we just ask for that to be noted for the record.
Thank you, Mr. Yes, Mr. Chanona.
Can I ask Ms. Speaker a question?
Mr. Chanona, directed to the panel, let's say, because you're under cross-examination now.
Right. Ms. Peak referred to the letter of the 22nd of May that makes reference to the letter of the 3rd of May that we wrote. So by default, whatever in that letter is included. It makes reference to a letter they acknowledge receiving, but not reviewing. So I'm not a lawyer, but I think it's in the evidence by default.
Mr. Chanona.
Mr. Chanona, you can direct us to it when you locate it within your trial bundle if it's there. But my question was really to look at the letter. So we can move on until you indicate that.
Well, so I'll need to call my office for them to find the letter. Am I allowed to do that? They probably take a few minutes to do it, but if I have your permission, I can call now.
You can call, but we can move on to Mr. Laban.
All right. Okay. All right. So we want where in the trial bundle the letter of the 3rd of May and our submission of the 29th of May, those two, 29th of April, those two things?
Yes.
Yes.
I get none. Yes. Okay.
Yes. And in the meanwhile, you can contact. So this is Mr. Chanona. Mr. Chanona.
Yeah.
Right.
Yeah,
we are finished with evidence, and we will deal with Mr. Laban now. So if you can contact Mr. Laban as well.
I'm doing it now. Yes, ma'am.
Mr. Chanona, were you able to contact Mr. Laban?
Yeah. Yes, I'm getting him right now, ma'am. So
Sure.
you just look.
Mr. Chanona, you already. Oh,
Yes, ma'am.
go ahead. To contact Mr. Laban. Go ahead.
He should be there momentarily, ma'am, and I will get the location in the bundle of these two letters that Ms. Speaks requested. Sorry, that the panel member requested.
That's fine. We would locate it. We would like to relieve you now as a witness. We would locate the documents if they are in fact there. Right? So we don't need you to, don't stress to look for it anymore. We can locate it. We want to relieve you now as a witness, but you'll stay on as the representative.
Okay.
Yes. Just for housekeeping, Mr. Mutu, I know earlier I would have asked you about cross-examination of Mr. Chanona, but in light of the consolidation, rather than being an interested party, we would not allow you to cross-examine Mr. Chanona's witnesses.
I hear you.
Yes. And vice versa as well, meaning he would not be allowed to cross-examine you.
Tony, you have to close the door.
Yeah, I'm gonna just set it up. Sir.
Good afternoon, Mr. Laban. Mr. Laban?
Yeah, are you hearing me now?
Yes, we hear you. I saw someone left the room. Is there anyone else in the room with you?
No.
Thank you very much. So you're here today to give evidence, and you would have sworn to, or you would have given a witness statement dated the 17th of February, 2025. You recall that?
Yes, yes.
And you want to rely on this witness statement as your evidence?
Well, I may have to, if permissible, just expand the item.
Okay, so you're going to be sworn in you're going to be sworn in.
Okay.
So listen to the oath.
Sure.
Good afternoon, Mr. Laban. Do you want to swear or do you want to affirm?
I guess swear, might be the simplest one.
Okay, could you raise your right hand for me, sir? And keep it raised.
Hmm?
And please repeat after me. I. Please state your name.
Anthony Laban.
Solemnly swear.
Solemnly swear.
That the evidence.
That the evidence.
I shall give to the hearing panel.
I shall give to the hearing panel.
In this case,
In this case,
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Let me go over it, Mr. Laban. You can put your hands down now. On the 17th of February, you gave a witness statement in this matter,
Yes,
and you would like to rely on this witness statement as your evidence.
yes. Like I said, in addition to some expansion, I may want to do it permitted.
Well, okay, so you'll be asked questions by the other attorneys and you would answer their questions.
Oh.
Right? Is there any objection to the witness statement of Anthony Laban being tendered into evidence?
No objection.
Mr. Mutu? Oh, right, yeah, sorry.
No objection.
Yeah. Right, so we proceed, witness statement of Anthony Laban dated the 17th of February 2025, tendered as AL. So Mr. Laban, Ms. Peak is going to ask you some questions now.
Sure.
Good morning, Mr. Laban.
Morning.
I'm going to ask you some questions and do your best just to answer the questions that you are asked so we can move along quickly. Is that okay?
Yep,
Now, you were present at the negotiation meeting with UDeCOTT on the 19th of April 2024, correct?
that's correct.
And it was made clear to you and the other representatives of Kee Chanona that Kee Chanona's proposal was over the budget
Yes,
and that you needed to reduce the cost by approximately 6 to 7%, correct?
that's correct.
And there was a discussion at the meeting as to how those costs could be reduced, yes?
Yes,
And you indicated that you would meet with your design people and revert by no later than Tuesday of the following week. Remember that?
that's correct.
And in fact, you got the recording of the meeting, Mr. Laban?
We subsequently got it after requesting.
And you listened to that recording?
Yes,
And you confirmed what I just asked you, that you indicated you would meet with your design people and revert by no later than Tuesday of the following week, correct?
that's correct.
And UDeCOTT representative said that after the meeting, she would issue the post-negotiation letter and indicate the timeline to respond, which would be the date that you gave, Tuesday of the following week. And you were told that you had to submit a revised Form 1 and Form 2, correct?
That's correct.
And according to your application for review, you received a letter dated the 19th of April 2024, not so? From UDeCOTT?
Yes,
And that letter said, first of all, it confirmed that you were to submit the revised Form 1, which is the letter of tender, and Form 2 tender breakdown, correct?
that's correct.
And you had to do so by 4 p.m. on the 23rd of April 2024, correct?
That's correct.
And that was the date that you had committed to submit your revised proposal to UDeCOTT, yes?
Yes,
And on the 23rd of April 2024, Mr. Laban, Kee Chanona did submit a revised Form 1 and Form 2, correct?
that's correct.
But the revised bid was not a reduction of 6 to 7%, was it?
Nope,
In fact, according to Mr. Chanona, it was less than 4%, correct?
it was 4.5 thereabouts.
Well, I think it was less than 4%, but the point is it wasn't 6 to 7%, correct?
That's correct.
Now, after the deadline date of the 23rd of April 2024, a further letter was sent to UDeCOTT proposing a further reduction.
Yes, no. A further letter was sent by KCL advising of a further reduction.
Right. But there was no revised Form 1 and revised Form 2 submitted, were they?
Not from my recollection.
And you got a letter from UDeCOTT on the 22nd of May saying that that letter was received after the deadline for the post-negotiation process and consequently was not reviewed, correct?
That's correct.
And that your revised proposal was not successful, correct?
Yes,
So since the 22nd of May 2024, you knew that your Kee Chanona's revised proposal had been rejected.
Yes.
And your understanding was that it was rejected because it was in excess of the client's budget?
And beyond the deadline of the 23rd of April.
Well, what came in by the deadline was not the 6 to 7% reduction that was requested.
Yes, I agree with that, except that, may I say,
No, Mr. Laban, you answer the questions that I'm asking you. And Kee Chanona's contention is that UDeCOTT should have disclosed the client budget.
That was not our request. That was mentioned at the, I think was the debriefing.
So it is not Kee Chanona's contention that the bidder should have been provided, sorry, with the budget at the time of the proposals.
That was not a request from KCL that we provided be the budget. Our contention is that introduced a new criteria, which was known at the time. We don't request the budget from any client.
Okay, thank you very much, Mr. Laban. That's what I wanted to get from you. But you would have been able to deduce from the percentage reduction that you were asked to come back with what the budget might have been, correct?
Yes.
So it was clear to Kee Chanona in what respect it didn't meet the client's requirement or budget, correct?
At that point, yes.
And just to confirm, as you said in your witness statement, Kee Chanona is not disputing the evaluation assessment undertaken by UDeCOTT in any way, correct?
That's correct.
Thank you, Mr. Laban. I have no further questions for you.
Am I allowed to expand on any items?
Thank you, Mr. Laban. Mr. Laban, you would have filed a witness statement which would have given your evidence. And today was simply for cross-examination by opposing counsel, meaning UDeCOTT's attorneys. So you can, Mr. Chanona will deal with it in his closing. Thank you very much. Let me check with the panel to ensure there are no further questions. But you, Mr. Laban. Okay. So no questions from the rest of the panel. Mr. Laban, you are relieved as a witness.
Okay, thanks.
Mr. Chanona, is this the extent of your case?
Well, do I get to ask anybody any questions?
When we get to UDeCOTT's witnesses, not your witnesses, meaning you can't cross-examine Mr. Laban.
No, I know that. Yeah.
Right, so when we get to UDeCOTT's witnesses, then you get to ask questions, but this is all your evidence, right? So you can close your case and move on to.
Well, I mean, you do have this skeleton statement and those things there.
Yes, please, yes.
Okay.
Yes.
Yes.
In terms of the witnesses.
This concludes our positive case.
Thank you very much. So we can move on now to NH's witness. Mr. Mutu, is your witness nearby? Available?
He is ready. And he is on the link. He should be on the link. I don't know if he has been admitted. Doesn't appear so.
Okay. Mr. Conan, yes, absolutely.
Yes.
You'll admit him? Good afternoon, Mr. Conan.
Good afternoon.
Is anyone else with you in the room?
No, not at this time.
Thank you. So you will hear the oath, which you will repeat, and then after to be sworn in, and then we proceed with your evidence.
Good afternoon, Mr. Conan. Do you wish to swear or do you wish to affirm?
I can swear.
Okay, can you raise your right hand, please, and keep it raised during the oath? Thank you. I. Please state your name.
Kieran Conlon.
Solemnly swear that the evidence.
Solemnly swear that the evidence.
I shall give to the hearing panel.
That I will give to the hearing panel.
In this case.
In this case.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Okay, Mr. Conan, you can place your hand down. So, Mr. Conan, you would have filed a witness statement on the 17th of February 2025.
Yes.
And a supplemental witness statement on the 19th of February 2025.
Yes.
And you seek to rely on the contents of this witness statement today?
I do.
Right. So, Ms. Peak, if there are any objections, unless there are objections from Ms. Peak, may the witness speak?
No objection.
Right. The witness statement be tendered as CC. Mr. Conlon, Ms. Peak will be asking you some questions now. So answer the questions as asked.
Okay.
Good afternoon, Mr. Conlon.
Hi, Ms. Speaker.
I'm going to be asking you some questions. Just listen to the question and answer only the question that I ask you. Some of my questions are formulated to elicit yes or no answers, so just try to answer the question. We have a lengthy witness statement from you, so be assured the panel has your evidence. So just respond to the questions that I ask you. Is that okay?
Yeah, sure.
So in the procurement process under consideration, Mr. Conlon, NH did not seek any clarification of any aspect of the procurement documents. Is that correct?
I believe that to be correct, yes.
And NH did not mount any challenge to the terms of the solicitation documents under the provisions of the Procurement Act, did it?
Sorry, could you repeat?
Are you aware that under the Procurement Act, a bidder can challenge or mount a challenge to the terms of a solicitation document or an RFP? You're aware of that?
Yes, yes, yeah.
No, NH didn't do that, did they? In this case?
This, you'd need to clarify that for me because we're
Okay,
in the proceeding now.
Your challenge is to the intent to award the contract to FIDES, not so?
Yes, it is.
Good. Now, as an experienced bidder then, Mr. Conlon, NH was content to submit its bid on the basis of the RFP that UDeCOTT provided, correct?
Yes, our understanding of it, yes.
Yes, and even though when you read the RFP and saw that one of the evaluation criteria was cost comparison to internal estimate, NH did not ask UDeCOTT to disclose the internal estimate, did it?
Not at that time, no.
And I take it, Mr. Conlon, that you believe that it would be unfair for UDeCOTT to depart from the terms of the RFP to favor one bidder over the other, correct?
Yes, as far as if I could broaden my response there, our understanding is it was always going to be a lowest bidder wins if everybody passes the technical threshold.
So first of all, Mr. Conlon, that is not responsive to anything I asked you, but the panel does have the benefit of your opinion in your witness statement where you see that, so you don't need to reinforce it. Now, I think in your witness statement, you say that you accept that it is not the role of this panel to substitute its view as to the evaluation of NH's bid, correct?
Mm-hmm. Yeah.
Good. Now, you accept that the RFP in this case, Mr. Conlon, made it clear in several places that the project scope and project intent was for a 7-story building? Yes or no? Yes or no?
I would need to broaden that because
Sorry?
I would need to broaden that because on the first time we bid this project, we were told to basically ignore the town and country planning and to follow the proponents.
You see, Mr. Conlon, that is a clear example of you not listening to the question and responding. So let me ask the question again. Do you accept that the 2024 RFP made it clear in several places that the project scope and project intent was for a 7-story building? If you're not able to tell us so.
Mr. Conan, Mr. Conan, pause a bit. I saw Mr. Mutu's hands up. Is it that you have an objection, Mr. Mutu?
I will leave it for the moment, ma'am. For the rights, I'll raise it.
Thank you, Mr. Mutu. Mr. Conan, you could proceed now. Proceed.
Okay. We understand the town and country planning document was part of the bidding process.
I'm going to ask the question again because I want you to respond to the question I ask. That's going to be most helpful for us and for the panel. Do you accept, Mr. Conlon, that the 2024 RFP made it clear in several places that the project scope and project intent was for a 7-story building?
I would not accept that.
Okay, thank you. Now, I'm going to take you to places in the RFP where that is made clear. Do you have a copy? Do you have a hard copy of your witness statement, Mr. Conlon?
Yes, I do.
Okay, could I take you to, sorry, not your witness statement. Do you have the application for review?
Yes, I do.
All right, can I ask you to look at page 10? And ma'am, is the panel using the electronic bundle of the,
Yes.
the electronic application for review?
Yes, please. So if you just to the page we would project.
Yeah, it is page 26 of the application for review.
That's 1 minute.
Okay. This is section 3 of the RFP, project description.
It's under intent of the project. Yes, under project description, correct. Ma'am, may I proceed?
It will take a few seconds. It'll appear on the screen shortly. So you can proceed, but it'll appear on the screen shortly.
So, Mr. Conan, were you involved in the submission of this bid?
I was.
Good. So you're familiar with this RFP?
Yes.
And do you see on that page, under project description, paragraph 3.1, it says the new NLCB head office and car park facility will extend from Pembroke Street to Abercrombie Street with a site area of 40,688 square feet. The 7-story building, do you see that?
Yes.
Good. So does that not refresh your memory, Mr. Conlon?
We have done, well, can I broaden my
Does
response?
that refresh your memory that this RFP is for a 7-story building?
It's not just yes and no answer. We have done many, many design and builds. We take the RFP. We have to use the user space requirements and look at the overall requirements to what the client actually needs. We have to tailor the building to the client's requirements. Now,
Mr. Conan, that is not responsive to my question. And I think we do have that evidence in your witness statement. So I don't think there's any necessity to repeat it. Certainly not in response to my question.
Mr. Conan?
Mm-hmm.
Mr. Mutu?
Yes, I have an objection. And the objection is that the witness is trying to answer a question. If he says that the question does not readily admit of a yes or no answer, he's entitled to say that. Opposing counsel cannot force him to give a yes or no answer to a question. If it is that the panel finds that the witness is non-responsive, then submissions can be made about that at the end of the day. The second thing is opposing counsel is running a commentary in relation to the witness's evidence. The job of counsel is to question the witness, not comment on the witness's evidence. So if the witness can be allowed to give his answer to the question and the panel take the evidence, that is what we submit would be the appropriate course.
Thank you, Mr. Mutu. Ms. B?
With respect, my question was simply, does looking at this reference refresh your memory? I don't see how a response other than yes or no can be responsive to that question. It is Mr. Conan who is giving a commentary. Mr. Mutu, please, I'm responding. Could you please take your mic? Yes, thank you. Mr. Conan, just listen to the question that I ask you and respond only to the question. Mr. Mutu is objecting to me giving you assistance to just answer the question. So can we please, we have a lot of ground to cover and we have limited time. I'm going to ask you the question again. The seeing what paragraph 3.1, sorry.
Could we rule on the objection?
Sorry, I apologize.
Mr. Mutu, your hand was up again?
No, I just neglected to take it down.
Sure. So in this instance, Mr. Mutu, I will agree with Ms. Peak that the question was of the nature to require yes or no answer. She was asked, the witness was asked whether it does refresh his memory. Right? So Ms. Peak, you may proceed. Objection overruled.
Thank you. Mr. Conan, what's the answer to the question, please? I might have missed it.
Yes, it does refresh my memory.
Thank you. Can I take you to another page of the RFP? It's page 60 of the hard copy if you have, and it is page 76 of the electronic bundle, ma'am.
So we're having a bit of a technical difficulty projecting it. So if you have it, Mr. Conan, you can use your hard copy.
Yeah.
You have it? You have it, Mr. Conan?
Overview?
Yes, and if you look at paragraph 2, it repeats what we read before under 3.1, and it again talks about the 7-story building will provide approximately a gross area of 119,737 square feet of office space and 54,896 square feet of car park space. Do you see that?
Yeah, I remember this, yes.
And if we go next to hard copy, page 84, and electronic bundle, page 100.
Description of the works.
Description of works, and you see in the second paragraph quite clearly the same language and a repetition, the 7-story building, correct?
Yes, I see that.
And I think there is another reference, page 66. Page 66, electronic bundle. Sorry, I don't have that reference. It should be 82, I think. Just give me a minute. Yes. Do you have it? If it could just slide across the page, please, on the screen. Yes, you see again there under project objectives, Class A office space, 7 stories, correct?
Yes, I see that.
So I've taken you to 4 places in the RFP which speak specifically about a 7-story building. Now, you were referring to the Town and Country Planning Permission, correct?
Yes.
Can that be taken off the screen now, please? Yes, Mr. Conlon. The Town and Country Planning Permission formed part of these tender documents, did they not?
At the time, yes.
And in fact, that also said it had to be a 7-story building, not so?
I don't know. Well, it says 7-story, but also 27 meters.
See, Mr. Conlon, I'm just focusing on the 7 stories for the time being, okay?
It says 2 things, not just one.
You have counsel here and they will argue your case for you. You're just here to answer the questions that I ask. Now, you remember the Town and Country Planning Permission talked about a 7-story building.
Yes.
And it was based on the requirements of the Ministry of National Security, not so?
Yes.
So having seen all of those references in the RFP to the 7-story building, including the Town and Country Planning Permission, do you now accept that this RFP made it clear that the project scope and project intent was for a 7-story building?
No, I do not.
You don't accept that. All right.
Can I broaden?
No, thank you very much, Mr. Conlon. We have your evidence. Please be assured the panel has your evidence. So notwithstanding the 4 places that I've referred you to, and the Town and Country Planning Permission, which says it's a condition of the planning permission, UDeCOTT submitted a 9-story building, correct?
Yes.
Good. Now, in your witness statement, you made reference to an inquiry that you made in relation to a previous RFP for this project, correct?
Yes.
So let's be clear, no clarification, as you said, in relation to this RFP. You made a request for clarification in respect of an earlier RFP, correct?
Yes, basically this was a rebid, so yes.
Yes, good. And this is what you say in your witness statement. NH received the following response from UDeCOTT, which made it clear that the 27-meter height restriction stipulated by Town and Country Planning should not be treated as a limit, or that a failure to strictly adhere to same would result in bids being disqualified. Remember saying that? Giving that
Yes.
evidence?
Mhm.
Now, that relates to the height stipulation, not so?
It would be both.
Well,
elements.
Let me reread it for you, Mr. Conan. NH received the following response from UDeCOTT, which made it clear that the 27-meter height restriction stipulated by Town and Country Planning Division should not be treated as a limit, or that a failure to strictly adhere to same would result in bids being disqualified. Remember saying that?
Mm-hmm. Yes.
Now, there's nothing that I read for you there that talks about stories, 7, 9, 10, anything, correct?
Correct.
So from what I read to you, your understanding from UDeCOTT was that the height stipulation should not be treated as a limit in relation to that first RFP?
Both the original bid and this bid, the height stipulation.
Well, you didn't ask any clarification, Mr. Conlon, in relation to this RFP. So your understanding could only have been in relation to the one that you made the inquiry on, not so?
Yes, but it's a rebid for the same project, you know.
Mr. Conlon, did UDeCOTT say that any requests for clarifications that were made in relation to the earlier RFP and the answers given would apply to this RFP?
I can't remember if a statement was made.
And you certainly haven't annexed any document that suggests that, not so?
No, I haven't.
No. The query that you raised in relation to the earlier RFP related to the difference in height in the Town and Country Planning Permission and the height in the conceptual design submitted by UDeCOTT, correct?
Yes.
So that query that UDeCOTT made in relation to the first procurement process was as to height, not stories.
Okay, yes.
So I'm suggesting to you, Mr. Conlon, that no one misled you into thinking that there was no requirement to adhere to the number of stories set out in multiple places in the RFP and in the Town and Country Planning Permission. Did anyone mislead you into thinking that, Mr. Conlon?
No, we did not. We were not misled.
So I'm suggesting to you, Mr. Conlon, that the number of stories is a planning consideration set by Town and Country Planning, not so?
I think we made the statement that it's the height is usually the ruling factor, not the number of stories when it comes to Town and Country Planning.
I know you said that, but I'm asking you whether Town and Country Planning didn't confine themselves to height. They also said 7 stories. Is that not your understanding?
The TBC document does stipulate both height and stories.
So stories was part of the planning. It was a condition actually of the Town and Country Planning Permission, not so?
An outline condition, yes.
Sorry?
Yes, an outline. Yes.
Yes. And the number of stories as set out in Mr. Tiwari's witness statement is also a condition that affects planning matters like density of usage of the building, maintenance and expenses. Do you accept that?
To a certain extent, yes. Hello, if I could just say.
No, Mr. Conan, thank you very much. So no, you said in your witness statement that the RFP required that the building be a maximum height, correct?
They had outlined a 7-story building, yes.
No, I'm not talking about stories anymore. I've gone to height.
Height.
Yes,
Okay.
do you accept that it required the building be of a maximum height?
The RFP?
Yes.
No, there was nothing that defined. It talked about stories. It did not define a height. The RFP was silent on that.
Well, part of the RFP, sorry, Mr. Conan, but part of the RFP was the town and country planning permission also.
Yes.
And so that had a height.
Yes.
Good.
But sorry, I thought you asked about the RFP.
Yes, but wasn't the town and country planning permission document a part of the RFP?
So is the schematical drawings that was issued, which is 34 meters.
Yeah, is the answer yes?
To which one? The
is
RFP.
the town and country planning permission document part of the RFP that NH bid on?
Yes.
Yes?
And
And there's a height requirement in there, not so?
Yes.
Good. And as we've been through in the 2023 procurement proceedings, NH had made an inquiry about height, and NH was told adhere to the RFP on height, correct?
Yes.
Now, there is a drawing in here that forms part of the conceptual design, and it shows that the design of the conceptual design has a height of 29.475 meters, correct?
Conceptual design, I thought, was closer to 34 meters.
No, if we go to page 72 of the bundle, which I think is electronic, page 88.
Yes, it's 34.125. And if I remember correctly, it was also raised 900 millimeters from grade. So that would be about 36 meters in total.
But so the office levels is 29.475 feet, correct? I'm not sure if it's feet or meters. Forgive me. Meters.
It's meters.
Yes.
Okay. Yes, but town and country planning would go to the highest point of the structure, which would be, in this case, the staircase at the roof level. That would be considered under town and country planning requirements.
Good. So in fact, there was a discrepancy between this conceptual design and town and country, the town and country planning permission, correct?
Yes.
But in fact, NH's bid exceeded both town and country planning permission and this height, didn't it?
Yes, it did.
In the conceptual design. So therefore, it would be correct to say that NH did not adhere to the height in the RFP, did it?
No, we didn't.
So even on your own case, Mr. Conlon, NH's proposal was not compliant with the RFP and with UDeCOTT's specific instruction.
It was compliant with the user space requirements within the RFP.
Mr. Conlon, didn't UDeCOTT say adhere to the RFP? Answer the question, please, Mr. Conlon. Did UDeCOTT say adhere to the RFP?
Yes.
Good. And NH did not adhere to the height in the RFP, did it?
As regards
we've been through this.
As regards the height, our bid did not achieve that.
And as regards the stories, it did not either.
No, it
We've
didn't.
been through this as well.
Yes, I've just
Good.
agreed.
So, Mr. Conan, I'm suggesting to you, on NH's own evidence, NH's bid was non-compliant and should have been rejected and not evaluated.
I disagree wholeheartedly.
So if there was another bidder, Mr. Conan, whether Fides or anyone else, that submitted a bid that was not compliant with the tender requirements, you would have no objection to it being evaluated and the contract awarded to them on your own evidence.
Well, we were compliant.
Please answer Mr. Conan, please. There's a discipline here. If you don't understand the question, I want to be fair to you, I will repeat the question, but I want you to answer the question that is asked. You say you don't accept that if NH had not complied with the bid requirements, its bid should have been rejected. So I'm asking you equally, if any other bidder, I'm not going to call a name, in this procurement process did not comply with the requirements of the RFP, your position will be that its bid should not have been rejected either. Wouldn't that be consistent with the answer you gave?
Yes. It would.
All right. Thank you, Mr. Conan.
It's hard yes and no every question.
Sorry. Now you're familiar with the grounds of NH's application for review, yes?
Yes.
You signed that application and certified what was in there as true and correct, yes?
Yes.
So I'm going to ask you some questions now directed to those grounds of challenge. Do you accept that there are really three main areas of complaint that NH has made in its application?
Yes.
So the first and the principal one, based on the number of paragraphs you deal with it in, would be the cost criterion, correct?
Yes.
The second one relates to that you lost 0.2 of a point in relation to experience in a similar capacity on two similar projects, correct?
Yes.
And the last relates to you losing 1 mark for debt ratio and losing 1 mark for liquidity ratio, correct?
Correct.
Where your complaint is that UDeCOTT ignored international standards and best practices and NH exceeded them, correct?
Yes.
So let's start with cost, which appears to be a major complaint. Can we go to page 14, electronic bundle, page 30, Mr. Conan?
That's the evaluation criteria?
Correct.
Yeah.
Now, there are 5 evaluation criteria, Mr. Conan, and number 5 says cost, and there's 1 line item in there. Cost in comparison to internal estimate. You see it?
Yes.
Now, would you agree with me? I mean, we both speak the English language. This is saying clearly that what UDeCOTT will be looking at when we're looking at cost of the proponent is you will be looking at that cost and comparing that cost to the internal estimate, not so?
Yes.
There's nothing in here, Mr. Conan, that says that the bidder's cost will be compared to the costs of other proponents, does it?
It doesn't stipulate that, but there is.
Thank you very much, Mr. Conan. I have some further questions. It also doesn't say that the cost will be compared to the bid of any one proponent, does it?
No.
It doesn't say that the cost will be compared to the lowest bid, does it?
Doesn't stipulate that, no.
The only standard set out in this RFP for bidders to be guided by is that your cost will be compared to the internal estimate, not so?
Yes.
But in your witness statement, Mr. Conan, you say a procuring entity must evaluate each tender against the lowest cost proposal. Do you remember saying that?
Yes, because that's the international practice.
Okay, Mr. Conan, please. Do you see that anywhere in this RFP? You see this RFP saying that the proponent's bid will be evaluated or compared to the lowest cost proposal or the lowest bid. Does it say that?
No, it doesn't, but that's the expectation.
That's your expectation. Well, we'll come to that. What it told you, and it told each of the bidders who received this RFP, was that cost would be compared to the internal estimate. Yes?
Yes, and points awarded based on that.
Sorry?
And the points will be awarded based on the internal.
Thank you very much. Now you have annexed to your witness statement, Mr. Conan, a number of RFPs that were issued by public and private bodies, correct?
Yes.
In none of them is the cost criterion here on page 14 replicated. Isn't that correct?
No, I think this is the first time this has ever been used.
Well, I'm not going to agree with you on that, but do you accept? He gave us multiple RFPs attached, and in none of them does the RFP say cost in comparison to internal estimate. Do you accept that, or did you not read those RFPs?
Yeah, no, I accept that.
Thank you.
We've never seen that term before.
You've never seen that term before?
Cost in comparison to internal estimate is not something we've come across before. So.
Mr. Conan, did NH not submit a bid for the repairs to the atrium of the Cabildo building that had the same language? Or if you don't remember, say so.
I don't
I'm only raising it because you say that there was never one like this. Is it that you don't know?
I don't remember.
You don't remember. All right.
It's quite different.
Okay, but let's look at paragraph 38 of your witness statement, where you give an example of a term or criterion that is set out in other RFPs. Do you have it?
Yes.
And it says there, and this is an RFP issued in relation to the new meteorological services building at Piarco. Did NH win this bid, Mr. Conan?
We don't know. It's still under.
Okay, thank you.
Procurement.
So it says the cost proposal, just above the formula, shall be assessed utilizing the formula. You see it?
Yeah.
CA over CP multiplied by 20. And CA is the lowest responsive tender sum, combined cost for design services and construction works associated with the proposal that passed all criteria. And CP is the proponent's corrected tender sum. Correct?
Yeah.
So that formula in that RFP and in others explicitly told the bidders that costs would be evaluated against the lowest responsive tender sum. Not so?
Yes.
Those are the words in the formula, correct?
Correct.
No such language in this RFP, page 14, correct?
Okay, yeah.
But you are inviting the panel, Mr. Conlan, to apply the provisions contained in those other RFPs to this RFP, correct?
It was our understanding that a similar process would be followed.
Can you answer my question, please? You are inviting the panel in NH's application for review to apply the provisions contained in other RFPs to this RFP. Yes or no?
Yes.
Now I'm suggesting to you, Mr. Conlan, that would be for UDeCOTT to depart from the terms of the RFP and apply criteria that were not disclosed. What do you say to that?
Well, it's our feeling that UDeCOTT have departed from their criteria.
But we know that, Mr. Conlan, but I am suggesting to you that if the panel were to accept your contention that it should apply the provisions of the other RFPs to this one, it would be inviting UDeCOTT to depart from the terms of this RFP and apply a criterion that UDeCOTT had not disclosed. Do you understand the question? Yes or no?
I do. And to be honest, I wouldn't be thinking that UDeCOTT would be departing from their RFP.
Okay, you don't think it would be? All
no.
Right. Well, that'll be a matter for submissions. So I'm suggesting to you, Mr. Conan, that there was nothing unfair in UDeCOTT applying the express words of the cost criterion, which said comparison with internal estimate, and not doing a comparison with the lowest bidder. What do you say to that?
I would disagree, to be honest.
Okay, thank you.
And
it wouldn't be doing something that UDeCOTT did not represent the bidders that it would do, according to you.
No, it would be the expectation is that what they would do. Yes.
Okay, that would be your expectation. All right. Thank you, Mr. Conan. Now, you say as well, NH in its application says that the scoring system applied is unfair and inappropriate and so on, because it failed to take into account the deviation between the prices. Remember that in the application?
Yes.
No, it would only be rational to take into account deviation in prices when each proponent is proposing the identical design and quantities. Do you accept that?
Yeah.
So as proponents in this RFP process are proposing different designs and finishes, taking into account deviation in prices might not evaluate value for money. Do you accept that?
Yes.
Now, in your witness statement, you say that in September 2023, the previous RFP was issued for this particular project, and it stipulated that proponents whose technical proposal obtained a threshold score or higher, the top ranked proponent would be the proponent whose fee proposal is the lowest cost, correct?
Yes.
Now, that 2023 RFP was a 2-envelope system, wasn't it?
Yes.
So all aspects of the proposal assessed, correct, in the first envelope?
Mm-hmm.
And thereafter the cost in the second envelope was assessed, correct?
Yes, technical and financial. Yes.
Yes. So, but this RFP was a 1-envelope system where all the criteria were ranked and aggregated together to arrive at the top ranked proposal, correct?
Yes.
And according to the RFP, there would thereafter be a negotiation phase at which negotiations would be held as to matters including price and design and so on, correct?
Yes.
So, and you say in your witness statement that if all technical proposals were given the same score, then price would be the sole determining factor, whatever the differences in design, correct?
Yes.
But that would be highly speculative and unlikely to happen, wouldn't it, Mr. Conan, that all the technical proposals would be given the identical score?
Well, if everybody achieves the user space requirements and the look and feel of the building, yes, it's entirely possible.
It's possible. Have you ever seen that? Have you ever seen that in your many years of experience, that everybody scored the identical score for technical proposals?
It wouldn't be identical. It would be plus and minus in different sections.
Okay.
Mr. Conan, before you proceed, yes. I see Mr. Mutu.
I was taking an objection on the basis that the witness should be permitted to finish his answer. He was explaining why it would not be impossible or improbable. And he was interrupted by another question, which asked really, had he ever seen it? So I would say the basis of my objection is that the witness is not being allowed to answer the question which has been posed to him properly.
I'm sorry, I asked about the same score, meaning identical, Mr. Conan. Did you understand that was my question?
Yes, it would be.
Sorry.
Mr. Conan, I want you to respond to Mr. Mutu's objection.
I'm sorry, I wasn't aware that I had interrupted Mr. Conan when he was still formulating his answer. I'm sorry, did I do that, sorry.
To speak, Mr. Mutu indicated that he was clarifying or expanding on the issue of whether, in terms of parties getting the identical score, and he was interrupted, so he was objecting. Can you respond to his objection?
I'm sorry, I was saying I was not aware that I had interrupted Mr. Conan when he was answering the question. So, Mr. Conan, can I just repeat the question and Can you answer it? I'm sorry, Mamo. I don't know whether you want to rule on the objection.
No. Well, if it is you're going to proceed to let him answer, then we can continue.
Thank you. I'm just going to ask the question over, Mr. Conan. You said in your witness statement that if all technical proposals were given the same score, which I understand to mean identical, correct?
Yes, will you be plus and minus in different sections?
Same score, Mr. Conan. 10 is 10, not so?
Well, if you have 5 or 6 different sections, you could have variances between the 2 different bidders in different sections, but end up with the same score at the end of it as a total.
This is your language, Mr. Conan. If all technical proposals were given the same score, remember using that language?
Yes.
Then price would be the sole determining factor, whatever the differences is in this, whatever the difference is in design. You remember saying that?
Yes.
And by that statement, you were suggesting if everybody got, I'm just going to use an arbitrary number, 10. If everybody got 10 for their technical proposals, then the sole determining factor, whatever the differences in design and so on, would be price, correct? That's what you were trying to convey? And my simple question to you is that is a highly speculative and unlikely occurrence that in a bid process, every bidder is given the same or identical score for the technical proposal. And what's your answer to that?
It's not that. If you look at the evaluation report in this situation, there's only 0.7 of a difference in the scores.
0.7 of a difference in the aggregate scores.
And to you, that's identical?
It's very close.
All right. Now, Mr. Conan, NH also complains that UDeCOTT acted unfairly in failing to disclose the scoring system that it applied for this cost criterion. Remember making that allegation?
Yes.
But you knew, Mr. Conan, that NH got full marks of 30, correct? When your bid was compared to the internal estimate.
Yes.
So did it not occur to you that the further away the bidder was from the internal estimate, the lower the mark would be?
The expectation is there will be a graded system from cheapest, lowest price.
Thank you, Mr. Conlon. I'm going to ask my question again, and do me the favor of answering that question and no other, please. Did you not understand that the further away from the internal estimate a bidder was, the lower the mark that would be awarded?
Yes.
So, and in this case, Mr. Conlon, knowing what the formula was, would not have affected NH's cost for doing this project, would it have?
In this instance, is the difference between us being awarded the project and not being awarded the project. Sorry.
Mr. Conlon, let me ask the question again. Knowing the formula that NH used to determine the cost criterion would not have affected NH's cost for doing this project, the NLCB building, would it?
No.
Because NH submitted the best price that it could for constructing the 9-story building that it submitted, not so?
Yes.
And I'm suggesting to you, Mr. Conan, that there's nothing unfair in not disclosing the method of how you apply the cost of a bid to the internal estimate.
I would disagree. If we had known beforehand that everybody that was lower than the internal estimate would get the same score, we may have reconsidered actually bidding the project in the first place.
You wouldn't? So you would not have tendered, is what you were saying?
Quite possibly, no.
Okay. But so far as the price is concerned, you would not have been able to do it at a lower price, correct?
I don't think we could do it much lower than that, no.
Now, part of your application, Mr. Conlon, also says that UDeCOTT's failure to disclose the internal estimate was unfair.
Yes.
Now, it's not a practice in the construction industry in Trinidad and Tobago, Mr. Conan, for an employer or project manager in competitive tender proceedings to disclose the internal estimate. Isn't that so?
It happens. It's called GMP, gross maximum price.
Sorry?
Well, we have done several bids that have been GMP pricing, where the client will give you the cannot exceed price for a project, and you're asked to bid on a design build basis for that.
What are the abbreviations? What do the letters stand for, Mr. Conan?
GMP, gross maximum price.
Okay, so when you receive an RFP that is a GMP, gross maximum price, each of the bidders is told your bid should not exceed that figure.
Yes, one of two things: you cannot exceed, or else you get deducted points if you do exceed.
I see. Okay, good. So in those cases, that is where your internal estimate or budget is disclosed to all of the bidders, correct?
Correct.
But outside of GMP bids, Mr. Conan, it is not the practice in Trinidad and Tobago in RFPs such as this to disclose the internal estimate, is it?
It could have been. There's no reason why it couldn't have been. You know what I mean? It hasn't been. But
it hasn't been. No, that's my question. And I'm suggesting to you that outside of a GMP process, you can't conduct a fair negotiation as to price for a project when all the proponents know the price. Do you accept that?
No, I don't. To be honest.
Well, let me go further. If all the proponents know the target price, Mr. Conan, in that GMP example, everyone would have a strong incentive to tailor their price to the target price, not so? To come in below or at, no?
No, they would still go. It's a similar process that you follow. And most of that process is, can you actually build the project for the GMP price? And if you feel like you can, you go through the process, you do your takeoffs, you develop the design, and you come up with your price. Your price is still going to be your price, and whatever you're going to come in with your price is going to be the same, because you're still in a competitive nature where others are going to be pricing it honestly, really, because if you win the project, you want to be able to build it.
Sorry, thank you. But also, Mr. Conan, if you're a contractor that doesn't have a lot of work and you've given the internal estimate, you're not going to want to take the chance of submitting a proposal that's higher than the internal estimate because you're not likely to get the job, not so?
Well, if a contractor was willing to cut their price just to get a job for turnover purposes, that's market forces at work. Sometimes clients get the benefit of that, sometimes they don't.
And of course, the opposite might be the case too. You might have a bidder who's not really able to do it at that price or below the internal estimate or the GMP, and he submits a bid below it because he feels that he has a good chance of getting it, not so?
Well, that's where you rely on the technical part of your RFPs and your evaluation processes to make sure that whoever's submitting this price can actually build the project in the first instance. And secondly, you have your internal estimate to advise for abnormally low pricing.
But in this case, 30% of the mark was allocated to costs. So you might have done reasonably well on your technical aspects, but you weren't able to, compare favorably to the internal estimate. Correct? Well, that was possible on an application of these evaluation criteria, wasn't it?
Not if you're lower.
Not if, sorry?
If you're higher than the internal estimate that nobody knew, you would lose marks. Yes?
Yes, exactly. So I think everyone now understands how it works. And I'm suggesting to you, Mr. Conan, that the provision of the target price would not achieve the objective of obtaining value for money because the employer would not be in a position to ascertain whether the contractor is really able to do the job for the target price or less.
I disagree. The
You
technical,
don't accept that.
not on a cost basis, on a technical basis. But this was also an invited, this wasn't an open bid. There were select contractors request to bid. Everyone, I would expect UDeCOTT to have knowledge of them contractors and be able to assess that they're capable of doing the job in the first place.
Thank you very much, Mr. Conan. Well, that will be a matter for submissions. Let's turn next, Mr. Conlon, to your contentions in relation to experience. Now, you accept that the complaint is that you lost 0.2 of a point, correct?
Yes.
For the experience of your architect, correct?
Yes.
And you accept that the RFP required bidders to demonstrate experience on at least 2 projects of a similar nature of a value of at least $5 million, correct?
Yes.
And projects of a similar nature was defined as institutional and office accommodation buildings. And examples were given: fire stations, police stations, schools, prisons, office buildings. And then the language again of a similar nature as indicated by the requirements of the technical specifications. Remember reading that?
Mm-hmm. Yes.
And the RFP also said that proponents are encouraged to provide details on as many projects as possible in order to be awarded the maximum points possible, correct?
Yes.
So you read and understood that it was talking of projects of a similar nature as indicated by the requirements in the technical specifications, correct?
Yes.
Now, the technical specifications for this RFP are to be found in a document called Performance Specifications for the Proposed Head Office.
Okay.
Mr. Conan, I'm going to take you to just answer my question. Yes, it's internal page 80 and it's page 96 of the internal of the electronic bundle. That's where it starts. And I'm going to invite you to look at paragraph 1.2, which is page 84 of the internal bundle, 96 of the electronic bundle. Do you have it, Mr. Conlon?
I have the cover sheet for the performance specification.
Right. And if we go to internal page 84, which is electronic page 100.
Okay.
You're just interrogating what are the requirements in the technical specifications. So paragraph 1.2 says the National Lotteries and Control Board is desirous of consolidating all its services located at various sites into one head office building and providing more adequate office space for its current insufficient head office. The intent is to include rentable office space within the new head offices to provide passive income for the company. The new NLCB head office and car park facility will extend from Pembroke Street to Abercrombie Street. Site area 38,018 square feet. The 7-story building will provide approximately 109,178 square feet of office space. And if we go down to the bottom of the page, Mr. Conlon, under 301, you'll see energy efficiency. Computerized building management system optimizes energy use by mechanical and electrical systems, solar energy use within the building to cut energy costs, use of natural day lighting to reduce lighting energy costs, correct?
Yes.
And there are many other performance specifications. Now, Enid submitted 4 projects for the architect. Mahogany Court Housing Development, yes?
Yes.
Pan American Life Insurance Company,
Yes.
where Mr. Homer, Stephen Homer, was the interior architect. He didn't design the entire building, correct?
Correct.
And the, Carenage Police Station.
Yes.
And the Cliff, which is standalone bungalows in Barbados, correct?
Yes, in Kitts, I believe.
St. Kitts? I'm sorry. No, none of these projects I'm suggesting to you, Mr. Conlon, were of a similar nature to the 7-story commercial building as indicated by the requirements in the technical specifications.
Okay. But during our debriefing, we were told something different. We were told
just answer my question, Mr. Conan. It's a very straightforward question. I've read for you the requirements of the RFP. I've identified the projects. And I'm asking you whether any of the 4 that I've identified for you, one of them being interior design of a building, and not the design of the building itself, is of a similar nature to the 7-story commercial building as indicated by the requirements and the technical specifications of this RFP.
Yes, I would say mahogany court because it's 8 stories high, is similar in nature. Even though it's a residential building. It's
but
very,
mahogany,
very similar.
Thank you, Mr. Conan, but mahogany court was used.
Yes.
I thought your complaint was that mahogany court should not have been used and Carenage police station should have been.
Well, we were told during the debriefing that it was mahogany court that he was marked down for because it was a residential building.
So you have no complaint that mahogany court was used?
Well, we were told we lost marks because of that.
Mr. Conan, forget what you were told.
I'm
asking you today.
It's part of the record.
No, I'm asking you today because I think your evidence today is that mahogany court should have been used.
I don't believe he should have been marked down for it. And if he was going to be marked down for one project, they should have used the police station at Carenage because that was listed in the RFP as a basis to get full marks.
Mr. Conan, I'm going to read paragraph 34 of the application for your review, which you certified as correct. And your complaint is that UDeCOTT wrongly focused on Mr. Homer's experience on a mahogany court housing project and ignored his experience stated on the Form 7, that is the Carenage police station. That is no longer your position?
My position was we were told by UDeCOTT.
Forget what you were told, Mr. Conlon. You're giving evidence under oath today, and you've just said to us the only project that you consider to be of a similar nature is mahogany court. That's your evidence. Do you now complain about mahogany court being used instead of the Carenage police station today?
The complaint is based off what we were told by UDeCOTT.
I understand what you're saying, Mr. Conlon. I understand what you're saying. But you're in the witness box now. You're NH's sole witness. You have told this panel the only project that you consider to be of a similar nature as indicated by the requirements and the technical specifications is mahogany court. So are you no longer...
And I said at the end of that statement, from a multi-story point of view.
Yes, whatever the reason, I understand. But we're talking, the 2 options are mahogany court and Carenage police station. And your evidence to this panel under oath is that the only project of a similar nature.
The Speaker, I think you're
trying to take an objection.
I'm sorry, Mr. Mutu.
I'm sorry. Yes. Yes, my objection is this, that the witness is the question is irrelevant because the claim as formulated is set out in NH's challenge Form 8. That is the complaint, that is the case. To ask the witness whether he's no longer complaining about X or Y does not take the matter any further. We have not withdrawn the complaint as set out as formulated. So seeking an answer from the witness as to whether his complaint is now X or Y is, with respect, irrelevant.
Can you respond to your friend's objection?
That is a very strange objection. Sorry.
Mr. Mutu, are you finished?
Yes, I am.
Thank you, Mr. Mutu.
That is a very strange question, objection to take. We know what the application for review says, but I think what Mr. Conan is saying is that something was said to him in the debriefing session that led them to believe that it was the mahogany court project that was used, and that is why the complaint is that you should have used Carenage Police Station. But coming out of the witness's own mouth,
Okay,
in answer to the question.
Ms. Speak, 1 minute.
Sorry.
Mr. Conan, are you able to step out of the room for a bit?
Yes.
Yes, so we will contact you when we want you to step back in. Leave the
Okay.
link as well, sorry.
Leave the link. Yes?
Yes.
Okay.
Ms. Speak,
Yes.
are you hearing us clearly on your end?
Yes, I'm hearing you.
Okay, right. So you can proceed with your response to Mr. Mutu's objection.
Thank you. My question to the witness was, none of these projects were of a similar nature to the 7-story commercial building as indicated by the requirements in the technical specifications. And the witness said the only one that he is of the view is of a similar nature is Mahogany Court. So I then said to him, in your application for review, your complaint was that the UDeCOTT wrongly focused on the experience on Mahogany Court and ignored the Carenage Police Station. And I'm asking him whether today that is no longer his position. What is unfair or improper about that? This is the witness giving evidence. He certified the application for review and he's giving evidence on oath. So why can he not? Why is that not a proper question to ask him?
Miss Speak, what I understood your friend objection to be that your question is irrelevant, not unfair. Am I correct, Mr. Mutu?
Yes, that was the basis of the objection.
Yes, the issue is relevance, not fairness.
Well, I apologize. How could it not be relevant when, a certain contention has been made by this witness and then he gives evidence that contradicts that contention? The application for review is certified to be true and correct by him. And I believe what he is saying is we put it in there because that's what we understood from the debriefing meeting. But I'm asking him today, the 21st of February, you are giving evidence on behalf of NH. Is your position no longer that it was wrong for UDeCOTT to focus on Mahogany Court, which you say is the only one that is of a similar nature? So, I don't understand how the question could be viewed as irrelevant. It's very, very relevant. It goes to the very base of the ground of challenge and the credibility as to whether that is still being maintained.
Well, I would tend to agree with your friend. You would have mentioned it several times today that the focus is the grounds that are on the pleaded documents, right? So if the NH has filed in their Form 8 and they've indicated the issue, whether or not Mr. Conan disagrees with it today, right? It doesn't really advance the issue that is before the panel. So I would agree. The objection is upheld and we bring the witness back in and we'll proceed from this matter.
Thank you, ma'am.
I think the witness has signed off of the link altogether. We're going to have to try to get him back on.
We did ask him to sign off. So if you can contact him, we will give you a few minutes, Mr. Mutu.
I'm obliged. Thank you.
In the interim, Mr. Chanona.
Yes, ma'am.
I have noted during the proceedings you have been up and in and out of the room.
I went to move the curtain because it was getting dark, and I went to get a glass of water because it had finished.
Yes, so I appreciate you may not want to interrupt the cross-examination, but please indicate at least in the chat that you want to be excused.
Okay, because that's why I didn't want to, but yes. I'll use the chat in future. Sorry about that, Madam Chair.
Yes, thank you. And Ms. Speak, whilst we are waiting to witness, can you tell us how long, can you give us an average of how long again you may have with this witness?
I'm about halfway through, ma'am.
Halfway through. Perhaps. Let me consult with the panel as to whether this may be an opportune time to take a break.
Certainly.
I appreciate that you are halfway through your cross-examination. Would it be okay for us to take the lunch break now, or would you want that we start and then we break?
No, whatever is convenient to the panel.
Mr. Mutu.
Yes, Madam Chairman, I do have a question because I'm just trying to understand what the scheduling of these proceedings are going to be. I know you have a timeline of next week, Thursday, I believe, to deliver your decision. And I appreciate today was set aside for taking evidence, but looking at the time, and if Mrs. Peak is going to be perhaps another 45 minutes to an hour, I am just trying to understand what are the logistics for the continuation of the hearing. Are we likely to continue later today? In which event I'm happy to do so. Or are we to return on another day?
Well, Mr. Mutu, we're going to try to see as much as we could conclude today. So the aim is to conclude today.
I'm obliged. Thank you.
So with that being said, since Ms. Peak has no objection to taking the break now, we can perhaps take a half an hour break, and by which time, so we will return, well, at 2 o'clock, just to be exact, just a few minutes over 30 minutes. And so, Mr. Mutu, you can get your witness ready. By that time, do remember that he's under oath, and to have discussions with him. So we'll take the break now.
And ma'am, can you direct the witnesses not to have discussions
about? Already, right, yes. I didn't realize he returned. Yes. Mr. Conan, you're not to have discussions with anyone concerning this matter and your evidence. You're under oath and you're still being cross-examined.
Understood.
So return at 2 p.m. Thanks, everyone.
Recalling the matter of CP 2025-2 Kee Chanona Limited against Urban Development Corporation of Trinidad and Tobago and CP 2025-3 NH International Caribbean Limited against Urban Development Corporation of Trinidad and Tobago.
I see Ms. Peak and Mr. Chanona. Mr. Mutu?
Yes, I
Right.
I apologize.
So I see all the parties here. Ms. Peak, can you give us an idea of how long? I know you said you're halfway through, but in terms of time.
My estimate, the rest of it, we should move pretty quickly, so no more than an hour, I would think. That's my estimate.
And Mr. Mutu, can you give us an estimated time that you may be on cross?
I mean,
with the other witnesses, for
Mrs. Peak's witnesses, about
Yes.
2.5 hours. It depends on how the process of question and answer goes.
So, okay, thanks. So we continue with Mr. Conan. So, Mr. Conan, we're going to continue with your cross-examination. Ms. Peak will continue with your cross-examination.
Okay.
Ms. Peak, you may proceed.
Good afternoon again, Mr. Conan.
Gotcha.
When we took the break, we were discussing projects of a similar nature to those indicated by the requirements in the technical specifications, correct?
Yes.
And in your application for review, your complaint was that the Carenage police station should have been considered instead of Mahogany Court, correct?
Yes.
Now, Carenage police station is a 2-story building with no indoor parking facilities, correct?
Yes.
So no one would look at the Carenage police station, Mr. Conan, and a 7-story commercial first-class office building and suggest that the two of them have the same requirements of this technical specification. Would you accept that?
Not directly, no.
You don't?
Police stations were mentioned.
No, I know it was mentioned, but my simple question to you is, would you consider the Carenage police station, which you've identified, and a 7-story Class A office space building with an auditorium as of a similar nature as indicated by the requirements in the technical specifications of this RFP?
Only insofar as the open office spaces would be similar, but other than that, no, not really.
Other than that, no. Can I invite you to look at internal page 477? It's electronic bundle 493 to see where the projects are listed. Can you look at it, Mr. Conlon?
493, I've got...
Yeah, 477 internal page 493 if you're looking at the electronic bundle.
Okay, yes.
So Mahogany Court was a $192 million project, correct?
Yes.
Carenage Police Station was a $53 million project.
Yes.
And you made no complaint about using Pan American Life Insurance, correct?
No, after the meeting that we had, they stipulated the problem was with Mahogany Court.
Okay, so, but I mean, in your application for a review, you've made no complaint about Pan American Life Insurance.
Well, we listed 4 projects.
Mr. Conlon, let me see if I can remind you. Your complaint was that Mahogany Court should not have been used and Carenage Police Station should have been used. Do you recall that?
Yes.
There's no mention about Pan American Life Insurance.
No.
And can I invite you to look at the description that is next to Pan American Life Insurance, which is a $12 million project? Mr. Homer was the interior architect, wasn't he?
Yes.
And what the description is, he was the lead designer and project lead for the design, furniture, and finishes selection and specification, construction management, and supervision of 16,000 square feet of commercial office spaces, upgrade to accommodate executive floor and 4 number agencies at the headquarters building of Pan American, correct?
Yes.
Would you describe that as a project of a similar nature to the 7-story Class A commercial building with an auditorium as indicated in the technical specification?
I'm objecting.
Yes.
Sorry, please forgive me for not raising.
Mr. Mutu?
Can't hear you, Jason.
Sorry, I said, please forgive me for not raising my hand, but what has been happening, understandably, is sometimes I raise it and it doesn't come to the tribunal's attention until after maybe 1 or 2 questions. So I apologize for that. I'm taking the objection on the ground of relevance.
Yes.
As Mrs. Peak has pointed out, the concern of NH in relation to experience is in connection with the failure to utilize the Carenage police station. As to whether or not Pan American is a suitable building or not for the purposes of evaluation is not an... Yes.
Again, could we have Mr. Conan leave while we discuss the objection? Very much.
Okay.
Yes, Mr. Mutu, you may proceed.
Yes. I'm saying that whether or not Pan American was a suitable choice for evaluation under Mr. Homer's experience is not with respect, and I may have missed it, but I don't think I have, is not an issue which arises on the pleadings or even in relation to the evidence. So my objection is on the ground of relevance.
Thank you, Mr. Mutu. Let's speak. Do you want to respond to the objection?
I think the witness answered the question already. So I don't think I need to pursue it further.
From the record.
Well, if that's the case, then my application would be to strike that item of evidence from the record.
I think that would be a matter for submission, Mr. Mutu. I don't think that is an occasion to strike it out. The question was asked and answered.
I don't think Mrs. Peak could be ruling on my objection, so I'm sure that's a misplaced comment.
So,
Speak. Do you want to respond to, apart from the fact that the witness may have answered the question, your friend
yes.
is relevant?
Well, as far, I mean, in my respectful submission, the question was asked and answered before the objection was taken. And then Mr. Mutu says, you should strike it out of the record. And my response to that would be, that would not be appropriate. It is for my learned friend to make any submissions he wishes to make as to the relevance of the evidence that has already been given by the witness. That is how I understand it.
Okay, so when the witness return, we would not be returning to this issue of the Pan American building, correct?
Certainly, my lady.
Mr. Mutu, do you want to respond?
Well, I think you've made your ruling. If I understand it, it's that the evidence remains in the record. Or
No,
have I misunderstood that?
No, when we consider it, we will determine how much weight to attach to it at that stage.
I'm guided, thank you.
Yes. Can you ask your witness to return?
We are trying to do so.
Thank you very much. Thank you, Mr. Conlon. Ms. Peak, you may proceed.
Yes, Mr. Conlon, I'm suggesting to you that when you have regard to the 4 projects that were listed by NH at pages 477, 478, there can be no legitimate complaint with regard to the score of 4.8. What do you say to that?
We put forward the 4 projects that we thought were most relevant. Obviously, there was more projects that Mr. Homer has done that we could have put forward. We do find harsh, shall we say, that he was marked down, because the relevance of Mahogany Court is exceptional in that it's an 8-story structure. When you're in construction, anything over 3 to 4 stories is a completely different building that you have to factor. The fit-out work he did at Pan American is important because it was larger than the actual fit-out that we have to do at NLCB on a square foot basis. So I do see relevance in these.
But, and Mr. Conlon, would you not accept that the building elements such as finishes and mechanical, electrical, and plumbing services are vastly different in an apartment building than in a Class A office space with these technical requirements?
But the office space he did for Pan American would have dealt with the air conditioning and, the MEP requirements that you would need in an office block. The Mahogany Court will deal with the challenges of working at extreme heights over 4 stories. So they're both relevant.
Well, they might be relevant, Mr. Conlon, but they are not of a similar nature as indicated by the requirements in the technical specifications. That's the point.
Well,
yes or no, and let's move on.
All right, I'll stay with no, because
all right, and anyway, I wouldn't go back, even though you mentioned Pan American, I won't go back to it. In fact, I'm suggesting to you, Mr. Conlon, that 4.8 was a general score having regard to the projects which you identified and the criteria identified in the RFP. What do you say to that? Yes or no?
I disagree.
All right. Now let's move on to the next point, which is the debt ratio and the liquidity ratio. Now, you have many qualifications, Mr. Conlon, but accountancy is not one of them, is it?
I would be very much a layman, for sure.
Okay, good. Now, in your application for review, you said in treating with the sub-criteria debt ratio and liquidity ratio, UDeCOTT disregarded and or ignored international standards and or best practices for construction companies and arbitrarily deducted points from the score awarded to NH. Since NH exceeded international standards and or best practices, NH ought to have been awarded the maximum score for these criteria. Remember saying that?
Yes.
And that is NH's complaint in this case, correct?
Correct, that's right, yes.
So let's go to page 14, which lists the evaluation criteria. This is electronic page 30.
Yep.
You see it, Mr. Conlon, and under proven financial capacity, which is item 4, it says audited financial statements 2020, 2021, 2022, or management accounts for the same years prepared by a member of UDeCOTT in good standing. Net worth 4 points, debt ratio 2 points, liquidity ratio 2 points, return on revenue 2 points, right?
Yes.
Now you would agree that to get the maximum points for debt ratio and liquidity ratio, it wouldn't simply be because you submitted the audited financial statements for those 3 years, correct?
I agree, yes.
Because that provides the information from which the ratios can be calculated, correct?
Yes, agreed.
And you would read and understand this to mean that the healthier the debt ratio is and the healthier the liquidity ratio is, the more points that you would get.
Yes.
Or to put it another way, using these criteria, you would get higher marks for ratios which indicate, to use the language of item 4, a proven financial capacity, correct?
Yes.
Now, NH did submit its audited accounts for 2020 to 2022, yes?
Yes.
And of course, they were prepared long before this 2024 RFP was issued, correct?
Yes, I believe so.
And you've read the witness statement of Simon Cely on behalf of UDeCOTT?
Yes.
And in that witness statement, you saw her say that for debt ratio, she utilized the ratio of total liabilities over total assets?
Yes.
And would you agree with me, or if you don't have the capacity to do it, tell me so? Would you agree that that ratio is not in breach of or inconsistent with international standards or best practice?
It's not in breach. It is an international standard that's used. It's just not a standard we would expect to be used in this situation.
So it's an accepted manner of calculating a debt ratio?
It is, but not in this situation.
But not in this situation, you say?
No.
Okay. Now, in your witness statement at paragraph 57, you say NH understood debt ratio to be debt to equity ratio, correct?
Yes.
Now, ma'am, I'm going to require the electronic page to be brought up on the screen, which is his witness statement at page 1729, because we're going to have to click on that document. So it's his witness statement, page 1729. It's very near the end of the witness statement. Now, Mr. Conan, who provided you with this document?
Our CFO.
Your CFO, all right. And can we just scroll down, please?
1 minute, Mr. Mutu?
Yes, thank you. For one reason or another, we are not seeing the document. We are simply seeing.
We're seeing the document, Mr. Mutu. It's on the screen.
Yeah, I have no doubt you are. We aren't. We're just seeing the letters CM.
It is. On my screen has several pages. I don't know whether it might be on a different page on your.
So, let me see, Mr. Chanona, are you seeing it?
Yes, ma'am, I am.
The document on the screen?
What I'm seeing, Sonny says ready ratios.
Right. And Mr. Conan, you're seeing the document on the screen?
I am, yes.
So, Mr. Mutu, you may want to check your.
Well, it may be something on my end with the settings. We just follow on the, if we get the relevant page number, we can find this one. But for the other documents, which have to be put up on the screen, if the relevant page number can be identified,
yes.
We are grateful.
It's final, it's titled Final Witness Statement. It's Mr. Conan's witness statement, 1729, the electronic version.
Thank you.
At the top of the page, it says ready ratios.
Can we scroll down? Sorry.
So, Mutu, you have another question?
No, I was just saying we found it. Thank you.
Great.
Okay, thank you. So, Mr. Conan, you see there under solvency ratios, there's something called debt ratio and debt to equity ratio, correct?
Yes.
So that suggests they're two different things, not so?
Yes, I suppose. Yeah.
So do you accept that debt ratio is not the same thing as debt to equity ratio as NH is contending in its application?
Well, generally speaking, we do the debt to equity ratio. What was given to us was an asset to liabilities ratio.
Well, what the RFP said was debt ratio. It didn't say debt to equity ratio. Do you accept that?
Okay.
And this document is saying there's one line for debt ratio and debt to equity ratio has another line. So does that not suggest to you that they are not identical?
It would suggest so.
All right. Now, And it says in the application that UDeCOTT arbitrarily deducted points from the debt ratio. And in support of that allegation, your witness statement relies on this document, which deals with construction average industry financial ratios for US listed companies, correct?
Yes.
No, sorry, NH is not a US company, is it?
No, it's not.
NH is not a publicly listed company, is it?
No, it's not.
And if you look at the averages, a debt ratio for these various years over the period 2018 to 2022, you would agree that NH's debt ratio was kind of around these averages, not so?
I haven't got the document in front of me for our financials, so. But if you say so, I'll take your word.
So what is NH's debt ratio according to you, Mr. Conlon? Average, sorry, for the 3 years.
Document. Just give me a second. Let me look up the electronic version. Okay. From our point of view, debt ratio would be 0.07, 0.02, and 0 for the 3 years.
Well, we're going to come to, but you have two different computations. If you look at paragraph 59 of your witness statement,
yes,
when you looked at total debt,
0.63,
and you look at the 3 years,
0.62. That would probably
the average is about 6, not 0.6, not so?
Somewhere around that, maybe 0.59.
So therefore, according to this document that you provided, NH's debt ratio was about average, correct?
Yes.
So I'm suggesting to you, Mr. Conlon, that one would not expect to get the highest marks or points for average performance, would you?
Can I speak a little bit on this?
No, sorry. Just answer my question. It's a very specific question. You said you agree that it's about average, and this is a very simple question. We all people of the world. You're an employer or in the position of an employer. You would not expect to give the highest points for average performance. Don't you accept that?
Yes, but when the performance is in the hundreds of millions, it's different from when it's in the tens of millions.
Well, that would be a matter for submission, Mr. Conlon. I'm suggesting to you that what UDeCOTT did was not arbitrary at all, contrary to NH's contention.
We find it, if it is a straight asset to liability calculation, it's unfit for this purpose, in our opinion.
If it's a straight asset to liability comparison, it's unfit for this purpose?
Yes.
But did you not accept that that is what the definition of debt ratio means?
No, it's not. We assumed it was debt to equity.
Or you assumed it's a debt to equity. And as we pointed out to you here, it's two different things on your own document, correct?
Well, it seems so.
No. Ms. Cely in a witness statement says how the debt ratio was scored. And she says full marks were awarded for less than 0.5 and less marks for a score between 0.5 to 0.1. Correct? You remember reading that?
Yes.
And NH's average was 0.6, so a score of 1 was applied. Remember reading that?
Yes, the average is 0.59.
So I'm suggesting to you, I don't think it's 0.59, it's 0.6. But anyhow, that'll be a matter for submission. I'm suggesting to you that there's nothing arbitrary about marking in that way, based on the document that you provided, which is the only document you provided, Mr. Conlon.
Yeah, if you're speaking on arbitrary, yes. it is an arbitrary decision.
But what is the basis of the arbitrariness, Mr. Conan? Your own document is saying these are averages.
Yeah, well, it does not take into account the amounts involved, the values involved.
Okay, so
Yeah,
depending on the value, sorry, depending
Yeah,
on the value, it makes a difference.
Well, it would do. It shows average. We have about 140 million in cash, where we could go and build the project, even if UDeCOTT never paid us. There's no other contractor maybe could sustain that in this region.
Okay, Mr. Conlon, thank you. Now, this is the only document that you have supplied in support of the complaint in your application for review at paragraph 35, correct? International standards and or best practices, correct?
Yes.
All right. Now, if we go to the same document and we click on the words debt ratio, you could do it here. Can you click on the word debt ratio?
Yes, please.
And go to the next page. I'm able to do it on my electronic version. Can you do it, Mr. Conlon? Click the words debt ratio. Okay, it takes you to another page. Yes, and right. And can we go to the words? Go down a bit, please. Yes, more about debt ratio. Do you see that in blue? Can we click that, please?
I've got a breakdown by industry.
We go into debt ratio. Yes, you see that? And if we go down that page to benchmark.
Sorry, it's taking me somewhere else, so I'll just follow yours.
Okay, take your time. So debt ratio, then more about debt ratio, and then benchmark, which is up on the screen.
Mr. Mutu?
Yeah, for some reason I'm getting taken to debt ratio breakdown by industry page.
No, okay. Well, see if you could focus on what's on the screen then, Mr. Conlon.
Okay.
You see benchmark? And are you able to read the optimal debt ratio is determined by the same proportion of liabilities and equity as a debt to equity ratio. If the ratio is less than 0.5, most of the company's assets are financed through equity. If the ratio is greater than 0.5, most of the company's assets are financed through debt. And then it goes on maximum normal value 0.6, 0.7. You see that?
Okay.
So when Ms. Cely says that full marks are awarded for less than 0.5, I'm suggesting to you that that is rational and reasonable and not arbitrary. What do you say to that? According to your own document, I should see. According to your own document.
It says here.
Mr. Conan, do you accept that it is not arbitrary as you have alleged, but based on this document, full marks for less than 0.5 is rational? Yes or no?
Based on this formula, yes.
Now, so do you accept then that NH's statement in its application that UDeCOTT disregarded and or ignored international standards and or best practices and arbitrarily deducted points is a wrong statement based on the document you have provided?
Possibly.
So I'm suggesting to you that UDeCOTT applied normal accounting standards and benchmarks.
I think they applied a calculation that we don't think is fit for purpose.
All right, I hear you. Now let's look at your second area of complaint, the liquidity ratio.
Mm-hmm.
We may need to go back a few pages, but we'll come to that. Paragraph 25 of Ms. Cely's witness statement says that UDeCOTT got full marks if you had a ratio of greater than 2, reduced marks for a score between 2 and 1, and anything less than that got a score of 0. And since NH's liquidity ratio average was 1.1, a score of 1 was applied. Remember reading that?
Yes.
Now, do you agree then that that is a rational and logical way of ascertaining what your liquidity ratio is?
The average over the 3 years is 1.503. So, okay, I'm not
right.
I'm not an accountant.
So the higher marks you would get higher marks for a better ratio, which indicates higher liquidity, correct?
Okay.
That's logical. And that would indicate the contractor is better able to have cash to pay his labor and suppliers so that the work could progress and eventualities could be provided for.
Yes, as I've just stated, the quantum of the money, the cash in hand, is critically important in this situation.
Well, here you're being assessed for liquidity ratio. That's what is being tested here.
Yes.
It's not cash in bank.
And I stated over these 3 years, we would have 140, pretty much the value of this project, cash in hand.
We'll talk about that in a little while. So lower marks would mean a lower ratio because you have less access to cash to pay your labor and suppliers to enable your work to progress and to provide for eventualities, correct?
Well, not in this situation. I understand what you're saying, but not in this situation. Not for NH, should I say, in this situation.
Well, not for NH. Okay, let's go back to page 1729, which is your ready ratio site that your CFO put you on to. Page 1729 of his witness statement. So there's information there dealing with benchmarks for liquidity ratio. So can we click current ratio on the liquidity ratios, please? Sorry, it's come off the screen. Right, so can we, that's not, no, I don't think this is not his page 1729.
And that's the one I got when I clicked on that.
Okay, ratio. So can we go back to Mr. Conlon's 1729 of his witness statement, please? Construction average industry financial, yes. So if we click current ratio under liquidity ratios, and then can we click then more about current ratio? Can we go down a bit, please? Yes, under what is the normal value of current ratio? I'm going to read it for you, Mr. Conan. The higher the ratio, the more liquid the company is. Commonly acceptable current ratio is 2. It is a comfortable financial position for most enterprises. Acceptable current ratios vary from industry to industry. For most industrial companies, 1.5 may be an acceptable current ratio. Generally, a ratio of 1.5 to 2 is considered a normal and acceptable value, meaning that the company has $1.50 to $2 of current assets to cover each dollar of current liability. A high current ratio may indicate that the company is not efficiently managing its current assets, while a ratio below 1 may indicate that the company may struggle to make its short-term payments in a timely manner. It is important for investors to analyze a company's current ratio to get an understanding of its short-term financial health. Low values for the current ratio, values less than 1, indicate that a firm may have difficulty meeting current obligations. However, an investor should also take note of a company's operating cash flow in order to get a better sense of its liquidity. A low current ratio can often be supported by a strong operating cash flow. If the current ratio is too high, much more than 2, then the company may not be using its current assets or its short-term financing facilities efficiently. This may also indicate problems in working capital management. All other things being equal, creditors consider a high current ratio to be better than a low current ratio because a high current ratio means that the company is more likely to meet its liabilities, which are due over the next 12 months. You understand what the document is saying?
Yes, I do.
So this is consistent, Mr. Conlon, with UDeCOTT's allocation of marks for liquidity ratio greater than 2. Reduced marks are applied for a score between 2 and 1, and anything less gets a score of 0. And since NH's liquidity ratio average was 1.51, a score of 1 was applied. Correct?
Well, I don't agree. This document says a ratio of 1.5 to 2 is considered normal and acceptable value. So therefore,
well, again,
we should have got 2 points.
Sorry. Yes, I accept that. So normal and acceptable, according to this, but it also says a ratio of less than 1 indicates difficulty in meeting obligations, correct?
That's fine.
So 1.1 is just within the range of normal. 1.51, sorry. 1.51 is just within the range of normal.
Yes, and the first year that it was low was, there's reasons for that, but on average, we're still above the 1.5 threshold.
But you're just above the 1.5, you're 1.51, and I asked the question again, would you give top marks to somebody that is just within the range of normal?
Normal and acceptable, yes, they should get top marks.
Well, that's not what your document says, Mr. Conan. So I'm putting to you that NH's marks for liquidity ratio were rational and reasonable and in line with normal, well-known accounting standards. What do you say to that?
I disagree.
Is it correct, Mr. Conlon, that when you calculated your debt ratio, debt equity ratio, as you called it, you used only the amount owing to banks and didn't have regard to the other debts, liabilities or debts?
I don't believe so.
So then why is it you did 2 different calculations in 58 and 59 of your witness statement? And in 59, you say, out of an abundance of caution, NH has also calculated its total debt ratio using total liabilities and not just debt financing. Are these your words, sir?
Yes, they are.
So according to NH, UDeCOTT was wrong to use all the liabilities of NH. It should have just used debt financing.
I believe so, yes.
Even though we know the definition is total assets over total liabilities? That's still your position, Mr. Conan?
Yes, well, I've already made my point on the adequacy of total assets over liabilities in this situation.
But you accept,
it's not fit for
but you accept that that was a matter for the judgment of UDeCOTT, the evaluating entity, not so? Do you not accept that?
No, we don't agree with how they've applied it, no.
Can the document be taken off the screen now, please? And in fact, according to the witness statement of Ms. Cely, NH was very selective in the debt it chose to determine the ratio. Isn't that correct? Debt, as you call it, the debt to equity ratio?
That's her statement.
I'm asking you what you did, or if you didn't do it yourself and somebody in your organization did it, tell us you're not able to answer.
The finer details I'm not really in a position to answer.
So you're not able to refute the evidence that NH was selective in the debt it chose to determine the debt to equity ratio.
I can neither confirm or deny. From the
thank you.
The information that I have, we use standard practices. So
you use standard practice. All right. So we have your evidence. I'm just going to move on now to your supplemental witness statement, Mr. Conlon, that the panel has agreed to accept in evidence. So we've been through the earlier RFP for the same project, correct? That was issued in September 2023.
Yes.
And that was that had the same Town and Country Planning Commission, Planning Division requirements, correct?
Yes.
Which was a 7-story building, height restrictions and car park, correct?
Okay.
Yes?
Yes, there was some slight differences in the RFP's requirements.
Right, but basically the building was to comply with town and country planning requirements, which was common to both, correct?
The town and country planning was the same for both, yes.
Good. And of course, NH submitted a bid in response to the 2023 RFP.
We did.
And according to your witness statement, that RFP was based on the identical conceptual design and specifications as the one in February 2024. Correct?
More or less, yes.
Well, these are your words, sir. Identical. I don't know, you could have more or less with identical. You said the identical conceptual design and specifications.
Yes, okay. Fine, identical.
Sorry?
Yes, identical.
Okay. So just 5 months after the first bid was submitted, and it submitted a bid in response to this RFP.
Mm-hmm.
Yes?
Yes.
And you are claiming for the preparation of this bid $127,125, correct?
Yes.
Now, in your application for review, you certified that the information in there was true, and you also said you understood that if you submitted false or misleading information, that could result in the panel taking appropriate action under the Act. Remember that?
Yes, I do.
And I take it that you're aware under the Act that if you submit false or misleading information, this is an offense and you're liable on conviction to a fine of $500,000 and imprisonment for a year. Did you know that?
Yes,
Okay.
I'm aware.
Now, in that application, you certified as true at paragraph 38 that NH's bid preparation costs were $239. So, sorry, $239,625. Remember that?
Yes.
Now, you did not attach to the application for review any proof of that sum, did you?
No, I think we have done it on the supplemental witness statement.
Is that a yes? You didn't attach any to your application for review?
Possibly not.
Well, did you submit any document proving that $239,625 was spent in preparing this bid?
Can you check the document, please?
Sure.
Can you tell me at what page electronic?
The application for review that you have, the application for review, if you have it, it is page 12, electronic bundle.
Okay, yeah.
So there, paragraph 38, you said bid preparation costs were incurred in a total sum of $239,625. You see that?
Yes, yes, I see that.
Now, in your witness statement that you filed, you say that NH is not able at this stage to provide documentation to substantiate that cost, correct?
Not the designer's costs, no.
So at the date of the application which you certified, you had no proof that the sum of $235,629 was, as you say, incurred.
It was expected to be incurred.
That's not what it was said, you know, Mr. Conan. You said these costs were incurred. So you're now saying that they were expected to be incurred?
Well, they were incurred, but we have found a way to offset them on the design side by getting other work for the design team.
So because they were working on other projects is what you mean?
Yes.
Now, as an experienced contractor, Mr. Conan, you're aware of the tenet that says when an RFP is issued and a tender comes in response to the RFP, there's a preliminary contract that comes into existence and parties are expected to act in accordance with that contract. Are you familiar with that or not?
I believe I've read that summary, yes.
All right. And this RFP at clause 5.8, and I'll just read it for you, says, each proponent is solely responsible for the risk and cost of preparing and submitting its response to this RFP and any negotiations relating thereto. Neither UDeCOTT nor its officials, employees, or contractors are liable for the cost of doing so or are obliged to remunerate or reimburse any proponent for these costs. Remember reading that?
Yes.
Good, and you understood what that meant, right?
I understood if all being equal, yes, there would be no reimbursement on a failed
Right,
bid.
and similarly, there's a clause 418 in the RFP that says UDeCOTT does not bind itself to reimburse proponents for any expenses incurred in preparing their proposals. Remember reading that?
Yes.
Now, when NH tendered for this same project in 2023, and no contract was awarded, NH made no claim for bid preparation costs, correct?
No, we generally don't.
You generally don't, because you understand that's a term of the RFP that's pretty standard, correct?
Yes.
But notwithstanding that, you submitted a bid in response to this RFP, NH is seeking to recover the cost of preparing that bid.
I think the term that we used, should be quashed.
Well, we're not on quashing, but you're seeking to recover
It's only under that rationale, what would we say?
Yes, it's sounding like a lawyer, but I'm only on the question of,
Sorry,
of
I've
the
spent too much time with you
reimbursement.
guys recently.
Yeah, you're seeking to recover the costs of preparing the bid for this 2024 RFP, correct?
Yeah, under the auspices that if it gets quashed, yeah.
All right. So the first question I want to ask you, Mr. Conan, is whether the bid preparation costs that you claim in your supplemental witness statement are for this RFP alone.
They are for this RFP alone, yes.
Now, you remember when we were talking about the 2023 RFP, you were saying that there was a query in relation to town and country planning and so on and so on?
Yes.
So I'm suggesting to you, Mr. Conlon, that NH's proposal pursuant to this RFP is not materially different to the bid proposal that was submitted in response to the 2023 RFP.
It is significantly different in several ways, most of them related to shipping, costing and pricing the project. Material prices worldwide have been moving all over the place. We have to update prices every month now because nobody is holding a price more than 30 days.
And you want to say in September 2023, people were holding their prices? Nobody,
even in Trinidad nor worldwide, is giving you any more than 30 days. So
we have
to go back to the market every time that we bid.
Understandable. So, but basically that work was done in 2023 as well to submit in response to the 2023 RFP, correct?
No. Generally, what we will do is we will put out at least 3 to 5 inquiries for each element that we're looking for, and we would update and send them all out again to make sure that we have up-to-date prices, but also on logistics, which is a real challenge right now.
Good. So you've already identified your suppliers and you're simply sending an updated inquiry as to costs, correct?
No, we would usually engage with additional suppliers to see if we can get better costs, which we could then pass on to the client.
Okay, so I'm suggesting to you, Mr. Conlon, that having regard to the 5 months earlier procurement that you were involved in, it didn't take the hours that you've identified in your witness statement to retool the 2023 proposal.
Yeah, I find the time reasonable.
You find the time reasonable.
You may not, but I do.
Well, it's a matter for the panel. But when we add up the hours that you've identified here, we get 390 hours. And if we divide that into an 8-hour day, we get 48 days of work.
2, 3, 4, with 6 people. Yes.
So you're saying that 390 hours was spent in retooling this RFP for the identical project with the identical conceptual designs and specifications, correct?
Yes. What the retender actually did for us is give us more time so we could drill down on the planning, site logistics and everything else to be able to bring a better price to the client.
Now, your RFP is the document that you have submitted to this panel in support of your claim for $127,125, correct?
Okay, yes.
You've given us 6, what do you call that, names, designations of officers.
Mm-hmm.
You haven't given us the names of the persons who worked on this project, have you?
We haven't been requested to reveal
Have you
them.
given the names, Mr. Conan?
No, we were not asked to, so no.
You would ask to. Well, I'm not on a question of who may have asked you, sir. This is your evidence in support of NH's application. You haven't produced their salary slips.
No,
You haven't produced their timesheets to show that these hours were worked on particular days by particular persons, have you?
no,
And this supplemental witness statement was produced 19 days after the application for review, not so?
yes,
Well, I'm suggesting to you, Mr. Conlon, that these rounded off hours that you put in this supplemental affidavit do not represent the accurate times taken by these unnamed individuals to do this work.
I disagree, but okay.
Did you prepare this document, Mr. Conlon, this table?
Yes, and the backup, which was attached to the updated witness report. My basis is as a quantity surveyor. It's taught me when you're putting in hourly rates, you do not put in somebody's salary. You put in the cost to employ somebody. So you have to factor in everything from pensions, holiday pay, medical benefits, car rentals, or all of the things that NIS, all the things that build up to actually employ.
Well, okay, we've seen that in the attachment to your witness statement, Mr. Conan. So without producing any documentation to support the table, other than the schedule that you have produced, this is the basis on which you expect the panel to award you $113,000 for estimation. Is that it?
Yes, but further better particulars can be forwarded if required.
Speak. Just to alert you, you have about 5 minutes left.
Yes, much obliged. I'm coming to the end. Thank you. And just on this particular document, Mr. Conlon, these are all NH employees, correct?
Yes, yes, they are.
The full-time employees of NH.
Yes.
So NH has to pay these persons, these unnamed persons, whether or not they worked on the tender. Not so?
Yes.
So
But
NH would still have had to outlay the same money on their salaries, correct?
Well, chances are they'd be working on something that may end up paying, end up bringing in a project. So,
well, you see, Mr. Conlon, we don't know. You didn't put that evidence before the panel. All we know is these are full-time employees who worked a number of hours on this particular project. But the point is that these are salaries that you have to pay them in any event. They're your employees. And we don't know. We can't speculate because you haven't put any material before us to say that there would have been something else that they were working on, correct?
they did a lot of work in pre-construction. So,
all right. Okay.
Chances are they would have been working on another project that may have been successful in the bidding process.
Okay, so chances are that's your evidence. So I'm suggesting to you, Mr. Conlon, that the sums that you've claimed for preparation of the bid are not valid sums, were not sums that were actually expended by NH. What do you say to that?
Well, on a time and cost basis, they were expended by NH.
And let me use my new language that you use. These were not costs that were incurred, to use the language of paragraph 38 of your witness statement, Mr. Conan. Sorry, of the application for review.
Absolutely, these costs were incurred.
Were incurred, all right. And the overheads that you claim as well, and in paragraph 6 of your witness statement, Mr. Conlon, those overheads would have been spent by NH whether they were working on this bid or not, correct?
Yes, if they may have been working on a successful bid, if they hadn't been working on this one.
Yes. Thank you very much, Mr. Conlon. I have no further questions for this witness, ma'am.
Thank you, Mr. Mutu, any re-examination?
No re-examination.
So, Mr. Con, Conan, you are relieved.
Okay.
You're finished with your. Oh, sorry. Let me ask my other panel members. I forgot.
Mr. Conan, at any time during, say, the technical presentation or thereafter, was NH advised by the client that your bid was non-compliant, had been rejected or disqualified?
No, at no time.
Okay.
Not as far as I remember, no. And the evaluation report suggests saying we were the third place proponent. Yeah.
Okay.
Thank you, Mr. Conan. You're
Okay.
relieved.
Thank you.
Mr. Mutu.
Yes, Chair?
This is the case for NH International.
Yes.
Thanks. So we could proceed to the speaks witnesses.
Thank you, ma'am. We would call Mr. Gurja Tiwari. We'll have to send a message to him to let him know that we're ready for him to be admitted to the room.
He's waiting in the lobby, so.
Okay, so can he be admitted, please?
Yes.
In the meantime, can I just ask if Ms. Tulsi can be relieved for a few minutes? I can proceed in her absence. She'll be back shortly.
Yes.
Thank you.
Mr. Tiwari. Mr. Tiwari, you will be sworn in. The oath will be read to you. You will indicate if you want to be sworn or approved. Mr. Tiwari, you hearing us? Mr. Tiwari. Mr. Tiwari, speak. Can you inquire whether or not Mr. Tiwari is hearing us?
I take it not. Mr. Tiwari, you're not hearing us, are you?
Are you able to communicate? You and your team able to communicate with him? Otherwise, perhaps call him to see what the issue is.
Yes, the instructing attorney is calling him now.
Thank you very much. Okay.
Hearing you. I signed out and I signed back in. Okay, well, they're on the phone. Hi.
Mr. Tiwari.
We're hearing you now, Mr. Tiwari.
Hello. Are you all hearing me?
Yes, we're hearing you. You hearing us?
Hearing anything?
Mr. Tiwari? Mr. Tiwari? He said he wasn't hearing, but he was responding.
Mr. Tiwari, are you hearing us now? Do you have your volume on your device?
I am
on
seeing
maximum?
everybody. I'm not hearing anything. I don't know if you all
Can you
hearing
check?
me.
Can you check the volume on your device that you're using, your computer or whatever it is, to make sure it's on maximum? Because we're seeing and hearing you.
Perhaps we can send a message in the chat.
Try me now.
We're always hearing you, is whether you can hear
I'm
us.
hearing you all now, yes.
Okay,
Yes,
good.
fantastic. So Mr. Tiwari,
Yes,
the
ma'am.
oath is going to be read for you to repeat, and then we will proceed with your witness. We will proceed with your evidence. Sorry.
Good afternoon, Mr. Tiwari. Do you wish to swear or affirm?
I'll affirm.
Okay, could you raise your right hand and keep it raised during the oath? Thank you. I, please state your name,
Girja Shankar Tiwari,
do solemnly, sincerely and truly affirm
sincerely and truly affirm
that the evidence I shall give to the hearing panel in this case
shall be
the truth,
the whole truth,
and nothing but the truth.
To speak. I know you could have gone, Mr. Tiwari. I know I would have led Mr. Conan, but you could proceed with Mr. Tiwari, the tenant statement.
Thank you. Mr. Tiwari, you gave a witness statement in this matter,
Yes, ma'am.
and the matters contained in that witness statement true and correct to the best of your knowledge.
Yes, ma'am.
Ma'am, I would ask for his witness statement to be taken as his evidence in chief.
Yes. Mr. Mutu, any objections?
None.
So the witness statement of Girja Tiwari, tenant is GTGT. So Mr. Tiwari, Mr. Mutu will have some questions for you now.
Yes, go ahead. I've some external noises, so I'm coming close to the computer to hear what is being said.
Yes. Mr. Mutu, your witness.
Good afternoon, Mr. Tiwari.
Afternoon, Mr. Mutu.
Can you see and hear me?
Mr.
Yes.
Mutu, before we proceed, just could you remind me how long you said you would be, you intend to be?
I think in total for both witnesses, about 2.5 hours. Per witness, I can't exactly say. It might be that depending on how the cross-examination goes, I cover more ground with Mr. Tiwari, but I don't need to pick up with the witness, with the second witness.
Sure. So we let you know when you cover the hour, so you can work accordingly.
I'm grateful. May I proceed?
Yes, please.
Thank you. Mr. Tiwari, you currently do work for UDeCOTT as a consultant, is that correct?
External consultant, yes.
Yes, okay. And you've been doing work for them for quite a number of years on and off, is that right?
That's correct, yes.
Okay. Now, you were not a member of the evaluation committee
That is
for
correct.
this year, is that correct?
Yes.
Yes. Have you ever served on an evaluation committee before?
Yes. For UDeCOTT, yes.
Okay. Now, your qualification is as a quantity surveyor. Am I right about that?
Yes, that is correct.
Right. Now, I'm going to be taking you to various aspects of your witness statement and some of the documents in this case. Do you have available to you what is NH's application for review?
Yes.
And there are a number of annexures. You have that electronically or you have it in hard copy?
I have the witness statement, not the annexures.
Sorry, not the witness statement. There's an application.
Sorry, the application. I have the application, but not the annexures.
I see. So, to the extent that I'm going to take you to various documents, do you have any documentation in front of you that pertains to these proceedings that contains the annexures?
No, I don't.
Mr. Mutu, if you point us to the particular pages, we can try to have it up on the screen.
Yes. I thought the witness would have been provided with it so that it could have made things a bit faster, but we'll see how we manage. Now, you are familiar with UDeCOTT's RFP for this process. That's correct, isn't it?
Yes.
All right. And you are aware that NH's bid was not rejected by UDeCOTT. Isn't that right?
I wasn't aware previously.
Yes.
I'm aware now.
Yes, so you are aware. And you are aware under the terms of the RFP, UDeCOTT would have been entitled to reject a bid if its evaluation committee formed the view that the proposal did not respond to material respects of the RFP.
Yes.
Yes, okay. Now, I want to take you directly to the cost or the evaluation criteria. Now, that is set out at page 14 of the documentation annexed to NH's application for review.
Yes, I have it in front of me.
Okay. Right. Now, on this project, bids were to be scored by UDeCOTT out of a maximum of 100 possible points. Is that correct?
Yes.
And UDeCOTT in its RFP identified 5 scoring criteria, correct?
Yes. Yes.
And it allocated different points to each criterion.
Correct.
Yes. And to the criterion of cost, it allocated 30 points.
Correct.
Now, NH obtained the maximum 30 points under this criterion of cost, correct?
I know that now, yes.
Yes. Well, everything I'm asking you is what you know now. If I'm asking what you know at a prior time, you will I will let you know. Now, NH's bid was for approximately $147,600,000, VAT exclusive. You accept that?
Yes.
And FIDES, who UDeCOTT has now ranked at the top bidder and is considering entering into a contract with, was also awarded a maximum of 30 points. You accept that?
Yes.
Yes. And FIDES's bid was $163,404,000, approximately, VAT exclusive.
Yes.
And that is approximately $15.8 million more expensive than NH's bid.
Yes.
Right. And insofar as the application of this cost criteria is concerned, which will come to in a moment, do you accept that under 4.3.1, and then we can turn it up if you want. Let me help you. It's at page 13 of the RFP. 4.3.1.
Page 13 of the RFP of the.
Well, it's yes, page 13 of the RFP.
I don't have the RFP in front of me right now.
Would you like us to have it on the screen?
Go ahead and ask me the question, that's fine.
Right, okay. If the witness needs assistance from the document, I'll take him to. But do you accept that UDeCOTT faithfully represented that each proposal would be evaluated against a predetermined criteria and point system, which we just referred to?
Yes.
Yes. And similarly, that the evaluation committee will carry out their evaluation of the proposals on the basis of responsiveness to the RFP, applying the evaluation criteria and the point system set out in it.
Yes.
Yes. Now, under the proposal cost, the words are cost in comparison to internal estimate. Do you accept that that is the only methodology identified in the RFP for evaluating bids. On the item of cost.
The answer to that question is yes.
Good. Now, UDeCOTT awarded the points to NH and FIDES by using a method in which it compared their respective bids to UDeCOTT's internal estimate. Isn't that right? Good. Now, as far as you are aware, that internal estimate has not been disclosed in these proceedings. Am I right about that? To the best of your knowledge.
You're putting me in a difficult position. I know the estimate, but I don't know if it was disclosed in these proceedings or not.
Okay, so you are unaware. Are you aware whether UDeCOTT disclosed that estimate, internal estimate, to any of its bidders?
I'm not aware that they did that.
Okay. And all that this criterion of cost is saying is that UDeCOTT will undertake a comparison of a bid from a proponent as against that undisclosed internal estimate. Correct?
Yes, correct.
Now, UDeCOTT in this case compared its internal estimate. I'm going to take two different scenarios, right? So the first one is insofar as bidders who exceed the internal cost estimate are concerned, right? Let's deal with that category first. UDeCOTT in that case scored bidders out of 30 points in a manner proportionate to how much higher their bid price was over the internal estimate.
Correct.
Do you accept that? Yes.
Yeah.
And therefore, every bidder who scored above the internal estimate, if their bids were different, received a different score.
Correct.
Yes. And in this case, none of the bidders over the internal estimate had the same bid.
As far as I am aware.
Yes. But when you say as far as you're aware, you came here today to give evidence in these proceedings as a quantity surveyor, correct?
Yes.
You've made certain comments about the various bids and the proposals and how the tenders committee evaluated those bids. It is therefore reasonable to expect that you familiarize yourself with the bids. Have you?
Yes, I am.
Okay, good, because that's the premise I'm proceeding on. So we cover the first category for those bidders who exceed the internal estimate. Now, for bidders that were equivalent to or lower than UDeCOTT's internal cost estimate, but not abnormally low, UDeCOTT automatically awarded such bidders a maximum of 30 points. Isn't that right?
Correct, yes.
There was therefore, I'm suggesting to you, that there was therefore a different method of scoring for bidders who went over the estimate than those who scored below the estimate.
That is not correct.
Okay, let me take you through it. We just went through the evidence of the two different categories, correct?
Yes.
And you accepted that bidders who scored above the internal estimate were awarded points based on their prices and those prices being computed relative to the internal estimate.
Correct.
And we also got from you that those bidders therefore all got different prices, all got different scores allocated.
Correct.
And that is because for scoring purposes, each bidder was considered and awarded points on the basis of the actual dollar value of their bid.
Relative to the internal estimate.
Relative to the internal estimate.
Correct.
But when we come to bidders who hit the internal estimate or who were below the estimate, there was no question of a differential in scoring. Isn't that right? They all got 30 points.
Not entirely correct, no.
Fides got, okay, let's look at a concrete example.
Yeah.
Fides got 30 points.
Yes.
NH got 30 points.
Yes.
There's approximately a $16 million difference between both of them.
Yes.
But yet, they are both scored equally. Correct?
They both got the maximum marks of 30 points.
Right. They both got the maximum marks of 30 points. Let's flip it now. If Fides came above the estimate.
Yes.
Right? And NH came above the estimate.
Yes.
But Fides was $16 million.
Yes.
More than NH above the estimate.
Yes.
Fides would have gotten less points.
Than NH, yes.
Than NH, yes. And therefore, I'm suggesting to you that clearly illustrates that when UDeCOTT was applying its scoring criteria, it had a different methodology for dealing with people who were above the estimate and for dealing with people who were below the estimate.
That is not correct.
Okay. Would you agree with me that there is nothing in the published scoring methodology at item 5 that speaks about the bids being treated in that manner for bidders who were equal to or less than the estimate? In the methodology.
I can't answer your question.
Okay, well, pull it up. Let's pull it up.
No. The question as asked cannot be answered.
Okay, well, let me try and reformulate it. I am saying to you, it's a straightforward question, Mr. Tiwari, that when one reads item 5 of the evaluation criteria, you will see nothing published there about a methodology that says bidders who attain the value of the internal estimate or less than will be awarded maximum points. Is that anywhere?
No, that's not stated explicitly.
Right. Okay, you're saying it's stated implicitly?
Yes.
Okay. In the RFP?
In the evaluation of the tenders, yes.
No. In the criteria. I'm talking about the criteria.
Yes, I'm saying yes. It's implicit.
Okay. So it is implicit in this table, and you're asking the hearing panel to find that implicit on page 14 of this table.
I'm saying to the panel, I can explain why.
No, we can get the explanation after.
Yeah. I'm
asking you, you are saying to the panel on a reading of this, it is implicit in this criteria. Is that what you're asking the panel to accept?
Rather than implicit, I'm saying it's not irrational. No,
we're not talking about what is irrational or not, Mr. Tiwari. We are talking about published criteria. So are you now accepting rationality on one side? Are you now accepting that it is not published?
No, I'm not accepting it's not published, no.
Okay, good. So it is published?
The criteria cost in comparison to internal estimate is the premise on which tenders are evaluated.
Mr. Tiwari, let's try and help the tribunal, please. Sure. And we'll get along much quicker. I'm respectfully suggesting to you, as a matter of English, that the way in which tenderers or bidders who achieve scores equivalent to the estimate or below the estimate does not appear, a maximum of 30 points does not appear on this.
And I'm saying no, that's not correct.
Okay, fine. I'm equally suggesting to you, nor is there published in this criteria any methodology that suggests or tells bidders that if they attain a bid price which is in excess of the internal estimate, they would be scored in a manner proportionate to how much higher their bid price was over the internal estimate.
I need you to repeat that for me, please.
Okay. That there's nothing in the published criteria that tells bidders that if their bid exceeds the internal estimate, they will be scored out of the maximum score of 30 in a manner proportionate to how much higher their bid price was over the internal estimate. Do you accept that?
Yes.
Okay, good. Now I want to put a hypothetical situation to you, right? Because we need to understand how this methodology works. And the purpose of the hypothetical situation is precisely that. Let us take, for example, a situation where all bidders score, or some bidders score the same on every criteria, the aggregate. They attain aggregate marks which are the same on all criteria except for criteria 5. Right? Are you following me? So for example, let's just say we had NH and, by way of example, we had NH and finance. And of the 4 criteria, they both ended up with 70 points on the 4. Okay? Let's take that example. And even if the aggregate of 70 points was as a result of, well, let's not take 70 because 70 is maximum score. Let's say 60, right? But for each category, their scores were different. But when you aggregate them, they end up with 60. Are you following me so far?
Yes.
Right. Then the only item left for the evaluation committee to consider is cost, right? Out of 30 points. I'm suggesting to you.
I don't agree with that, but go ahead.
You don't agree
I don't agree that you can disaggregate the technical from the cost. It's one evaluation, including technical and cost. So you have to come up with a total at the end of the day. So if they come up with, if they both end up with 95 marks at the end of the day, including the cost.
Yeah, Mr. Tiwari, you can explain whatever you want to explain after, but I don't think it's relevant to what I'm talking about.
Sorry.
I am not, let me be clear to you. I am not talking about a 2-envelope type system. That's not where I'm going. We are operating out of a maximum score of 100. Yes. And there are 5 criteria to be satisfied. We agreed on that. And I'm postulating to you an example where 2 bidders both get 60 marks on the 4 criteria. And however they get the 60 might be different, but in any event, they are there. The only remaining criteria to consider is cost. And therefore, the marks of cost ultimately are going to determine who scores the highest.
That is correct.
Good. And I'm suggesting to you that if UDeCOTT has a system where once you get the amount of the internal estimate or lower, even if the differential, as in the case here, is $16 million, both bidders get 30 points. that could never result in a situation which promotes an objective of value for money.
I don't agree with the last statement.
Okay, fine. You have had a chance to look at the witness statement of Mr. Conan.
Mr. Conan? Yes.
Yeah. Okay, good. You have it with you?
Yes, I have it.
Right. Could I ask you to have a look at paragraph 43?
Is it the supplemental statement or the?
No, is his principal witness statement, paragraph 43.
No, I don't have the original witness statement, but go ahead and ask me.
Okay. Before I get to that, let me close off on this. Right? I want to suggest to you one other thing. We had established, I believe, that bids who scored above the estimate was scored on a relative basis and got points on a relative basis, right? And those who scored below or equivalent to got a maximum points. Yes, we established that.
Well, the reality is they got the maximum points, but I don't distinguish between above the estimate and below the estimate. They both were scored on the same basis.
I understand that. What I am suggesting to you is if the same methodology of relativity was applied, that was applied above the estimate. If that same methodology was applied below the estimate, for people who hit the estimate or got below, fighters would have got less points than NH on the criteria.
No, that is not correct.
Right, okay. You understand that what I am putting to you is essentially a mathematical computation.
Very much so.
Right, okay. Now, you have confirmed that you've seen the witness statement of Mr. Conan, right? Now, as I understand your evidence, you say that a system involving design build, where the criterion of cost is evaluated on the basis of relative bids of bidders, with the lowest bidder being essentially the awarded full marks. You say that that is not a system that promotes value for money. Am I right in understanding your evidence that way?
Not necessarily. Okay. Providing best value for money.
So it can provide best value for money.
Overall.
Right.
You have to, in the overall scheme of things, it may.
Okay. Now you have seen annexed to Mr. Conlon's witness statements a number of tenders, RFPs, by a variety of state enterprises in which they use the formula that I have referred to, correct?
I know formulas have been applied elsewhere, yes.
Okay, well, Pass, let me just take you to it. Right, there is a NIPDEC issued a RFP for the meteorological services building on a design build basis in August 2024. Are you familiar with that?
No.
Okay. Can I ask that the witness be taken to electronic bundle, page 225.
Just give us a few minutes, Mr. Mutu.
Yes. Are you seeing it, Mr. Tiwari?
No, I'm not seeing it. I'm seeing CM.
We have this here.
That appears to be the
Mr.
same
Mutu,
problem.
if you wish to go ahead and read it for me, I'll be able to respond.
All right. Okay. So what I was referring you to was the cover page that identifies that it's a document issued by NIPDEC, request for proposals to provide design build services for the new meteorological services building at Piaco on behalf of the Ministry of Public Utilities. Madam Chair, I think this is going to prove somewhat.
Mr. Mutu, you can go ahead and read the relative section you want me to look at and I'll respond.
Right.
Mr. Tiwari. Mr. Mutu, you were saying?
I was saying I'm beginning to wonder whether this is going to provide some challenges. The normal expectation, and I'm not putting blame at anyone's feet. The normal expectation would have been that the witness would have had a bundle of documents whereby he could assist the tribunal for the purposes of cross-examination. He doesn't have that, and I'm trying to understand how best we can assist you in the absence of that. Is it possible for perhaps UDeCOTT to email to him an electronic bundle? I don't know if Mrs. P can assist in that regard.
Mr. Mutu, before we proceed, when you got the difficulty earlier, what did you do to be able to see what was on our screen?
I haven't been able to alleviate the problem.
So you still don't see?
Yes, I still don't see. I'm working off of electronic and hard documents here.
Yes. Ms. P, would it be possible to get a copy of the bundle to your witness?
Well, can Mr. Mutu identify what it is he's referring to? We're now looking at Mr. Conan's witness statement. Is there anything else you would like to have emailed to him?
Yes, it would be very helpful if he had NH's Form 8 with the various annexures.
All right, so we'll make arrangements for the instructing attorney to email to Mr. Tiwari, who is not at the NH location, sorry, not at the UDeCOTT location, those two documents, the application for review with the annexures and Mr. Conlan's witness statement with the annexures.
Can you also send along the supplemental statement so it's complete as well?
Yes, and it's
statement.
Yes,
Thank
I think.
Oh, he said he had this.
I'm grateful. Thank you. Okay, I'll see what I can do in the meantime to move along. So, Mr. Tiwari, you've asked me to read out what the RFP has in it. But essentially, the part that I'm interested in is under item F on page 260, which essentially sets out a cost proposal formula. And it says that the cost proposal shall be assessed utilizing the formula CA over CP by 20, where 20 is the maximum amount of marks. And it says CA is the lowest responsive tender sum, in brackets, combined cost for design, services, and construction works, close brackets, associated with the proposal that pass all criteria, and CP is the proponent's corrected tender sum. Now, is that a formula that you are familiar with?
Yes.
Okay. And would you agree with me that that is a formula that is widely used for determining and allocating points in design build contracts in Trinidad and Tobago?
Design bill or design bid bill?
Design build.
Design bill. It is used. I don't know how widely, but it is used.
Okay. So you would not be surprised if I were to suggest to you that it was used by HDC. Would you?
No.
Would it? Right.
No.
On the Thomas Trace housing development. No, it wouldn't, would it?
Sorry?
It would not surprise you.
No, it doesn't surprise me.
Right. Nor would it surprise you that it was used by NIPDEC for the design build project for the new ARIMA licensing office.
Again, no.
Right. Now, coming back to the question of internal tender estimates.
Just to clarify, you are reading from the RFP, what they sent out to the contractors. So contractors knew what formula they were going to use.
Yes, yes, yes.
Okay, sure.
Yes.
Go ahead.
I'm happy to give you the page references for the.
No, that's fine. I mean, I don't need to go there.
Right. Okay. Thank you.
Mr. Tiwari, are you able to check to see if you got the email?
No, all I'm seeing is CM on the screen.
No, are you able to check to see if you got the email from Ms. P?
The emails, yes, I can check.
This is me
Yes, I
assuming
got
it
an
was
email from
sent.
Carla Williams.
Yes. Mr. Mutu, would you want to direct the witness?
I'm happy to move to another aspect of the cross-examination on cost, given that he's accepted that it is a formula that is used.
I'm not getting into downloads. So.
Oh, no. Mr. Tiwari, we're going to move on from that.
That's fine with me. I'm quite happy to move on, yes.
Mr. Mutu, you proceed.
I'd like you all to take down the CM though, so I can see the participants on a larger scale, yes.
Yes, Mr. Tiwari. Now, I want to deal with the question as to the use that internal tender estimates are traditionally used for. Okay. Will you accept that internal tender estimates are often used, or let me phrase it this way, primarily used for the purpose of determining whether bids are abnormally low or abnormally high?
No, I don't agree with that.
Okay. Do you accept that they are used for that purpose at all?
Well, it is used for that purpose, yes.
Yes, okay. And for example, using the same formula that I referred you to, that dealt with the relativity of bids against a maximum score, using the lowest bidder as the highest scorer. In that type of situation, an internal estimate would be useful to weed out bids that are abnormally low or abnormally high.
There is I cannot accurately respond to your question for the reason that there are other factors in evaluating a bid other than the bottom line.
No, I am not on the other factors. What I am saying to you is on a question of cost. when an employer is going out into the marketplace for a bid for a project, won't an employer want to know whether the bids which are coming in are remotely close to a cost at which the project can be built for?
Yes.
All right. And in fact, that is prudent.
Yes.
Yes. And that if one has an internal estimate, then one uses it as a benchmark against which you can determine whether bid X or bid Y is abnormally low or abnormally high. Can't they?
They can, yes.
Yes, as against cost. Now, when a party is bidding as against an undisclosed internal estimate, that party is necessarily guessing the target that they have to meet. Not so?
No.
Okay, well, let's look at that by way of example. On this bid, we have established that the internal estimate was not disclosed to bidders.
That is correct.
And if the methodology that UDeCOTT is using is a comparison to the internal estimate, based on what is published, then a bidder is going to, or should, in order to try and achieve maximum points, formulate its bid as closest to the internal estimate as possible to get maximum points. You accept that?
No.
You don't accept that?
No.
So even though a RFP is telling you we are going to be comparing the bids against our internal estimate, and that is the basis on which you are going to be scored, is a bidder is not going to be concerned with trying to hit that target to get maximum points.
No, not necessarily, no.
Okay, good. So if a bidder, well, do you accept that the bidder, is it your evidence that the bidder is to play no regard or should not be bothered by the internal estimate for the procuring entity?
That is correct, yes.
Well, so I'm hearing a phone ringing in the background.
That's my office phone ringing. Somebody else will answer it.
Yes. I am suggesting to you that a evaluation criteria designed in this way encourages bidders, in order to achieve maximum points, to try and hit UDeCOTT's internal estimate.
That is not correct.
I'm also suggesting to you that a scoring system which operates in that way is one which does not promote value for money.
That is absolutely incorrect.
And I'm suggesting to you that why that is so is because the bidders are not concerned with a scoring system designed this way. They are not concerned, in order to win the bid, with producing their lowest bid price, but are in fact concerned with hitting the undisclosed target price, which is the internal estimate.
That is not correct.
I'm also suggesting to you that a scoring system designed in this way is unfair to bidders because they don't know what target they have to aim at if the internal estimate is not disclosed.
That is not correct.
May I have one moment? Okay, I'm going to move to another area with you, Mr. Tiwari. As I read your witness statement, you make a few remarks about planning approval for this project and in the context of NH's bid. Am I right?
Correct, yes.
Now, correct me if I'm wrong, but one of the arguments you make is that NH's design did not conform with the outline planning permission given by Town and Country. Is that right?
Yes.
Now, NH's height for their bid for the building was 38.4 meters, correct?
I accept that. I'm not sure, but yes.
Okay, well, it's at page 748 of NH's, the attachments to NH's Form 8. Just mentioned for the record, but you accept it. Yes?
Yes, I have no reason to dispute it.
Right. Now, the outline approval for this project, that is something you're familiar with?
Yes.
Now, that outline approval, which is to be found at page 327 of the annexures to NH's Form 8. That fixes a maximum height of 27 meters from ground level to the ridge of the roof. You accept that?
Yes.
So 27 meters is the upper limit granted by Town and Country.
Yes.
Yes. But UDeCOTT's conceptual design had an overall height of 34.125 meters. You accept that?
No reason to dispute it, but go ahead.
Right. And it had an office level height of 29.475 meters. You
Again, I have no reason to dispute it.
Mr. Tiwari, you came here today and you gave a witness statement where you spoke about planning approval and all of these things and NH's non-compliance. My expectation is that you would have familiarized yourself with these documents in order to help the tribunal. Did you?
The difficulty I am having is what purpose does the indicative design serve in an RFP?
No,
it's not telling you build that. It's telling you this what.
Please, Mr. Tiwari, just answer my questions. We're getting along well.
Yeah.
Right? Did you familiarize yourself with the documents before you came here today? Right. Did you familiarize yourself with the documents when you were preparing your witness statement?
Yes.
Yes. The witness statement is a product of your work?
Yes.
Yes. Okay, good. So, are you in a position to agree that the office level height of UDeCOTT's conceptual design was 29.475 meters?
No.
Okay. I would like to show you a document. Do you have any documents in your...
For the RFP, no.
But it's annexed to, I'm reminded that it's annexed to your witness statement.
Yeah, but you see, if you will allow me to tell you how I calculated my figures, I'll tell you.
Oh, no, I'm not.
This is the reason why I can't say I agree with your figure.
Mr. Tiwari, okay. Do you have your witness statement?
Yes.
Do you have the exhibits to your witness statement?
No, I don't have the exhibits, but I know the exhibits. The RFP was one of the exhibits, yes.
Right.
So Mutu, would you like us to project a particular part of the witness statement?
The difficulty is...
Yeah, but we can't see, right?
Yes.
Mr. Tiwari, are you using a phone?
No, I'm on a laptop.
Oh. Are you still not able to open any of the attachments from the emails you got?
I always have a difficulty downloading large files on my computer, especially drop files and these things, they never download. I usually get my files on a flash drive and bring it to my computer. So it is always going to be difficult for me to get large files. Small files, yes, but large files, no.
You see, the difficulty is that if the witness can't really subject himself to a proper cross-examination, it means that his evidence is valueless, ultimately. and because it can't be tested. So I don't know what UDeCOTT can do to assist Mr. Tiwari with getting the appropriate exhibits. It can't be that the inquiry on behalf of NH is frustrated because of UDeCOTT's own failure to make the arrangements with him. Or a failure, I'll be finished in a moment. Or failure on his part to have a facility to see what is put up on a screen. Because it's both elements that have frustrated the process.
Well, can I just respond to that? It is usual, and I know my learned friend is well familiar with this, that the usual practice for a witness is to just have his witness statement in front of him and not other documents. But I'm wondering whether Mr. Mutu's team can put up the document on his screen to see whether Mr. Tiwari is able to get it. He is at a different location, and we really want to get on with the proceedings. So it's usual if I am cross-examining that I will take steps to put up a document. Let's see if he's able to read it, if Mr. Mutu puts it up rather than the panel secretary. Are you able to assist us?
I think the problem with that, Mr. Speaker, is that Mr. Tiwari is having a difficulty where he can't see any documents put up on a screen. So that is that is a challenge.
I know, but I think the difficulty he's had is with the panel secretary putting it up. Can we try to see if you're able to put it up, if he's able to see it? If not, we'll have to try to make some arrangements to maybe have the hard copy sent to him.
Mr. Mutu, perhaps that's a good suggestion. You can try, if you are able, to share the relevant documents.
We'll see if we can do anything here, but just in the interest of time, in terms of Mr. Tiwari's availability to get a hard copy, what's his proximity to the instructing attorney for UDeCOTT?
2 blocks away.
Oh, he's only 2 blocks away. So that would be quite helpful. Perhaps I can move along and to see whether that can be accommodated in the meantime.
Yes. Well, you have just about 10 minutes left of the 1 hour. So I know it's an hour and a half, but I told you I'll indicate when you have gotten to an hour mark. And we still have Mr. Chanona left to cross-examine if he wants to cross-examine Mr. Tiwari.
Sorry, okay. I said 2.5 hours.
No, I know, but I told you I'll let you know when you got to an hour because you're not sure as to how you'll distribute the time with the witnesses.
Well, I'm grateful, but I could not have anticipated. I'm still going to try and keep within that time frame. But I could not have anticipated that a witness would come and not have access to documents. But I will move along and try and best assist the panel as I can. Right?
So whilst we move along, Ms. Speaker, are you making arrangements? Is your team making arrangements to get the hard copy across to Mr. Tiwari?
That is my understanding, ma'am.
Thank you, please. Mr. Mutu, you may proceed.
Thank you. I was suggesting to you, Mr. Tiwari, that both UDeCOTT's conceptual design and its office level height, both of those heights exceeded the outline permission for town and country of 27 meters.
I think that is correct, yes.
Yes, okay. So these were the documents from what you can see. UDeCOTT had in its possession at the time it went out to tender. Yes? The planning approval. Good. So it stands to reason that at the time it went out for to tender, it knew full well that it did not have outline permission for what it was asking contractors to bid on.
No, I don't agree with that.
Right. You understand the dimensions that I just indicated to you, yes?
Yes.
Right. And it is, you accept that Town and Country's planning approval is unambiguous in its language?
Yes.
Good. And notwithstanding that, you maintain that UDeCOTT could not have known that when it went out asking to inviting bids, at that point in time, it must have known that it didn't have approval for what it was asking people to bid on?
That is not correct.
Okay, I'll move on. The planning permission
was.
Can I just ask for Mr. Heffersdoon to be excused from the room for a few moments, please?
Sure.
Much obliged.
I lost voice. Your mic is muted, Mr. Mutu.
The planning permission was valid for 1 year from the date of its issue, correct?
Yes.
Right. And I'm suggesting to you that the date of its issue was the 15th of August, 2023.
Correct.
Accept that?
Yes.
Yes. What we do know from the papers in these proceedings is that by the 16th of January 2025, UDeCOTT notified Kee Chanona that it intended to award the contract to Fidesz Limited. You familiar with that?
Yes.
Good. And that was 1 year well after the expiry. That was 1 year well after the expiry of the period stipulated for the validity of the planning permission. Correct?
Correct.
And therefore, it is fair to say, would you not agree, that UDeCOTT was nonetheless prepared to pursue entering into contracts with entities for the project where it knew that the planning permission which it had from Town and Country had lapsed at that time?
You need to repeat the question.
It is fair to say that when UDeCOTT notified Kee Chanona of its intention to enter into a contract with Fidesz in 2025, it knew full well that its planning approval for the project had lapsed.
I cannot agree with that statement wholeheartedly. No.
Okay. It knew, let me see if I can reformulate the question. It knew that it did not have Town and Country planning approval in place.
I cannot agree with that statement wholeheartedly. No.
Right. Have you seen a document from Town and Country planning approval indicating that there was in place a valid approval as at the 16th of January 2025?
No, I have not seen any such document.
Good.
Ma'am, I'm objecting to this line of questioning on the same ground that my learned friend objected when I was seeking to ask questions. This does not form part of the grounds of challenge of NH. And my learned friend, I didn't want to interrupt him, but he was in error when he said the planning permission had expired more than a year ago. The date was August 2023 to August 2024. But my objection is this has nothing to do with the grounds of challenge which we've identified as being cost, human resources, and debt liquidity ratio. That's my objection.
Thank you, Mr. Mutu?
Yes, can I respond to that this way?
Yes, Mr. Tiwari, we will ask that you log off of the...
So I'm going to leave the meeting, right?
Yes. And we'll let you know when to rejoin.
May I respond?
Yes.
All right. There are essentially two responses. The first is that this is an issue on which Mrs. Peak cross-examined extensively the witness for NH. The second is that the subject matter of Town and Country planning approval relates directly to the question of relief in this case. Because what UDeCOTT has done by its evidence, and Mr. Tiwari is the key proponent for this, is put forward a case that NH effectively should not get this bid because its project as formulated does not meet Town and Country requirements. So to the extent that NH is asking for relief, which it does ask for in its bid, it asks for alternative relief, and it is asking for a reevaluation of the bid. that evidence adduced by UDeCOTT is aimed, as far as we see it, directly at that. And we are entitled to answer that. If the claim is NH should not be reconsidered and the panel should make no order directing a reconsideration of the bid because of this town and country planning approval situation, we must be entitled to demonstrate that it was not a material matter for UDeCOTT in relation to its bid process. And that is the context in which we seek to deal with this evidence.
Speak.
First of all, my cross-examination of the witness had nothing to do with any relief that is being claimed about re-evaluation. And the relevant time for determining that was at the date of the bid. That was the date that was relevant when the town and country planning approval was still, the 1 year period was still in existence. So I don't understand how, because my learned friend has asked for certain relief re-evaluation, and I did not touch on and ask any question about the duration of the town and country planning permission because it was not relevant, because at the time when NH's bid was submitted, Mr. Conan accepted that that was the applicable condition. So in our respectful submission, nothing in the application for review raises any issue about FIDES or anybody else in 2025 relating to town and country planning. And that's the very simple. I mean, we can go through the application for review. We have the grounds set out at paragraph 22 to 32 to 35 helpfully, and there's nothing in there that deals with that.
So we would tend to agree with Mr. Mutu. Ms. Peak, you would have cross-examined extensively on the town country approval, the 7th story versus the 9th story. And from your cross-examination, it appeared to be important to UDeCOTT. In light of that, we see it as a relevant issue to assist the panel in its determination of the matters, including the relief sought by NH International in these proceedings.
Much obliged.
So, Ms. Peak, your witness, would you be able to get him back?
Yes, we're making contact with him now, ma'am.
Yes. While we wait on the witness, Mr. Chanona, after Mr. Mutu finishes his cross-examination, you'll be allowed to cross-examine Mr. Tiwari.
Okay.
So you can probably think about how long you would require as well to give us an idea when we get to you.
Okay.
Thank you. Mr. Mutu, before we proceed, perhaps you should tell Ms. Peak, your friend, what other documents you require the witnesses to have. The second witness, sorry, one time.
Yes, I'm grateful for that. Essentially, it will be the same documents. It will be what is annexed to Form 8, the exhibits, together with the witness statement of Mr. Conan.
Yes. Perhaps we can make arrangements, Ms. Peak, can make arrangements to have those documents available to our witness before she comes onto the stand.
Well, we will do so, ma'am, but it may be the very same documents that were sent to Mr. Tiwari, but we'll do our best.
Yes. Understood. Perhaps you can get an email to her because she may not have the same email issue as Mr. Tiwari. Right, Mr. Tiwari.
Hi.
Mr. Mutu is going to continue with his first examination. Mr. Mutu?
Thank you, Madam Chair. Yes, Mr. Tiwari, you were involved in the first bid iteration for this project, correct?
Yes.
Right. And you told us you have seen Mr. Conan's witness statement, correct?
Yes.
Are you aware that NH wrote to the Town and Country Planning Division in connection for the first RFP for the project which took place in September 2023?
No, I'm not aware of that.
You did not see an email dealing with that issue annexed to Mr. Conlon's witness statement?
No, I did not review that.
I see. Have the documents reached you as yet? The hard copy of the document?
No, not as yet.
I see.
But I would suggest you go ahead and ask me the question based on whatever it is, I'll answer.
Well, I'm very grateful for the suggestion, Mr. Tiwari, but I will conduct my cross-examination in the way that I would like to. So I'm going to come back to that, and that is Exhibit CC8 to Mr. Conlon's witness statement. Would you not agree with me that seeking to raise now, UDeCOTT seeking to raise now, an issue of NH exceeding the height, maximum height fixed by Town and Country in the approval of August 2023, that seeking to raise that now is wholly disingenuous? As an obstacle.
Are they raising it in what capacity?
Well, raising it as an obstacle to NH being awarded a contract.
But I'm not aware that is being raised, but
Okay, let me ask you another question. Would you not agree that in the context of these challenge proceedings, raising that is virtually irrelevant because UDeCOTT itself was not having regard to the Town and Country requirements for the project?
No, I'm not agreeing with that. I can't agree with that.
Okay. I want to turn to the question of acoustic treatment. Well, again, Madam Chair, I'm hamstrung here because I need to go to the documents. I'll go on to one other area, but apart from that, unless Mr. Tiwari has the documents, I'm going to be in a difficult position. We've established, Mr. Tiwari, that this project is a design-build project, not so?
Yes.
And for projects of that nature, bidders are expected to come up with their own designs. You say so in your witness statement, yes. And if awarded a contract, the bidder is expected to take legal responsibility for its design.
Correct.
And to ensure that the design is buildable.
Correct.
And there is an expectation that bidders will come up with different designs. You say that in the witness statement, don't you?
Yes, that's correct. Yes.
Yes. Now, in the present project, the auditorium was a significant part of the design brief, correct?
Correct.
Yes. And the conceptual design located the auditorium in the center of the building.
Correct.
But Kee Chanona itself submitted a design which relocated the auditorium to the southern side of the building.
Correct.
Isn't that right? You are not critical of them for failing to adhere to the conceptual design, are you?
No.
Right. Even though that was a material deviation.
No, I don't agree that's a material deviation.
Well, we just covered that ground, Mr. Tiwari. But you are critical of NH for what you say is a failure to follow the conceptual design. Yes?
Correct. Yes.
Are you aware whether NH told UDeCOTT that the conceptual design provided by UDeCOTT's own internal architect was not constructible?
I know that NH said that, yes.
Right. And would you accept that given the Town and Country approvals which were in hand at the time that the project went out to tender, that design was not even constructible based on the approvals which existed then?
Yes.
Yes. So therefore, that being the case, when the project went out to tender, conceptual design must necessarily have been an item which would have had to have been subject to a fair degree of flexibility.
Repeat for me, please.
When the project went out to tender, the notion of conceptual design, right? Well, not the notion, the actual conceptual design, it being a height of 34 meters, and approval being 27 meters in height. The conceptual design must necessarily have had to have been an idea which would have been subject to some degree, a high degree of flexibility.
A degree of flexibility, not high.
Yes. But in any event, even if NH was unhappy with UDeCOTT's design, sorry, if UDeCOTT was not entirely happy with NH's design, forgive me, that is a matter which could have been the subject of negotiation if NH emerged as a top-ranked tenderer. Would you agree with that?
If they were the top-ranked tenderer,
yes. Yes. So that what the negotiation process envisaged is that you could negotiate cost. Yes?
Correct.
You could negotiate design.
Correct.
And all of those things were therefore subject to negotiation with the tenderer who scored the highest.
With the top-ranked tenderer, yes.
Yes. So in principle, if NH had scored as a top-ranked tenderer and was not disqualified, which we know to be the case, UDeCOTT could have entered into a negotiation with NH about NH's design, in principle.
They could enter into negotiations with the top-ranked tenderer, whoever that was.
Yes, and therefore, if NH emerged as the top-ranked tenderer, it could sit in a room with UDeCOTT and negotiate design, not so? Correct,
yes.
Yes. Might I make an inquiry through you, Madam Chair, as to whether Mr. Tiwari is now in possession of the hard copies?
Tiwari?
1 minute.
Until a flash drive was being sent to him. I don't know whether it has reached.
Mr. Tiwari, do you need to exit the room to inquire, or you can do so from where you are? Mr. Mutu, the other option perhaps is that, yeah, sorry.
Sorry, I wasn't listening.
No, I was asking if you need to exit the room to inquire. Are you able to inquire from where you are if the flash drive was delivered to you?
They called me a few minutes ago and said they will come in. I just sent my secretary downstairs to wait for them so she could bring it up for me. They may not know exactly where my office is.
Sure. Okay, thank you. Mr. Mutu.
But they're on the way here. UDeCOTT is on the way here.
Yes. Thank you. Mr. Mutu, I was about to suggest that perhaps you could reserve the rest of your cross and we could go on to Mr. Chanona. Mr. Chanona's cross of Mr. Tiwari.
Yes, I think that would be a productive use of time. Thank you.
Thank you. So at this stage, you'd like to reserve and then we move on?
Yes, Madam Chair. Thank you.
Right. So Mr. Chanona,
yes,
you're entitled to cross-examine Mr. Tiwari.
I have no questions to Mr. Tiwari.
Oh, you have no questions to Mr. Tiwari. Okay. Let me ask any of the panel members in the meanwhile.
Yeah, I may.
Yes.
Mr. Tiwari, clarification. Your services to UDeCOTT were to give a cost estimate.
Yes.
Did it also include proposing the methodology by which that item would be evaluated?
My cost estimate?
No, did it also include giving advice to you were not on the evaluation team?
No,
right? But in terms, okay, did you have any input into the methodology of the evaluation of the costs against the internal estimate?
Well, I have knowledge of the formula that was used to calculate the marks for the cost.
Okay, the other thing was in terms of, with reference now to Kee Chanona's bid. Oh, sorry, in terms of the bids, did you evaluate the cost estimates?
Yes.
Okay. Did you also evaluate the revised negotiated bid, the revised bid of Kee Chanona?
No, not the second, not the bid submitted pursuant to the negotiations, no.
Okay. And if you could, I'm having difficulty in understanding what you understand as value for money in this context, because you've referred many times to saying you didn't agree that the method would give value for money, the proposed method of it. So how do you see, how would you evaluate value for money?
Okay, so
against?
There are two things. Would you like me to explain how the points were calculated for the cost in terms of the tender?
No, I think Mr. Mutu went through that.
You want me to go specifically to evaluating a tender? Why would I say the lowest price does not necessarily give the best value? Is that what you're asking me?
Yes.
Okay. So there are two methods of tendering jobs. In this case, is a design bid build, and in the second, this case is a design build, and the second case is a design bid build. In a design bid build, the employer would do the design, prepare bills of quantities, and all contractors tender on that basis. So everybody is tendering apples against apples. In a design bid build, necessarily each architect will come up with a different design. So when the client gives an indicative design, it is intended to demonstrate, beside the indicative design, they also give a design brief of how many people it's supposed to occupy, how many car park spaces. Planning approval doesn't only relate to height, it relates to if so many people occupy the building, you have to provide so many car park spaces and things like that. You have to have this setback and that setback and all those other things. So in order to determine value for money, you have to see what one contractor is giving you as opposed to the other contractor. His price may be low, yes, but there may be reasons why. I'll give you one example. If you look at the air conditioning of a building, right? You can have a chill water system, which is extremely expensive, or you can have a series of split units, which is very ugly. It might cool the building, but it's very ugly. So in terms of evaluating value for money, which one is the better value for money? So it's not simply looking at the bottom line. The second factor, as a quantity surveyor, that I pay particular attention to is how the cost of the building is distributed, right? So that if the value of the building is 100% and 50% of the value goes in the structure, that signals to me that something is wrong. This tender is doing what in the industry we call front loading. So they are front loading their tender. So in terms of value, that doesn't give me value. That gives me risk. Another item I would consider is the preliminaries. If the preliminaries are too high, again, that's skewing the tender in a certain manner. What you want to look at in a tender is the balance of the rates. So if one tender is giving you a tile worth $50 a square foot, another tender is giving you a tile worth $30 a square foot, which is the better value, right? So it's not simply looking at the bottom line. The bottom line has to be taken in consideration with the overall design, the overall tender, because it's not simply a bottom line they submitted. They submitted a full breakdown. They were required as part of the RFP to submit a breakdown. They were allowed to provide quantities or not provide quantities as they saw fit. So in evaluating the tender, you would look at all these things. So it's for this reason I'm saying you cannot evaluate against the lowest tender, but against the internal estimate, because the internal estimate would have been based on certain parameters, right? And based on what each tender decide to provide you with.
So in your evaluation of the cost factor, did you first assess a value for money or a balance of each bid?
No, I did not evaluate value for money as a part of my evaluation. I looked at all the to see that the arithmetic was correct to start with, do an analysis of the tender and look at how the costs were distributed. And based on that, I only submitted to UDeCOTT the bare facts of what was submitted. I didn't provide an opinion that this tender is better than that tender. The evaluation committee would make that determination based on the information I provided them with.
Right.
None of this.
Yes, Mr. Mutu?
I have a question arising out of, sorry, I have a question arising out of that. Ms. Benguche Duncan, do you accept that she was the chairman of the evaluation committee?
Yes, I'm aware of that, yes.
Yes. And you can't say for certain what the evaluation committee did?
No.
Good. Did you have an opportunity to look at the transcript concerning the debriefing meeting with NH?
No.
Okay. Did you listen to the recording?
Which
of
recording?
Of the debriefing meeting?
No.
Okay. Well, I want to read something for you. The transcript is CC4 to Mr. Conlon's witness statement. And this is what Ms. Benguche Duncan says. It's at page 26. And let's take it from line 2, where Mr. Byrne put a question to her. I want to see if I can get the electronic number for the benefit of the tribunal and Mrs. Peake so that they can follow. One moment. Any update on the flash drive, Mr. Tiwari?
Not yet, Mr. Mutu.
It's on page 128.
I'm told it's at page 128 of the Kieran Conlon witness statement. And this is what is posed by Mr. Byrne, who is representing the interests of NH at that debriefing meeting. Question. No, okay. So let's assume it's not abnormally low. And what he's talking about there is a bid. And you have a budget. Let's just say of $100. I come in at 50 and someone else comes in at 150. We both get the same mark because of that? This is the response from Ms. Benguche Duncan. Persons above the budget, no. Based on the formula, if you are below the budget and you are not abnormally below the budget, you basically would get full marks. Question from Mr. Byrne. Okay, so if two people are below the budget, we both get full marks. Answer from Ms. Benguche Duncan. Yes, once it's not abnormally low. Yes. So that is UDeCOTT's explanation as to how they applied the criteria for persons below the budget. Now, what I want to suggest to you, Mr. Tiwari, all of the considerations that you spoke about in answer to the question from the panel of member Cely, you don't know for a fact whether any of those considerations were taken into account.
I know that they were not applied.
Okay,
and
good.
A formula was applied to arrive at the figures.
Thank you, Mr. Tiwari. And that formula that you say was applied, that has not been disclosed in your witness statement.
I did not disclose it in my witness statement.
Right.
But
and
I know
as far as you know, UDeCOTT has not disclosed it. As far as you know. If you don't know,
but in terms of disclosing it to other parties, I'm not aware.
Yes, okay, fine. That's as far as I can go at this stage in the absence of documentation. I find it a little bit curious, given that Mr. Tiwari is 2 blocks away.
But perhaps would you be willing to go on to the other witness and let Mr. Tiwari organize the?
No, I think that's going to interrupt the flow of what I want to do.
Sure. Okay. Mr. Tiwari, are you able to check?
My secretary hasn't come back upstairs yet, so they haven't come. You heard me? I said my secretary didn't come back upstairs.
Yes. Okay. So what
I'm gonna make a call now and find out.
Sure. Okay. So what you do? We could have a break for 5 minutes. You can follow up Mr. Tiwari, and perhaps speak on your, and you can also follow up on the delivery, and then we resume in 5 minutes, which will take us to basically 4:35 p.m.
Can I invite you, Madam Chair, before we take the break, to give the witness the normal caution?
Yes, Mr. Tiwari, before you get into your call, you are under oath. You are not to speak with anyone about these proceedings. You are still being cross-examined.
Unfortunately, it's the attorneys who are going to be sending the documents to me. So I have to call them to give me the documents.
No, I understand you can call them to collect the documents, but discussing the contents of the documents and cross-examination, you are forbidden from doing so.
Thank you.
Right?
Yes.
Thank you. Yes, so we return at 4:35 p.m.
Mr. Muthoot, let me just indicate, apparently they were having some delay in downloading the document, so they're actually trying to get Mr. Tiwari to come to UDeCOTT's office where he could see the soft copies.
Okay, thank you for that clarification, Mrs. Speaker.
Hi, good afternoon, everyone.
Ma'am, I understand that because there was the documents were taking a long time to download on the flash drive, they've made arrangements for Mr. Tiwari to be at the UDeCOTT office. So I believe he is here now.
Yes, I think I see it on the screen.
Thank you.
But you're instructed, yes. So, Mr. Mutu, you may proceed. Mr. Tiwari, are you hearing us?
Yes.
Right. Okay, so Mr. Mutu is going to continue his cross-examination.
I'm obliged, thank you. Mr. Tiwari, I'd like you to help us with the orientation of the RFP document, to just understand the structure of it, right? Do you have it in front of you?
It'll be up on the screen shortly. Yeah.
All right, okay.
Yes. Yes.
So it starts at page 1. And it should be headed Request for Proposals.
1 minute. 1 minute.
Right. Do you have the facility to scroll through it?
Yes, you can. 1 moment, please.
Thank you.
Can you give the electronic page number in the application for review? I think that might be the difficulty.
Yeah, I think it's seeing it as number 1 on my bundle. I'm just trying to ascertain.
No, but it comes after the application, so it wouldn't be 1. It might be 16 or 17.
Yeah, we're just checking.
Yes, we have it up now, please.
Right, and you're seeing a document that's headed Request for Proposals? Yes?
Yes.
And what is the page number? So we know how many pages you are ahead. Is it 17?
I'm looking at it from my witness statement attachment.
Okay, brilliant. So that we can, so you have a physical document in front of you?
No, on the screen.
Okay.
So, okay.
I see. Okay, well, let's refer to the internal page numbers of it then. You see on the bottom right, the internal page numbers?
Yes.
Right, so this is 1 of 34. So
yes.
This is a request for proposal document, right?
Yes.
And it contains, well, there's also a project scope of work document. And that begins, well, that's the next document that follows, I believe. That runs from pages 58 all the way through to 64. I'm not sure what is on the electronic bundle.
64, yeah, 34 pages there.
It's not the internal page.
It starts on page 74.
You have the internal page number?
Well, it's a fresh document. It starts at page 1.
It's page 74.
It's page 74 of the Form 8. In electronic page number 74 of Form 8. Perhaps we can try and take this more quickly, Mr. Tiwari. Let me see if I can do it this way, right? The RFP contains a project scope of works. Isn't that
Yes.
right?
Correct.
And
Yes.
that's essentially a general description of what is required. Correct?
Yes.
Yes. And then the RFP also contains conceptual designs prepared by UDeCOTT.
Yes.
Right. And then what is followed are performance specifications. Yes?
Yes.
And those specifications tell a bidder in detail what are the standards against which he is required to carry out the works. Correct?
Correct. Yes.
And then you also will have a BOQ. And in the BOQ for this project, that's where the works to be carried out are set out in detail. And the contractor is asked to price against those various items. Correct?
He's asked to break down his tender according to those items.
Yes. And essentially, when a contractor is looking at what he's bidding at, he's looking at the specifications and he's looking at the BOQ. Yes? And the conceptual design.
No, that's not. You are talking about a design bid bill. In the design bill, normally they do not provide you with this breakdown.
Right. Okay, but the breakdown was provided here.
Sorry?
The documentation was provided for this project.
A form of bill of quantities was provided, and tenders were asked to populate that form to break down their price.
Exactly.
So they populate the items they use, they put in items that were not included, and they show how their price was derived.
Right. So the bill of quantities is where a contractor looks at to understand what the employer wants, what the items of work that the employer wants him to be able to price for. When he prices for it is another matter.
That's not correct. This bill of quantities for the contractor to tell the client, this is what I'm giving you.
Okay. All right. So, but this is what, I mean, the bill of quantities must serve some purpose. You accept that?
Yes.
Right. And it allows the contractor to know what to aim at.
I don't know what you mean by aim at.
Okay. What the client wants.
Not necessarily, no. What the client wants is that when you give me a tender sum, you break it down so I could analyze it. And I want you to break it down in this format.
All right. Now, your evidence is that the RFP was clear that acoustic treatment for the auditorium was a key component, and NH didn't provide this in its tender bid.
That is correct. Yes.
Okay, good. And you also say that the RFP was clear that acoustic treatment for walls, including auditorium walls, was required.
Correct.
Yes. Now I've looked at the RFP, and I have been unable to find any specifications for acoustic treatment for the auditorium.
I don't think that is a requirement. The RFP would have said you need to put.
Listen to my question. Well, let me put it differently. There is no specification for acoustic treatment for the auditorium in the RFP documents.
Well, there may not be a specification, but there's a requirement.
No, but there's no specification. We agreed on that.
Well, I don't know what you mean by a specification. There's no specification for concrete.
You understand what the term specification means in the construction world?
Yes, very much so.
Okay, yes. And that is a particular requirement. It's like a performance specification. That's one type of specification. Don't you have that?
But that is...
No, don't you have performance specifications?
Where?
In the construction world.
In the construction world, yes.
In this project, didn't you have performance specifications?
Well, I don't know what you mean by performance specifications.
Page 108.
It's page 108 of your witness statement. There's a big document headed Performance Specifications for the proposed head office of the National Lotteries Control Board.
Okay, sure. I have that document. Go ahead.
So you know it now.
Scroll on. Right. Okay. Yes.
So you're familiar with what I'm talking about now?
Yes.
Okay, good. There's nowhere in that document that specifications for acoustic treatment can be found. Do you accept that?
Yes.
Okay, good. I want to suggest to you that there's nowhere in the RFP documents, the whole bundle of documents, that you will find any specifications for acoustic treatment for the auditorium. Do you accept that?
I need a minute to check that. Within the table of contents of the specifications, I don't think it is there. That is correct.
And similarly, there's nowhere in the RFP bundle of documents that there are any specifications for acoustic treatment for the walls.
I don't think that is correct. I'll have to research that and give you an answer, but I don't think that is correct.
You didn't identify any specifications in your witness statement, did you?
I think there was a reference to acoustic treatments.
I am talking about specifications.
Well, no, I don't think there were specifications particularly.
Good. So that's consistent with what I have found. But there are specifications in the RFP documents for all kinds of things, aren't there?
Standard specifications, yes.
Yes.
Even things that are not required in this project.
Right. NH pointed out, from your review of the documents, you had a lot to say about what NH did and what it didn't do. But NH pointed out.
I don't recall doing that.
Well, hold on, I didn't finish my question yet.
No, but you said I made a lot of statements regarding what NH did and didn't do. I don't recall doing that.
Right.
That is not correct.
You made comments about NH's design not taking into account end user requirements?
No, I didn't. I said it was 9 stories, it wasn't 7.
Okay, so you made no comment about end user requirements.
I said it has to conform to end user requirements.
Okay, so is your evidence that it does conform with end user requirements?
I did not analyze it and I was not part of that evaluation.
Oh, I see. So you are unable to say whether NH's bid conformed with end user requirements.
That is correct.
Right, okay.
Only insofar as it was more than 7 stories high.
Oh, I see. Okay, all right. Now, I'm suggesting to you that NH pointed out in its response to the RFP, in its bid, that the RFP was silent on the use of special acoustic treatments to the auditorium. Does that sound familiar to you?
That NH said that, yes.
Right. But NH did, in fact, also specifically point out that the RFP was silent for any special acoustical treatment of the internal walls of the auditorium. So not just only the auditorium, but also the internal walls. Yes?
The NH is saying that the RFP did not specify that.
Yes.
Yes, well, and it said that, but I don't know if that's correct. But
right.
I need to research that to confirm whether that's correct or not.
But you spoke about acoustic treatments, didn't you? Didn't you research that before you came here, Mr. Tiwari?
Yeah, but I really can't point it to this point right now where it is. But I'll have to go back and find it and point it out to you.
Okay. Look at paragraph 14 of your witness statement. You say there on the 3rd line, going to the 4th, NH submitted a proposal but did not include acoustic wall treatment in the auditorium. You're familiar with that?
Yes, I believe that was stated by NH in the attender. Isn't that correct?
Yes, yes. I am answering your question now, Mr. Tiwari.
No, well, I mean, they said that they didn't provide it.
Well, that is not correct. I want to take you to what is page 536 of the Form 8. Has that been managed? Has UDeCOTT managed to be able to download that for you yet, Mr. Tiwari?
I'm in the office here. They have it here.
It's
Right,
552 of the electronic.
It's 552 of the electronic bundle, M2.
Sure. Enclosures?
No, it is item It's item 10 and item 11. It's internal page 4 of 17.
470.
4 of 17, internally. And this is the contractor's proposal.
I haven't found that page, Mr. Muktu. You want to refer to, you want to tell us which document again?
The contractor's proposal.
Contractor's proposal.
Yes.
Just ask them which pages again.
Which proposal?
No, which page?
And which page in the proposal?
It's internal page 4, and it is page 533 of NH's Form 8. Do you have NH's Form 8 with you?
We have it. Yes.
552. Yes.
All right, go ahead.
Are you seeing item 11 towards the bottom of that page?
Yes.
Okay, good. Take 2 paragraphs above item 11. The last, well, it's the last.
And it has allowed for outfitting of the auditorium.
Right. The RFP was silent on the use of special acoustic treatments to the auditorium space. Thus, NH has not included any special acoustical treatments to the internal of the auditorium space. You see that?
Yes.
Good. Go down to item 11, sub-item 3, auditorium.
Yes.
RFP was silent for any special acoustical treatment of internal wall of the auditorium space. We have included for a basic acoustical wallpaper to help with reverberation. You see that?
Yes.
So therefore, NH is saying in its bid, it did provide acoustical treatment for the walls of the auditorium by way of wallpaper.
But not for the specialist acoustical treatment that you would expect in an auditorium.
Well, hold on, Mr. Tiwari. We've been through the fact that there are no specifications for acoustical treatment. We've been through that. So what I am suggesting to you is that to the extent that you say NH did not provide acoustical treatment for the walls of the auditorium, that is an incorrect statement.
No, that is not an incorrect statement.
Okay, let's move on. I don't have the luxury of time. I want to suggest to you as well that NH provided acoustical treatment for the ceilings of the building throughout. Do you accept that?
Suspended ceilings, yes.
Acoustical suspended ceilings, yes. That's what I'm suggesting to you.
Well, all ceilings are acoustical, so.
Right, okay, yes. Now, the evaluation committee made no complaint, because you've told us you've looked at the report. To the best of your knowledge, the evaluation committee made no complaint about the lack of acoustic treatment for the walls generally. Isn't that so? Isn't that so? If you don't know, you don't know. If you don't know, you don't know.
No, my question is.
No, Mr. Tiwari, I'm asking the question.
Sorry, not my question. In order to respond to your question, I need to know, is it in relation to the cost of it? Is it in relation to?
I am talking about the item itself.
Which item is that?
Acoustic treatment for the walls generally.
Yes.
Evaluation committee made no complaint about NH not providing acoustic treatment for the walls generally. If you don't know, you don't know.
It's not I don't know. The question is inappropriate. It cannot be answered because it has.
I'll move to another question. There is no specific. Well, is it your evidence that the walls for the entire building required acoustical treatment?
No.
Only the auditorium.
The auditorium needs acoustical treatment, whether it's wall, ceiling, floors, whatever, they need it.
Yes.
So I can't say the walls alone.
No, what I'm saying is insofar as acoustical treatment for walls is required, the only place that you're saying it is required is inside the auditorium.
Yes.
Okay, good. You've already told us you make no evaluation about the facade, right? Not being in keeping with end user requirements. Give me one moment. Trying to see what I can cut out. I have no further questions for Mr. Tiwari.
Thank you, Mr. Mutu. So, Mr. Chanona, let me ask you one more time. You have any questions for Mr. Tiwari?
No, no questions to Mr. Tiwari.
Any re-examination, Ms. B?
Just one area. Mr. Tiwari, in response to member Kelzik, who had inquired of you about value for money. Remember that discussion?
Yes.
And then Mr. Mutu inquired of you as to whether value for money was taken into account in the cost criterion. You remember that?
Yes.
And having regard to your witness statement, which talks about the different modes of evaluating cost, would you accept that the way that NH is requesting that the cost component be evaluated, that is by having regard to the lowest bidder, would not provide the value for money which UDeCOTT is trying to achieve?
Yes.
I'm objecting to the question being posed.
Yes, Mr. Mutu. Can we ask Mr. Williams, can you put Mr. Tiwari out for a short while?
Yes.
It's not long enough because he's asking to step out of the room.
I will ask him to step.
My objection on the basis is that this is not a question which arises for the purposes of re-examination. There was no ambiguity from the witness about it at all. He gave a clear answer. And there's no need for an explanation. That's a short basis for the objection.
Thank you, Mr. Mutu. Mr. Speak.
With respect, I don't agree that there is nothing that arises out of cross-examination, and indeed it arises out of the question asked by the member, and we're entitled to have his evidence clear, what he means when he speaks about value for money, because they're two different proposals, as it were, being put. NH is suggesting the only way that you can have value for money is by having regard to the lowest bidder, and his witness statement is very clear that that does not achieve value for money. So I'm sorry.
You can proceed, Ms. B. You're listening.
Yeah, so it seems to me I'm entitled, arising out of the questions that were put by the member, followed up by Mr. Mutu, to ask the witness that question. And I think it's something that would assist the panel.
Yes, we tend to agree with Ms. Peak. The question does require some clarification. His response, that is, does require some clarification. So objection overruled. Ms. Williams, can you have Mr. Tiwari return to you?
Yes, one moment, please.
Whilst we await the re-entry of Mr. Tiwari, Mr. Chanona,
Yes, ma'am.
do you anticipate you have a cross-examination for Ms. Cely?
Yes, ma'am.
Yes. Are you able to tell us how long you will be?
Maybe an hour.
Oh, would you want to go before Mr. Mutu or after?
After.
Okay, Mr. Mutu. Thank you very much, Mr. Chanona. In terms of Ms. Cely?
Probably about 45 minutes,
No.
maybe. But
Yes.
I think Mr. Chanona should be going before me.
On the mic not working.
Given the
Ms.
order,
Williams, we hear you.
given the order of the proceedings.
Yes, I understand the order of the proceedings, but he did not suffer any prejudice with the second. Having to go second for the first witness.
I mean,
Like, you can log out.
good afternoon, panel. Can you hear me?
Yes, we can hear you, but not see you.
Yes, we're having some difficulty with our camera. So we're requesting that we can just leave and come back in to rectify the issue.
Yes.
Thank you. Good afternoon, all.
Yes, Mr. Tiwari, on the issue of value for money. I'm not seeing any members of the panel, so just hold on a minute.
Yes, Ms. Peak, you may proceed.
Thank you. Mr. Tiwari, we were discussing value for money. You hearing me?
I'm hearing.
Yes. And there were 5 evaluation criteria utilized for this particular RFP, correct?
Correct, yes.
And including among them was cost.
Yes.
And were those evaluation criteria capable of ascertaining or assessing value for money of the respective bids?
Other than cost, no. In terms of design, and all has to be in relation to cost. The design in relation to cost, the specifications in relation to cost, the facilities in relation to cost.
So taking them all together in the aggregate, it is capable of assessing value for money of each individual bid.
I'm objecting. This is re-examination. Mrs. Speaker can't be putting the answer to the witness and then asking him to agree or disagree. That's a leading question.
I don't think it's a leading question, and clearly the witness didn't understand it as a leading question because he hasn't given a direct answer. Do you understand the question I'm asking you, Mr. Tiwari? I'm not putting an answer in your mouth. I'm asking whether you're aware that there were 5 criteria, including cost, and whether an application of those criteria, all of them, was capable of assessing value for money of each individual bid.
No.
Go ahead and answer.
Yes, you may answer.
Mr. Mutu. Hold on.
Sorry.
Hold on. Mr. Mutu, this question, are you objecting to?
Not this one. Not this one.
Because it seemed a bit different from the first question I heard. Right. So you can continue to answer this question, Mr. Tiwari.
Yes. Yes, it is capable. Yes.
All right. And there was a question, Mr. Mutu, I inquired of you about whether there were specifications for acoustic treatment. Remember that question?
Yes.
And you were suggesting that there did not need to be specifications?
Well, it's a design bid build, so the designer would have to provide what is required for an auditorium. Right.
So in other words,
even if the specification is not there, the designer has to provide what is required for an auditorium.
And in this case, the page that Mr. Mutu took you to talked about wallpaper. Would you regard that as satisfying the requirement of acoustic treatment for an auditorium?
No, not fully.
Yes. Miss P, hold up. Miss Williams, can you ask Mr. Tiwari to leave? And then Mr. Could proceed with objection.
Is someone engineer?
Yes, Mr. Mutu.
On multiple grounds. This does not arise, in my respectful submission, out of my cross-examination. The question is an expertise, a question going to construction expertise. Mr. Tiwari is a quantity surveyor, and the question is designed as to comparing whether what NH has provided by way of acoustic wallpaper complies with, well, what, right? A specification, he has already said there's no specification. So that demonstrates it doesn't arise out of what I said. And secondly, in any event, it's outside his area of expertise. He's a quantity surveyor.
Thank you, Mr. Mutu.
Mr. Mutu asked questions and took the witness to page 553 of the document and read out for him the references in NH's bid to acoustic treatment, and in particular that they have not included for any special acoustical treatment, and 3 of 11 which said we have included for basic acoustical wallpaper to help with reverberation. So it arises directly out of his cross-examination. And even though Mr. Mutu says that he's a quantity surveyor, that didn't stop him from asking the questions in relation to acoustics. So why is it I am not entitled to re-examine him on something that was raised here when the witness was very clear in response that you do not need specifications for everything? And he was directed to this particular sentence, which is talking about acoustical wallpaper to help with reverberation. And the specification, I think it's not specification, sorry. The RFP required acoustic treatment, including for the auditorium. So I think that's a perfectly legitimate question, and unless the panel thinks otherwise.
So, Ms. Speak, I agree that it came out of the cross, but there's no need for further clarification. There was no ambiguity in his responses when he was cross-examined by Mr. Mutu on that issue. So we would agree with Mr. Mutu on this.
As you please, ma'am.
Have any more cross-re-examination questions?
No further re-examination for this witness.
Thank you very much. Ms. Williams, could you just bring back in Mr. Tiwari so that we can discharge him?
Yes, will do.
Mr. Chanona, this is to confirm. Do you want to cross-examine Ms. Cely first?
No,
that is the natural order, actually. But
what's that, ma'am?
That is actually the natural order. Your matter arising being CP2. Yes, okay. We have Mr. Tiwari here. So, Mr. Tiwari, there are no further questions for you. You are finished here for today, and you are discharged.
Thank you.
Good to go. Sorry, wrong statement. But yes, you can leave. All right, so we're going to go on to the second witness for UDeCOTT, which is Ms. Cely.
Yes, Simon Cely.
Ms. Williams, can you get the witness?
Yes.
Yes. Yes, Mr. Chanona, you were saying.
Well, since they're already doing NH, I thought they'd finish NH, but if you prefer that I start, then I'll go. It makes no difference. It would be nice if Mr. Mutu went before me, though. Being a learned counsel, it would maybe help me.
Mr. Mutu, do you want to take up the offer to go before?
I'm very grateful for the kind invitation, but I will await Mr. Chanona. The issues in his challenge and my challenger are different.
No problem. So, Mr. Chanona, you will, once we swear in the witness, you will proceed with your cross-examination.
Okay. I need to bring a light closer to my desk, if that's okay.
Yes, that's fine.
Good afternoon. We have Ms. Simone Cely.
Thank you, please, Ms. Williams. Ms. Cely, you have to be sworn in first, and then we will start your cross-examination.
Good afternoon, Ms. Cely. Could you indicate if you wish to swear or affirm? Okay, please raise your right hand and keep it raised for the duration of the oath. I, repeat after me, I state your name,
Simone Cely,
do solemnly, sincerely and truly affirm that the evidence I shall give to the hearing panel in this case shall be the truth, the whole truth, and nothing but the truth.
Ms. Peak, you may proceed to lead the witness.
Good afternoon, Miss. Yes, thank you. Good afternoon, Miss Cely.
Good afternoon.
You gave a witness statement in this matter, Miss Cely,
I did.
and you're a senior accountant at UDeCOTT,
I am.
and the facts and matters contained in your witness statement are true and correct to the best of your knowledge?
Yes, it is, to the best of my knowledge.
Thank you. Ma'am, may her witness statement be taken as the evidence in chief, please?
Any objections from Mr. Mutu and Mr. Chanona?
None from me.
It may be tendered as SS.
Thank you.
Thank you. Mr. Chanona, you may proceed.
Good afternoon, Ms. Cely.
Good afternoon.
All right, you are familiar with the witness statement of Mr. Laban?
I will have to pull it up. I did go through it.
Well, it's page 135 of our bundle.
Just say one moment. One moment, let me. What page?
Well, you got the bundle, right? You got the...
Yes, it's here, yes.
Okay, so it's item 6 of his witness statement.
Item 6.
Have you found it?
Just a minute. You have the witness statement. So I have up the witness statement and the trial bundle. Which one am I looking at?
Well, in our trial bundle, it's number 135, page 135.
Okay. All right.
It's item 6 of that document on page 2.
Uh-huh.
All right. The first sentence in item 6, do you agree that is an accurate statement?
So I'm looking at, well, item 6 is about Ms. Aisha Kismat Ali, procurement officer. That
sentence, yes, ma'am.
Okay.
Just assist Mr. Chanona. I don't think this witness was present at that meeting.
Yes, she was.
Oh, she was. I'm sorry.
Maybe I should phrase the question. Were you present at the negotiation meeting?
No, I was not.
Okay. So the
Mr. Chanona, do you want to read it out for the purpose of us getting it on the record?
No, I wanted to read the
Paragraph 6 that you mentioned.
You are a member of the evaluation. Well, let me go to your witness statement. Maybe that would help me. The recorded the people who are present in the negotiation meeting, and your name. So you are not a member of the negotiation meeting.
I was not in the negotiation meeting.
Okay. All right then. The statement that Mr. Laban has here is that Ms. Ali, Ashia Kismat Ali, procurement officer, stated that the purpose of the meeting was to seek a possible reduction for a more efficient costing closer to their budget. So the meeting was prefaced with a specific purpose.
I'm objecting to that question, Ma'am. This witness was not present at the meeting, so to ask the witness questions about the meeting, I don't think that would be appropriate.
Fair enough. Then I go to the evaluation report, which is our 168 in our bundle.
Okay.
You were a member of this tender evaluation report?
I was, yes.
Okay. And this report was signed off on the 25th of April. Can you confirm that?
Yes, I will.
Yes.
You can confirm that, right?
Yes, yes. Yeah. Yeah.
And the signature on page 29 is your signature?
Yes, it is.
Okay. You refer to negotiations in this report?
Yes, it's there.
All right, but you were not part of that negotiation meeting?
No.
Okay. But you know a meeting was held on April 19th?
I'm aware.
All right. Did the other 4 members of this evaluation committee share with you what transpired at that meeting? Did I yes or no?
Yes, it's here stated in the...
No, that's not a question. The question being asked is, did the committee, or the committee members share anything of that meeting of 19th of April 2024?
Yeah.
Is that yes, that no, I don't know?
Yes, yes.
Yes, they did share it with you, right?
Mm.
So notwithstanding you're not present, as counsel says, you are aware of what is discussed there, right? Partially aware?
Partially,
you think so? Partially aware?
Yeah, partially aware.
So you know some things and you don't know other things because you don't know what you don't know, right?
Yes.
That's a yes? Okay.
Correct, yes.
But you make reference to it, right? You go forward and under item 37 saying that the meeting was informed that the proposal is over the client's budget. So they told you that part of it, right?
Yes.
Okay. All right. So Mr. Laban, even with this statement says that, which I just referred to a little while ago, Perhaps you can look at it because this is relevant to what the questions I'm going to ask you, right? Well, all right, your council, I mean, chair, I'll help. So just bear with me, right? Because I cannot bear over this, right?
Would you like us to share the document?
Okay, so perhaps if you can put up this document, this page 27 on the
of the evaluation report.
Of Laban.
Can that be go up on the screen, please?
It's a Laban statement.
No. This is the evaluation report. That's on page 168 of our bundle, and we're on page 27 of that document.
Yes. So give us some minutes and we'll get it up. So Ms. Cely, when we project the documents, you could perhaps look at the screen to see the document.
Okay.
Page 27.
Page 182 of this document. Page 182. Is this the page, Mr. Chanona?
This is the document, is page 27 of that document. The 28 pages, this is the second to last page of this document.
What is the page number on your trial bundle?
Well, the number I have is the document number. So if you just keep scrolling, that's
okay, right.
Till you reach the very last, second to last page.
That'd be 194.
Keep going, please.
This is the page, Mr. Chanona?
No, ma'am. Keep going.
Keep going.
Right there. Go ahead higher.
This is the page.
Just come back, please. All right. So on the negotiations, these were the statements made, right? And this is a document you signed.
Yes, it is.
All right. So you agree with everything that's stated here, right?
Yes.
All right. So there was a meeting held. In the meeting, the proponent or sales was informed that a fee proposal is over the client's budget and requested we look at the costs. We were told of which line items or rates were high and that the overall cost should decrease to meet their budget. Did the committee, when you were briefed on what took place in the negotiation meeting, did they share with you what were these rates and what were these areas that they wanted the cost reduction done?
No.
No, they didn't. Okay. All right. So 38 says they were informed of the line items where the rates were high and their overall cost should decrease to meet our budget. I want to put into evidence that Mr. Laban version of that is slightly different, because he says that the purpose of the meeting was to seek a possible reduction for more efficient costing closer to their budget. Okay.
Okay, hold on.
We go to
Mr. Chinawa.
Yes, ma'am.
If you are putting your case, allow Ms. Williams to answer.
Oh, sorry.
Did you hear what Mr. Williams said? You can either
No, I didn't.
accept.
Sorry, ma'am.
No, not sorry, not Miss Cely, sorry. Did you hear what Mr. Chinawa said? He's putting his case to you.
Yes, I heard what he said.
Did we get a response? Do you agree or disagree?
So if I disagree that this is different to what Mr. Laban said?
No, not any different. Mr. Laban expanded on it a bit more. So perhaps the committee members would have shared with you what was said, because Mr. Laban is very specific in what he's saying. The note in this thing that you signed the document to makes reference that the fee proposal is higher, and that we relook the cost, and we should decrease by something to meet the budget. Mr. Laban's version of it, which may or may not have been shared with you, was that the meeting was to seek a possible reduction for a more efficient costing closer to the budget. This is a very specific and clear statement.
Yes. So, Mr. Chinawa, suppose you have to ask her a question, or you can put your case to her. So, is it that you're asking her, or you're putting that to her that this is what happened?
No, what I'm putting to her, she was briefed by her committee members.
Yes, and that was answered.
And if this what Mr. Laban put here was what she heard, or she heard something different, it was never mentioned, because she's signing a document that refers to.
Okay, one at a time, Mr. Chinawa. You have to answer each question, each step. So, can you answer that question, Ms. Cely?
Which question exactly?
Mr. Chinawa, go over what you were saying about what Mr. Laban stated.
All right. Perhaps we could put Mr. Laban's document up on the screen. That would be
you 131. Page.
Yeah, page 131 of the
yes.
Sorry, so page 135 of our bundle, and it's on page 136.
136.
So page, the following page, ma'am, item 6. Keep going. You're 3.
Paragraph 6, please.
Item 6. Hold on.
Right.
All right. So Mr. Laban made this statement here. What we just read from what was signed was that the rates were high and the cost should decrease. What Mr. Laban has put here is that the purpose of the meeting was to seek a possible reduction for a more efficient costing closer to their budget. Not to match the budget, but to bring it closer to the budget. Would you disagree that this is an inaccurate representation of the meeting? Before you answer that, can I ask you, have you heard the debriefing, the video recording of the debriefing meetings as well as the negotiation meeting?
No, I would have just gotten a brief.
You got a brief. So you have not heard the recordings of the negotiation meeting. You have not been given that evidence.
No.
Neither have you heard the debriefing meeting.
No.
But those documents are entered into evidence in this hearing, and you're a witness for the respondent, no?
Yes.
And this is critical to our case, because what is stated in that meeting is exactly what is on the screen in front of us right now, verbatim.
Okay.
Can I ask the hearing panel to assist me?
Yes, Mr. Chinawa, before we go on, remember you're either asking her questions or you are putting what is your case to her, not comments, not a commentary.
Okay.
Right. So tell us what assistance you require from the panel.
Well, the witness has not had the privilege of listening to the negotiation minutes that is in evidence. So we can refer to the that recording, that's in evidence, and there's a verbatim note on it, right?
Yes, but Mr. Chanona, what are you going to ask about the recording? Do you want us to play the recording for the hearing?
No, because we well, the recording would reinforce what I'm saying. All right, so it's the negotiation meeting at the very beginning. I don't know if you can refer to the verbatim part of it. I can read out what he said.
Okay, so Mr. Chanona, right? In terms of stuff that the witness cannot answer, is something that you can deal with in your submissions. But for now, you're going to question her on her witness statement, and you may put what is your case to her.
But she makes reference to something at a negotiation meeting that's going to guide the evaluation process.
Yes.
So for her to be part of the evaluation process, to make reference to a meeting and arrive at a conclusion,
yes,
it's relevant that she's aware of what transpired at the negotiation meeting. I mean, the fact that UDeCOTT has not seen it fit to share that information with her is not, I can't take responsibility for that.
Yes, but that, Mr. Chanona, is a point for submission. It's not for cross-examination.
Okay.
What she stated already is that she was just briefed. She was not there in the meeting.
No, we understand that, but I wanted to the extent of what the brief was, because she says that they were in the negotiation meeting. All right, so we can probably take this down because they said she's not there. Could you put back up what was there before, which is the...
She wasn't a part of the meeting, so...
No, but all right, but also I'll go back to 168, which is the report that that was signed in evidence. The our bundle 168, I guess it's 168 plus 27 and 180. So try 191, please, maybe.
Yes.
7 and 68 is sorry.
Yes, I think it's lower down this page.
90, 93.
Right, this page, yes.
95, sorry, 95, right, okay. All right, so you're aware that a letter was submitted on the 23rd of April that brought in a cost, right? As stated on the screen, right?
Could you repeat if I'm aware?
No, but what's stated on the screen is at 39 is that submitted a letter dated the 23rd of April.
Uh-huh.
All right. You are aware of that letter? You have had sight of that letter?
Hold on.
Cely, you have to answer the questions.
Yes, I did not see the letter.
But in this signed document, you made a statement that the letter exists, return your costs, and you have affixed your signature to it.
I did.
Do you sign documents that have information that you're not aware of before and just sign?
Well, the negotiations would have taken place between different members of the committee, and we usually rely on the...
You answered the wrong question. You answered the wrong question.
Usually rely on the committee members with their expertise.
So, Miss Cely, can you answer Mr. Chanona's question? He asked you, do you usually sign documents without being aware of the content?
You don't know.
I was aware of the content. I did not see the letter per se.
Miss Cely, can you listen to the question and answer the question that has been asked of you? We have to record it. Mr. Chanona, can you ask the question again? Miss Cely, but you have to listen to the questions and answer what is asked of you. Yes, Mr. Chanona, continue.
All right, so you are a member of the evaluation panel.
Yes.
And you signed a report dated the 25th of April attesting to the validity, veracity of these documents.
Yes.
The signature was not qualified. You didn't say signing for page 10 and page 5 and page 7, right? You signed a 27-page document.
Yes, I did.
Right. And the document, it contains inside it that there's reference to a letter dated the 23rd of April. And the statement says this cost is still over the budget.
Yes.
So you're aware that a letter has a cost and it's over the budget.
Yes.
Okay. We go to point number 40, the point right after this.
Please, hold on.
Just one more page. No, sorry. Go down, go to number 40, please. All right, so there's a note there that it should be noted that the client indicated that they cannot provide funding over the approved budget. Was that a criteria in the evaluation that you just completed? Is that one of the criteria for evaluation? That you cannot provide, the client will not provide funding over the approved budget?
That is not a criteria for the evaluation.
Okay, but it's stated here. So what's the significance of this item being stated here? What relevance is it to this evaluation report that you're signing off on?
It speaks to the limitation of funding that the client has.
And what relevance, you're not answering the question, right? What's the relevance of it being stated here? This is an evaluation report. Is this part of an evaluation process?
Well, you have to make, yes, it is.
It is, all right. And where in the evaluation process is it stated? Because can we go back to costs? It's part of this document at I don't know what page it's on.
Which document would you like? This
very document that's in.
So I know it's in the trial bond, but if you tell
no. This right, that's right up on the screen, right?
Yes, the evaluation report.
Yes, which is up on the screen. So I'm just going to subtract out how much pages to bring it back down to.
And as we proceed, Ms. Cely, if you're unclear of the question, please indicate. You are not allowed to just remain silent and not answer the questions.
Noted.
All right, so if we go back to 7 pages down from 193 would be 185.
185, Mr. Chanona?
Yeah. Keep going, kind of hard to. If you could just keep scrolling back, going in a reverse direction to the beginning of the. If I see what page number this is, I'll be able to. Right, this is page 17. So could we go to page 20?
20.
Which would be 187, I think. All right, so at the bottom of this page. Pause right there. So you are a senior accountant at UDeCOTT?
Yes, I am.
And this criterion 5 on the cost is being evaluated in line of the RFP proposals, right?
Yes.
And it says here the cost submitted by each proponent was evaluated against the construction cost estimate.
Yes.
All right. What has been tabled in evidence so far, and you can correct me if you don't have that same information, is that there's a formula that was used that would take the internal cost estimate or the construction cost estimate as referred to here against each proponent's price, right? And a certain number would drop out that would be allocated against the 30 points here. Is that a fact? Is that a factual statement I'm making?
In the one envelope system that UDeCOTT uses, yes.
No, not talking about this RFP that is being evaluated on. So the RFP had a whole section inside it, 5 sections. The 5th one was cost. And what was shared with the panel to date is that each proponent's submitted fee proposal was put into a formula that had the client's internal estimate, as you put here, construction cost estimate, and it was evaluated and a certain score kicked out. Is that a factual statement? It is, okay. Are you aware of the score that Kee Chanona got?
Yes.
What is it?
Let me check.
Well, I'll help you. It's 28.6.
Okay.
All right. Out of a total score of 30 points.
So just to be clear, Cely, when you say okay, are you agreeing with Mr. Chanona?
Yes, I'm just verifying it with.
All right. So 28.6 out of 30 points. I rough that percentage to be 95.3%.
Okay, I will take your word for it.
Well, you're accountant. You can pull a calculator and check it.
Mr. Chanona, hold on.
Yes, ma'am.
She went to verify. Are you accepting what Mr. Chanona gave as the score?
Yes, the score is correct. The score that he said was correct.
Right. So, Mr. Chanona, before you move on to your second question, I'll just be minded you're halfway through the allotted time.
Right? Okay.
Yes. So you continue to the second question, Mr. Chanona.
All right. So
which was about the percentage.
All right. I put to you that that's a 95.3% score.
Okay.
Okay, I mean you agreed with me.
Yeah, I'll take your word for it, yes.
All right. Just make a comment. When I was a little boy in school and I got over 95, I got a big star. And my parents took me to buy KFC. That was a major achievement for me. Would you think that's a good score to get? Is 95.3, would 95.3% be a good score? Would you consider that to be scored very highly?
95 out of 100 is a high score.
It's a high score. So it meant that our price was pretty near to the required cost construction estimate. Would you say that?
Yes.
Pretty near, right? Okay, so what we had in evidence was that we were asked to do exactly that, to come as close to it as possible. I go to the negotiations, the briefing meeting. Were you a part of that that panel?
The briefing? No, I was not.
You was not, okay. All right, so let's go back to the same document, but to page, I think it's 193 or 195. Could we go to page 195, please, of the same document that's on the screen? Right, conclusion. All right, so number 41 says, in light of the above information and the inability of the top rank to provide the services within the budget, it's recommended that the second rank be done. So is this a new criteria being introduced?
No, it is not.
All right, but it seemed to imply that if the submitted price is below the above the number, there's some criteria that's going to say we have to move to the second rank. So this is a criteria being introduced. I mean, what informs this process?
Mr. Chanona, you have to allow to answer the questions.
Oh, sorry.
We ask the criteria and then we move on to what informs the process. And we haven't gotten an answer to the first questions. And Ms. Cely, you need to answer the questions. If you're unclear, please indicate you're unclear.
Could you please repeat the question?
All right. If I take line 40 and 41 together, it seems to imply that because the submitted price was above the client's budget and could not provide funding, that a new criteria is being introduced. Because 41 goes forward to say, in light of the above information and the inability to get below a price, you have to move on. So I read into this that there's a new criteria being introduced at this stage. Notwithstanding, we scored, sorry, can you agree with me or disagree with me?
I don't agree with that.
All right. So then second question, what informs this process? Why did you have to move to the, having ranked 95%, what informs the process that my inability, because you have a formula that we just discussed that takes the client's budget and each proponent and rates it. We got a rating of 95%. We're now saying there's a new criteria that says, besides that, you got to get below the budget. But then the formula that you had would have captured that information, right?
Correct.
Okay, then why the inability of the top rank proponent has failed?
Because it was in excess of the budget.
Which was a criteria within the evaluation process. Yes?
No, it's not. No.
All right, so then a new criteria is being introduced that says it has to be below, equal or below the client's budget. Am I right in saying that?
No.
Okay, then you want to explain to me, you're saying that you can't get the job because you're too high. So I'm asking, so the criteria is I can't be higher? They said, no, we're not saying that. So exactly how did this formula work? I mean, the document went all the way up to 40 and made a statement. It's above the client's budget. Okay, it's above the client's budget. I asked you what's the significance of that information. You said it's just a statement. It's not significant. Shall I ask the question again? What is the significance of 40?
In an evaluation, and when you consider...
No. You stated something. What's the purpose of this being stated in an evaluation report? It's specific. It says something. There's a reason for it?
Yes.
All right. What was the reason?
That if the bid couldn't be covered by the funding, then you'd have to move on to the next proponent.
And that's stated in that was not taken into account in your cost evaluation, was it?
No.
Okay. So if I would use, all right, so my formula for costs would be the client budget against the contractor budget. However, if it exceeds the client budget, you get a score of 0 because this is now a pass-fail criterion, right? Is this a pass-fail criteria? If you don't match it, you fail.
No, it's not.
Okay, then why are we not? Why did we move to the next proponent then?
Because during the negotiation, we were unable to reach to a level that would allow the budget, client's budget, to cover it.
But that was stated in the negotiation meeting that we have minutes of. We are told we need to come as close to the client's budget as possible. And now what I'm reading here is that.
Mr. Chanona, do you want to answer these
sorry.
statements in my questions? Yes. Continue, Mr. Chanona.
All right. Item 40. What's the there's a reason why item 40 is there, right? Is there therefore that follows this? Therefore, all right, okay. All right, because I trying to get a straight answer from you and I'm not getting it, right? It says it should be noted, means that everybody needs to note that the client indicated they cannot provide funding over the approved budget. And what's not stated is therefore anybody beyond the approved budget would be considered to have failed. Would that be an accurate interpretation of what 40 means?
That's not what 40 says.
No, I know that. I'm asking if is there an interpretation because 41 flows from 40. So what does 40? What is the relevance of stating 40?
The relevance of stating 40 is acknowledging whether the client can or can't provide funding over the approved budget.
Right. And 41 says, in light of the above information, is that a new criteria being introduced? Because of what's stated there?
No.
All right. But you just said if it's above the client budget, the project wouldn't go ahead. They don't have enough funding to go ahead.
That's what's stated in 40.
Well, it says they cannot provide funding over the approved budget. That means the project, as the RFP has gone out to people, says if this comes in above a certain budget, I can provide the funding.
Correct.
And the project would not fly. So any proponent that comes with a budget, with a price above the budget, would deem to have failed.
I don't know if it's failed.
Well, they push them aside to get somebody else. I mean, so I was head of the game, though I'm second. Something has moved me from first place to second place. And it seems to be a new criteria of pass-fail as it relates to the client's budget. Is that a fair interpretation of what 40 and 41 means?
No.
All right, so you want to tell me what it means? In your opinion, as an accountant?
The client indicated that they could not provide funding over the approved budget. So in the evaluation, we had to find a proponent.
What part of the evaluation, ma'am?
In any evaluation.
No, not anyone, this one. You send an evaluation report. So you said something inside this evaluation report says you have to do something.
Well, you enter into negotiations to see if you could.
That's right, which we did, and we just went through all that, and it came down, but not sufficiently enough.
Right.
But a conclusion is being drawn in light of the above. It informs something. So in light of the above, we have to do something else. And I'm saying, well, what informs that in light of the above? Where's the directive in the RFP that directs that in light of the above, that you're now presented with something and you now need to move forward? So something informs that process.
Cely, we are waiting your answer.
Well, it will have to be the internal estimate. It will have to be.
Which you did, and you had a factor of 95.3%, which you said was a very high score. So it's already covered for inside there, right? So sorry.
No, go ahead.
No, I'm making a point that comparing the internal estimate, that's under item, the fifth category of cost, and it was used. And you got a score. But what's in front of us seems to be a new criterion being introduced. That's not part of the published, solicitation document.
Ma'am, this question has been asked about 3 or 4 times, and the witness has answered. So I don't know how many times Mr. Chanona will be permitted to ask the same question.
Well, can somebody give me the answer, because I didn't get it yet?
Ms. Peak, we are still awaiting on the answer from this witness. That's why I repeatedly told her.
No, she gave the answer about 10 minutes ago when he asked it the first time. But if you want to ask, if he wants to ask it again.
Well, for the record, Ms. Peak, can you repeat the answer she gave?
Yes.
She said it is not a new criterion. She said that, and it's part of the record.
I heard that it's not a new criterion. So what is it?
Yes, he asked. That's what he asked after, and we're waiting on the answer for that, Miss Cely. If it's not a new criterion, what is it?
If it's not a new criteria, then if you're doing an evaluation.
Ma'am, the question I asked him, it says, in light of the above information, that's a statement that infers a decision is going to be made on some basis. I put it to you, it's a new criterion being introduced. You say it's not a new criterion. So what is in light of the above information? What is that referring to?
That during the negotiation process, the amount that came in.
Ms. Cely, we would have moved on from the negotiation. Mr. Chanona moved on from that several occasions before, said that there was a score of 95. After that, that's what his question is based on. Am I correct, Mr. Chanona?
That's absolutely correct.
We have moved on from the negotiation.
Can you answer?
Evidence is that it is not a new criteria, and Mr. Chanona is allowing you to say what is it then, and we are waiting on the answer.
It's just a statement that the client indicated they cannot provide funding over the approved budget.
Right. You said that before, and you also asked what was the purpose of the statement. Isn't that correct, Mr. Chanona?
Yeah, no, I'm asking the statement at 41 says, in light of the above information. Yes, we're clear with what you said. The client can't provide funding. In light of the above information, a decision is being taken. And I say, is that a new criteria that has been introduced? And it says no. Then what is being done in light of the above information to move us from first rank to second rank? You don't know.
That the client is unable to cover the cost as established by Kee Chanona.
Cely, do you understand the question being asked? Because the question about the client being able to answer the cost, you answered that a while ago. Do you understand the question that is asked of you?
Yeah.
Yes?
He's asking in light of the above information.
Yes, the client don't have the money to pay for the job. Therefore, in light of the above information, the following will happen. What informed that following to happen? What was the basis of it? I'm saying it's a new criteria. You say it's not, it's something else. It's something that informs that decision to move this way.
The negotiation process.
Negotiations started at 36 and finished at 40. We're into conclusion now. It's all stated, it's all there. We've gone through all the negotiations. We now drawing a conclusion. Something is informing the conclusion. I'm asking, what is it?
Okay, so let me see if I can assist. Ms. Cely, in light of the information that you said was just information on number 40, what was done to move KCL from position 1 to position 2? Is that the question you want to ask, Mr. Chanona?
Yes, Madam Chair.
Yes.
I still have to say that would have been the negotiation process.
We have passed the negotiation. This is after the negotiation.
With respect,
yes,
ma'am.
Yes, please.
Perhaps the witness could leave the room.
Yes. Thank you. Ms. Williams, could you ask Ms. Cely to leave the room?
She has left.
Thank you. Yes,
I don't think it is fair to tell the witness we've passed negotiations when we're onto something else, because the paragraphs which preceded in the light of the above information is captioned negotiations. In the light of the above information does not refer to in the light of paragraph 40 above. And the witness keeps saying repeatedly it is not a new criterion. It arises out of the negotiations and the bidder was not able to meet the client's budget. And that is the answer she's given. I don't think it's fair to tell the witness that is not responsive to the question, because this does not say in the light of paragraph 40 above. If you scroll up the page, you see 1, 2, 3, 4 paragraphs dealing with negotiations. So all of that precedes paragraph 41.
Yes. Okay, thank you, Mr. Chanona.
Yes, I agree. Negotiations finished at 39. There's a comment at 40, and now we come into a conclusion. So could I ask then, what is the above information? Isn't that all the preceding information that came up to this page? Everything that went before? A cost report that's done that gave us a score, a process that was followed during negotiations, and then the insertion of something seemingly totally out of context with everything on these 28 pages. It should be noted. Well, should that be noted at the RFP stage? Noted in an addendum? Because that seems to be the linchpin on which this entire thing is hung. We take every box from page 1 to page 27. Then this number 40 sentence just appears.
Yes, Mr. Chanona.
And it's a statement of fact. The man have the money, so you can't spend it. So therefore, what?
Yes, Mr. Chanona, we are responding specifically to Ms. Peak's objection. Do you have anything additional to add?
I'm not quite sure what you have to say.
Okay, so if
I can't say anything more than the questions that put. I mean, the evaluation process is being concluded and says in the light of the above information, and it says, well, what is the information? Well, the client don't have the money to do it. Therefore, we're going to the second rank. And I'm asking you, what informs that process? Well, the client have the money. Okay, we understand that. So is there unwritten criteria that says if they don't have the money, fail the proponent and go to the next one? Yes, because that seems to what is being inferred, implied, insinuated, suggested.
Okay, Mr. Chanona. So, Ms. P.
Yes, sorry, I took an objection. Can I respond? In my respectful submission, that is a matter for submissions. That Mr. Chanona can say whatever he wants to say, that paragraph 41 doesn't follow from paragraph 40 or the preceding paragraphs, but interrogating the witness on what do you mean by in the light of the above information really goes to a construction of the document that I think is a matter for submissions. But if the panel thinks that this particular line of cross-examination is helpful at this hour of the day, well, then it's a matter for the panel.
Well, Ms. Peake, the witness was not answering the questions. And that's the difficulty we're having because Mr. Chanona went through, he asked about the score in the negotiation, the 95, and then we got to the stage of establishing that Mr. Chanona is saying that his score was a high score, the witness accepted that. Then we moved on to essentially saying, no, there's this line here, and Mr. Chanona basically asked, what is this a new criteria being introduced? And she said no. And if she's saying no, it's not a new criteria, he asks her simply, well, what is it?
No, so I think
the 41 was to try to explain because she seemed perplexed and did not answer. Well, if it's not a new criteria, then what is it?
I think the question that was asked was what do you mean by in the light of the above information? And the witness's answer was negotiation. And the chairman said to her, we've passed that. And my objection was that is the witness's response because in light of the above information includes what preceded it. That is to do the negotiations at paragraphs 36 to 39. So the witness was answering the question and she was stopped and told, well, you know, we've passed that and you're not answering the question. That is the witness's answer to the question.
No, the question I'm asking was a new criteria introduced by virtue of, in light of the above information. Cely is a senior accountant who attended this evaluation meeting and signed it. So she's one of 5 signatures here, evaluator number 4. She's concurred with what here. So, I mean, this is a major move. This is the conclusion of the evaluation report. So much so that the top rank is being set aside. And I'm asking, what was the basis of it? So can you explain what was meant by that word in light of the... I suggested a new criteria. She says, no, she don't agree it's a new criteria. Then what it is?
That is what I understand too, and that was a clear question.
All right, okay. All right. We're not going nowhere, so all right.
Mr. Chanona, is that you want to move on from it?
Well, yes, because in light of time, yeah.
Well, no. If this is
I'm not a lawyer. I don't feel like a blue crab again. So, listen.
Yes.
You could bring back the witness, please.
Sure. Ms. Williams, can you get Ms. Cely, please?
Could we go back to negotiations, the 36 to 39, please?
Yes.
Just go up.
Mr. Cely, you have actually reached your half the entire hour.
Oh, I'm almost finished here.
Yes.
Ms. Cely is back with us.
Yes, thank you.
Could we go back to 36 to 39? Yeah, just bring it down a bit first, please. The previous page to this one.
Can we move to paragraph 39?
Well, 36 to 39.
It's one.
Just bring down just bring the page down one. Can we bring the page down, please?
Yes, I'm seeking to get some support to bring the page
Sorry,
down.
sorry.
Oh, sorry. To go up
The next direction.
194, please. Page 194.
Yes, please continue. Up again. Okay. All right. Ms. Cely.
Yes.
All right. So you say that you're aware that a meeting took place on the 19th of April.
Yes.
You're aware that a letter was submitted on the 23rd of April.
Yes.
You haven't seen the letter, but you're aware of its existence.
Yes.
All right. So April 19th was a Friday. April 23rd was a Tuesday. This evaluation document is signed on the 25th, 2 days later. Just making a statement.
Yes.
You're aware,
okay.
all right. Okay.
Yes.
You're aware. All right. You're aware that the negotiations as set out in the RFP was to do. Maybe we can refer to that in our. I think almost finished, madam. Can I get maybe 10 more minutes, please?
Yes, Mr. Chanona.
All right. You're aware that it's in evidence that there was a negotiation period set aside, maximum of 2 weeks. You're aware of that?
Yes.
All right. You're aware that the client can terminate the hearings at any time they think it's not going in any positive direction?
Yes.
You're aware of that, right? Okay. The negotiation you said you were not part of the negotiation meeting, right?
Correct.
Neither have you heard the tapes of it either, right?
Correct.
All right. So if I refer to the respondents' submission, which is respondent submission is
Mr. Chanona.
almost finished.
I understand you have the time, but it doesn't mean that you need to revisit or re-ask.
No. This is a new submission. This is a new submission. Right. 151.
No, but this is.
I'm asking for the respondent's skeletal submission.
Well, no. She has to be cross-examined on witness statements, evidence, not submissions.
Oh.
Either her witness statement or some other witness statement, but not submissions. You will respond to the submission.
Sorry. Okay, sorry. Let me get her witness statement. My apologies. I was focusing on the thing, right? So my serious apologies. So can we go to the client's witness statement, which is on page 139 of our bundle? Right. Okay. So I'm going to page 6, where it refers to KCL in particular, items 27 onwards. Continue. All right. So we're focusing on 28, which we accept as being factual. And then I want to focus on 29, but it's in 2 parts. So if you could just, I don't know if you could split the page in 2. Is it possible? No, you can't. All right. So 29. Let's look at the other page that has 29 in it.
Mr. Chanona, do you want the statement paragraph 29?
Well, I would like 29 and 28 and 29. If those 2 could be just put on the screen.
My lady, we have the paragraph up on our end.
Sure. So paragraph 29.
Well, it's 28 and 29. So we just have to go on 2 pages, right? So that's fine, right? So
If you want, you can read it out to the record, Mr. Chanona.
right. Okay, so let me deal with 28 first, right? So Ms. Cely you're making a statement that during negotiations, the contractor was informed that its proposed price was over budget and should be reduced by things. If this was done, KCL proposal would have been within budget. You are not at the negotiation meeting. So the statement that you're put here is informed from what source?
From just the briefing that I would have had.
Which debriefing?
No, not the briefing. When I would have spoken to the other members of the committee.
And that would have been during the evaluation process, right? Or next time?
No, that would have been after the evaluation process. Because negotiations would have passed.
All right. So you spoke to all 4 members of the committee, or you spoke to some of them or others?
I think I may have just liaised with Ms. Bangoshe.
All right. So we could put in record that Ms. Bangoshe advised you that during the negotiations with the contractor, you were told that the proposal over budget and that the cost needs to be reduced by a percentage. That's what she shared with you.
Correct.
All right, the last sentence, is that an inference you have made, or she shared that with you as well?
The last sentence of what?
Of item 28. If this was done, is that your opinion, or was that stated by Ms. Bengoshe?
No, I think that is just a fact.
What's the fact?
In terms that if it was released.
All right, so you're drawing a conclusion that if we got it done, then we'd be within the budget. So that's your statement. That's what you have inferred.
Yes.
Okay, fine. All right, so we go now to number 29. And it says, the revised letter submitted by the deadline date set out in the respondent's letter. Do you know where this deadline date came from? You read it in a letter, right? But could you tell me where that deadline date came from?
I can't remember off the top of my head.
But this is a statement that says you submitted by the deadline date set out, dated that. All right, so the negotiation period, was the 19th of April to the 2nd of May. That's a 2-week period, right?
Right.
No, you're over 10 minutes. The extra 10 minutes you asked for.
I know. Okay. All right. Please just maybe 5 more minutes.
Question?
Yeah, that's the last question. Yeah, this is it.
Yeah. Right.
All right.
So last question.
All right. So you're referring to a deadline. Just talking about this, number 29. So the last question. Well, last item of discussion is that.
Oh, no, not the last item. Think about it, and let's have one question or two. No more than 2 questions, because you asked for an additional 10 minutes, which we readily provided you with. And much of this is
could I go up to the second part of the next page, the second half of 29?
Sure. Yes.
All right. If the sentence says the respondent therefore formed the view that the revised proposal could not be accepted, what informed that view? The fact that the price is above the budget, the client's budget?
Cely?
That KCL's proposed price. Proposed prices could not be reduced by less than 6%.
All right. So it formed the view that it could not be accepted because of that and decided to abort the negotiations. You have evidence of the negotiations being aborted?
Evidence?
Well, you said, and decided to abort the negotiations. We are unaware that the negotiations were aborted, but you're making a statement that because of this fact, the respondent decided to abort the negotiations.
I don't think there's any evidence of abortion of the negotiation.
Right. Okay. But we submitted on the 23rd. Do you know when the thing was aborted? When that decision was made?
Not off the top of my head.
All right. We submitted a letter on the 23rd, and on the 25th, you signed a document that says we can pass. So somewhere between the 23rd of April and the 25th of April, a decision to abort the negotiations was taken.
Mr. Chanona.
All right. I leave my learned counsel in your. Sorry, ma'am.
Right. So we were saying one question. You went into 2, but yeah. I believe that the last question they asked may very well be unfair to the witness because she was not aware. I believe she said when it was aborted. Right. So.
No, but this is a witness that she says decided to abort. But my point, Madam Chair. She received a letter on the 23rd, It was referred to in the evaluation process. And on the 25th, the evaluation was signed off with KCL not getting it. So somewhere between the 23rd of May.
Yes, Mr. Chanona, that is
April.
Mr. Chanona, this information you can address in your submissions.
Okay.
Right?
All right. Well then, I'm
right. So this is for submission, right? So we will end your cross-examination at this time here now, and we will allow Mr. Mutu. Oh, any examination to speak on Mr. Chanona's cross? Would you want to wait to the end?
I'll wait on the end. I don't have anything arising out of Mr. Chanona's question.
Thank you. Mr. Mutu.
Thank you. Could I ask? Yes, okay. Thank you very much. Ms. Cely, you, I think we've established that you are a member of the evaluation committee, yes?
That is accurate.
Right. And the chairperson of the evaluation committee was Ms. Bengoche Duncan?
Correct.
Yes. In you answering questions to Mr. Chanona, you said in the context of the evaluation report, I relied on members of the committee with expertise. You recall saying that?
Yes.
Okay.
Yeah.
Who was a member of the committee with expertise in relation to the evaluation of cost criteria?
So the cost criteria is just a part.
I'm asking you, who was the member of the committee with expertise in relation to cost criteria?
The cost is a formula. The cost criteria is a formula.
Yes. Ms. Cely, could you listen to the questions that you've been asked? It is very late in the evening, and I just went through this exercise with Mr. Chanona. He asked you who. So you're supposed to identify a person. Who is the person with the expertise?
Ms. Bengoche.
Good.
Duncan.
Excellent. So Ms. Bengoche Duncan, you relied on who in relation to the determination of the cost criteria? Yes?
Yes.
Good. Do you know why she hasn't come before this committee, forgive me, this panel today to give any evidence?
No, I do not.
Okay. Are you familiar with the debriefing meeting held in relation to NH?
I am not.
Okay. Okay, so I take it that you didn't look at the transcript.
No.
Okay. In relation to the evaluation report, there's no formula for cost for the evaluation of cost set out in the evaluation report. Isn't that correct?
Excuse, I didn't get that.
I'm sorry, let me repeat it. I said in the evaluation report, no formula for the evaluation of cost, the award of points in relation to cost, is set out in the evaluation report. Isn't that correct?
Correct.
Yes. And the evaluation of cost of all of the criteria, the evaluation of cost is the single biggest criteria. You accept that?
Yes.
Okay, good. And that is dealt with at para 25, isn't it? Of the evaluation report.
Just check. 25. Yes.
It's on page 20.
Yes.
Correct? And would you agree with me that apart from one sentence, there's actually no explanation as to how cost criterion was evaluated?
Yes.
No formula. Correct? But your evidence earlier today was that a formula was used. Correct?
Yes.
Yes, good. And there's no formula. I'm trying to move through this quickly. We've been here all day. There's no formula set out in the criteria published, or that formula that was used rather, is not set out in the criteria published in UDeCOTT's RFP. Correct?
Correct. Yes.
Good. And in fact, I'm going to read something for you from what Ms. Bengoche Duncan said in answer to a question in the debriefing meeting. I could take you to the transcript if you would like.
Yes, please.
Okay. The transcript is CC4 to the witness statement of Kieran Conlon, and it's the electronic page is 127, and the internal page of the transcript is 25.
Okay.
127 of the transcript of the bundle.
Yes.
Yes, are you with me?
Yes.
Good. So I'm going to start from the bottom of the page at line 24. This is Mr. Byrne, a legal representative for NH.
Right.
And he's posing this question to the members of UDeCOTT's team who are there. And you'll see from the next page is answered by Ms. Bengoche Duncan. Can I ask you to read to yourself from line 24 on that page across the page to line 12?
Sure.
And let me know when you've read it.
There's the case, right?
Have you read it?
Yes.
Okay, so I'm going to summarize here. I'm suggesting to you that what Ms. Bengoche Duncan is saying is that people who put in bids above UDeCOTT's internal budget were scored on a relative basis, awarded points on a relative basis in relation to the budget.
Yes.
Good. And those persons who scored below the budget simply got full marks out of 30.
Yes.
Yes. And you don't disagree with Ms. Bengoche Duncan, do you?
I do not disagree.
Good. Would you therefore agree with me that the formula for awarding a score for persons above the budget was different to the formula for awarding a score to persons below the budget?
No.
No?
No.
Okay, let's go through that a moment. Persons above the budget, we already established this. They get specific scores in terms which are relative to the budget. Yes?
Yes.
Good. So if you have a bidder who is above the budget, if you have two bidders who are above the budget, their scores will differ depending on their price.
Yes.
Good. But if you have two bidders who are below the budget, their scores will be equal, even though they have different prices.
Once it's not abnormally low. Yes.
Yes, once it's not abnormally low. So having gone through that exercise with me, don't you now accept that those persons who are above the budget are scored on a different basis or scale or standard whatever word you want to use, to those who are scored, to those who come below the budget and are not abnormally low. It's a different method.
I don't believe so.
Okay, you don't believe so. So you are saying is your evidence that the method being used, as explained by Ms. Bengoche Dongshan, is uniform. Whether you are above or below. It's a simple question, Ms. Cely. Is it? Are you saying it's a uniform method? You're on oath.
Let's see.
Cely, are you going to get an answer this afternoon? Do you understand the question?
Could you repeat?
Is it a uniform method? People above the budget are assessed in the same way that people below the budget who are not abnormally low are assessed. Is the method uniform?
I would say it is.
Okay. Is this method, on your understanding, is this method of scoring set out in the RFP?
No.
Good, thank you. No. Do you accept that persons who tender in relation to an undisclosed internal estimate are trying to hit an unknown target for their bids? In order to score the maximum points on this system, we'll be aiming at an unknown target.
No.
Okay. Do you accept that bidders who are tendering bids do not know what the internal estimate is at the time of tender?
Yes.
And do you accept that bidders at the time of tender, based on this method here, in order to get the highest score, have to either hit the estimate or fall below it?
Could you repeat?
Do you accept that bidders at the time of bidding, in order to get the highest score for cost criteria, either have to hit the estimate or fall below it?
To get the highest, yes.
Right. And you also accept that they don't know what that estimate is?
Yes.
And if they don't know what the estimate is, they can't know what they have to do to fall below it. Correct?
I don't agree with that.
If I tell you to attain a certain criteria or to hit a certain mark, you have to fall below X, and you don't know what X is, do you know what to aim at?
In that context?
Ms. Cely, these are very straightforward questions. I mean, if you're having difficulty understanding my formulation of English, let me know. Can you answer the question?
My answer would be no.
Meaning you don't know your target that you have to hit at. Correct?
No, you would know your target because you have the BOQ and the details, whatever guess they're asking you for.
The BOQ doesn't give you a price. The BOQ gives you a target as to design or as to requirements, but we're talking about price.
Okay.
So talking about price, let me revisit the question. First, in relation to the example of X, if I tell you you have to hit a target and the target is X, and you don't know X, and you put in a bid, aren't you guessing?
You have to answer the question.
Can I just no?
No, you're not guessing. How do you know what to do to hit X, where X is a number?
Are we talking about in terms of this evaluation? This in general?
About the number.
About this evaluation,
Yes, about the number.
So the details that have been laid out in the RFP?
I understand the details as to what you have to do and what the specifications are. Ms. Cely, you are accountant?
I am.
You deal with numbers every day?
Mostly.
Yes, I'm asking you questions about numbers. You appreciate that?
Yes.
Right. And in the world of mathematics, and I suspect in accounting, sometimes you deal with an unknown variable.
Yes.
Right. So X is an unknown variable in my equation to you.
Okay.
You understand that?
Yes.
You understand that? And what I'm saying is that the budget, UDeCOTT's internal budget is an unknown variable to bidders.
Yes.
Yes. And if it's an unknown variable, then it must follow to try and hit it. You have to try and guess what it is. You might have you might have material which might help inform the guess, but you're still guessing. Isn't that so?
Okay.
No, not okay. You can't cop out of this question like that. Isn't that so?
I disagree.
Okay.
Yes. So, Mr. Cely, going forward, can we get a clear yes or no? The okay, it's difficult for us to understand exactly what you're saying.
Yes, Chair.
Thanks.
I want to move to another area. Human resource experience, human resources. This formed a scoring area for UDeCOTT. Isn't that right? It was one of the criteria.
Yes, it was.
And you dealt with it in your evaluation report, didn't you?
Yes, we did.
Right. Whose expertise did this criteria fall under?
It was the team. It wasn't one person in particular.
Okay, right. By the way, did you produce a score sheet?
A score sheet at the end.
Yeah, but you've produced. Oh, sorry, you filled out your own individual score sheet.
We usually discuss it within, and then one form is filled out.
I see. So it wasn't a situation of individual scoring then. You sat as a committee, and then you came up with a score.
Correct.
Right. Now, that's very interesting because let me take you to page 22 of the transcript. Right, that is CC4. Page 125. Okay. I want to take you down to line 22. Well, actually, let me take you to the page before, page 21. which is electronic page 123. Are you there?
Yes, I am.
Let's pick it up from line 24. This is Mr. Peters. This is NH's representative. He says, all right, and so the scores that we have here are the average scores that each evaluator had generated on their own independent evaluation of the various submissions. Miss Kismat Ali says, yes. You see that? And
Yes.
Ms. Ali was a member of the evaluation committee. See
Yes.
that? Let's turn the page. The next page. And let's go down to line 22. Mr. Peters is posing this question. Right, so the scores are presented and an average score is generated. And that's why we have fractions, I guess, occurring in some occasions. Mr. Bengoche Duncan, yes. So what I'm suggesting to you is the evidence given by Ms. Bengoche Duncan and Ms. Kismat Ali is in sharp contradiction to what you've said about scoring. You accept that?
Yes.
Good. So who is being untruthful, you or them?
So when we set in an evaluation, can I answer that question?
Who is being untruthful, you or them? Both can't be true.
Did you answer, Mr. Lee? Mr. Lee?
Yes.
Yes. Could you repeat your answer?
No one is being this. What was I don't know what was the word that you used?
Untruthful.
Untruthful.
No, right. Neither of us are being untruthful.
Okay, good. Let's go to we'll submit on that. Let's go to the evaluation of human resources. This is at page 9, internal page 9 of the 10-day evaluation report, which is electronic page. This is page 81 to the witness statement of Conan.
This is the correct page, Mr.
Unfortunately, my disadvantage is I can't see what you have up. It's in the document. It's an internal page 9. It's headed Criterion 1.
Yes, that is.
I'm grateful. Thank you, ma'am. Now, UDeCOTT, I'm going to ask you to keep this up, but UDeCOTT allocated a total of 15 points for human resources assigned to the project. You recall that?
Yes.
Good. And 6 points of that were allocated to qualification of key personnel. Yes?
Yes.
4 points were years since completion of first qualification. Yes?
Yes.
So that's 10. So, and NH got 10 points for those. Yes?
Yes.
Good. Right.
Mm-hmm.
The last one, I'm sorry. Are you with me?
I'm seeing what's on the screen.
Okay. And this is internal page 9 that says criterion 1. At the top of the page?
Okay, yes.
Yes? Okay, right. So let's go down the middle of the page to table 6. Are you with me?
Yes, I am.
Right. So at the top row on the table identifies contract values, the value of the construction project. Correct?
Yes.
Right. And you are familiar that with the fact that the evaluation criteria under this category dealt with provided that projects to a minimum value of $5 million were to be identified. Correct?
Yes.
Right. So 5 million was the threshold the evaluation committee was dealing with for the purpose of evaluating under this item, experience. Correct?
Yes.
Good. But there is a graded scale as you go across the column. You see it?
Yes.
The row rather, sorry. Where different points are awarded on a basis of different percentages of the contract value. Yes?
Yes.
Right. And that was a methodology which was used to score. Correct?
Yes.
And that methodology is not stated in the RFP, is it?
No, it's not.
Good. Now, what you also have here, in the RFP, I'm trying to stay on the same page if I can before we move off of it. Right. Yeah. While we are here, NH was scored in respect of 2 projects. Isn't that right?
Yes, that is correct.
Pan American Life and Mahogany Court Housing.
Yes.
Correct? Now, Pan American Life was given 5 points. Isn't that right?
Yes, that is correct.
And Mahogany Court was given 3 points. Yes?
That is correct. Yes.
Right. So it was given 3 points because it fell into a category of other, which is shown on table 6.
Yes.
Right. Now, NH also had listed under the category experience for its architect, the Carnage Police Station. Isn't that right?
Yes, it is.
But the evaluation committee did not score Carnage Police Station. Correct?
Correct.
Right. But Carnage Police Station was a project, the value of which was in excess of 5 million. Correct?
Yes.
Good. So it ticked the first box. But it was also a project, if we look in the RFP, this is internal page 27, which is electronic page, 27 of the Form 8 and 43 of the PDF.
27 of Form 8.
It's internal page 27, but the PDF page is 43.
Okay. Yeah.
Yeah. And you'll see 3 bullet points from the bottom of the page. Are you there?
Yes.
Right. So let's just go 2 paragraphs, 2 sentences above. The sentence beginning, the key human resources identified above.
Yes. Yes.
And what that is a reference to, that's a reference to the architect. Correct?
Yes.
Yes. And it says identified above must demonstrate experience on at least 2 projects of a similar nature of at least 5 million. Well, we spoke about the 5 million threshold. So let me take you to the next one. For the purposes of this paragraph, projects of a similar nature means institutional and office accommodation buildings. Example, fire stations, police stations, prisons, office buildings, etc. You see that?
Yes.
Do you accept that the RFP is telling bidders that projects of a similar nature includes police stations?
Yes.
Good. And Carnage was a police station. Or is a police station? Yes.
Yes.
And in the course of Mr. Conan being questioned today, there was some discussion about, of a similar nature as indicated by the requirements. The evaluation committee did not apply that, did they?
Yes, they did.
Okay. When is there a project in Trinidad, is there a police station in Trinidad and Tobago that you are aware of that is 7 stories high?
I am not aware.
Okay. Are you aware of any police station in Trinidad and Tobago that cost approximately $150 million to be built?
I am not aware.
Are you aware of any school?
No,
Are you aware of any 7-story fire station?
No.
Okay. And therefore, what I'm suggesting to you is when this RFP defines projects of a similar nature and it identifies police stations as such, Carnage police station falls squarely into the definition. Do you accept that now? Of projects of a similar nature as set out in the RFP.
Those are not the words, Mr. Mutu. I think you have to quote the words of the paragraph. Technical specifications, I believe it says. What paragraph are you looking at, please? It's not up on the screen. It's not on the screen.
Okay, I'm grateful for this suggestion. Thank you. What I was putting to you is that when one looks at the RFP, the Carnage police station falls properly within the meaning of institutional and office accommodation buildings as defined in the RFP.
Of a similar nature.
I would agree with your friend that you need to give the exact words. Because institutional and office accommodation is just part of it.
Okay.
Of a similar nature as indicated by the requirements in the technical specification.
Well, perhaps the easiest thing is if the witness can actually see the page.
Sure, no problem.
Right?
It is page 23.
Yes.
When you get it, we can share it. Of the final Form 8 and supporting documents.
I have it up.
Right. What I am suggesting to you is that the Carnage police station properly falls within the meaning of projects of a similar nature as defined in the RFP.
I don't agree.
Okay. I'm also suggesting to you that NH, having identified the Carnage police station as one project in respect of which Mr. Homer worked, that NH should have been awarded full marks. That is 10 points in relation to sub-criteria experience and not 4.8 as they were in fact awarded?
I don't agree.
Okay. I want to move to one part of the evaluation report again, and then I'm going to move to liquidity and debt ratio. All right. Can we turn to internal page 17 of the evaluation report, which is PDF 89 of the Conan witness statement? Are you with me?
Yes, I am.
Good. In relation, so what we are seeing on that page that is not redacted are comments in relation to NH's bid. Am I right?
Yes.
Okay, good. You are not an architect, correct?
No, I am not.
Right. You are not a civil engineer.
Correct.
Nor a quantity surveyor. So am I correct in saying that these statements as set out here are statements which were not within your expertise?
Correct.
And therefore, these were statements in respect of which you relied on other members of the evaluation committee?
Correct.
Right. Let's move on as briefly as we can to liquidity and debt ratio. These items fall under the criterion proven financial capacity in the RFP. Is that right?
Are you looking at a particular page?
No, I'm asking you.
Oh, yes, yes, yes.
So, and that's criteria 4. Yes?
Yes, yes.
And this was allocated 15 points. Well, you could have attained a maximum of 15 points in respect of this criteria. Yes?
Yes.
And this criteria could be what is described as a non-price factor. Correct?
Repeat for me?
A non-price factor.
Yeah.
Yes? In fact, all of the criteria are non-price factors except the cost.
Yes.
Good. And on criteria 4, proven financial capacity, we had one sub-criterion was liquidity ratio, to which 2 points were allocated. Yes?
Yes.
And another was debt ratio, to which another 2 points were allocated.
Yes.
And am I right that there's nowhere in the RFP that identifies the liquidity ratio against which tenders would be scored?
Correct.
And nowhere in the RFP is the debt ratio against which tenders would be scored identified?
Correct.
So again, tenderers would have to guess as against the target which they're being scored.
No. No.
No?
Yes. Well.
Sorry, no or yes? Which one is it? Don't we have a circumstance? Let me take a question back. Don't we have a circumstance here where, again, the tenderers don't know what is the evaluation sub-criteria, if I could call it that? Well, would you agree it's evaluation sub-criteria?
Yes, this is, yes. Okay,
good. And tenderers don't know. They aren't told what is evaluation sub-criteria they're using.
That is
good. No, as to the liquidity ratio, I think at paragraph 23 of your witness statement, you say UDeCOTT and NH computed it in the same way. Am I right? Right.
The
so
liquidity, yes.
Right. So there's no dispute as to the mathematical product. And Mr. Conan deals with that in his witness statement at paragraph 62. You read his witness statement?
Let me pull it up.
Sure.
Yes.
Yes? And
Yes.
UDeCOTT accepts these ratios as correctly computed on the basis of NH's financial data produced to UDeCOTT. Yes?
Yeah.
Right. And I did the math. The average of these ratios is 1.51.
Yes.
You accept that?
Yes.
Right. Now you are aware that NH's case is that their liquidity ratio compares favorably with international standards for construction companies. Are you aware of that?
Yes.
Right.
That's it. Yes.
Right. And you disagree. Am I right about that?
Yes.
Right. Now, you haven't identified any local or international standards in your witness statements in respect of liquidity ratios, have you?
I have not.
No. You accept that you could have, don't you? It's fairly obvious. If they existed. Yes? Yes?
Yes.
Right. And you were coming here to assist the tribunal today, weren't you?
Pardon me?
You were coming here to give evidence to assist the tribunal on the issues.
Yes.
Yes? Did you look to see if you could find anything to substantiate a liquidity ratio of greater than 2?
Yes.
You did? And you were unable to find anything?
As it pertains to standards?
Yes. I see. Okay. Is it your evidence that there is no standard?
Not. Can I answer? Do I have to say a yes or no answer?
Well, it's a yes or no question.
Okay. There's no international standard as
Right.
far as I'm aware.
Well, there being no international standard on your evidence, wouldn't it have even been all the more important to disclose to bidders what liquidity ratio UDeCOTT was using?
If sub-criteria is provided, yes.
Yeah. You saw that Mr. Conan had annexed to his witness statement an exhibit setting out construction average industry financial ratios for US listed companies. You saw that?
Yes.
Okay. Well, I'm going to ask you a few questions on it. It is at tab 7 to his witness statement.
Could you give me the page? The electronic page?
Yes. 1729. 1729.
Okay.
Yes?
Yes, it's up, yes.
Right. So the liquidity ratio. Well, this here shows average industry financial ratios for US listed companies. You see that?
Yes.
Right. Do you doubt the accuracy of these ratios?
No.
Okay. Do you accept that companies which are publicly traded in the United States are required to attain and adhere to very high financial standards?
Yes.
Good. And that therefore, if a company which is publicly traded in the United States has a liquidity ratio, that liquidity ratio is going to be reflective of an excellent standard.
Can you repeat the question?
Companies, let me take a step back. Publicly listed companies are highly regulated in the United States, yes?
Yes.
And there are very stringent financial requirements that apply to them.
Yes.
Yes? And what I'm suggesting to you is operating in that environment, would you not also accept that the liquidity ratios that apply to those companies are required to be excellent?
Yes.
Yes, thank you.
Yeah.
Now, insofar as those ratios are shown on this document, they fall within the category of current ratio. Do you accept that?
Yes.
Good. And the years in question, and this document shows ratios for 2022, among others, but the years of 2022, 2021, and 2020. You see that?
Yeah.
And those ratios are 1.54 for 2020. Yes?
Yes.
1.51 for 2021.
Yes.
And 1.45 for 2022.
Yes.
Yes?
Yes.
That's using those 3 years, the same 3 years that NH had to submit accounts for. That's an average of a liquidity ratio of 1.50. You accept that?
Yes.
And NH's liquidity ratio was 1.51. Correct?
Yeah.
So it was better than the average liquidity ratio for publicly listed US companies in the construction sector. Correct?
Yes.
Yes.
Mr. Mutu, have about 10 more minutes again. Can be sufficient?
Well, I just have one last area, and this is debt ratio.
Sure.
And I would crave the indulgence of the panel to finish that area.
Sure.
A lot of my time today has been truncated because of Mr. Tiwari's difficulty with accessing documents, which respect is not an issue we are responsible for.
No, understood. But we when we started Ms. Cely's cross-examination, we asked you your time for that particular cross-examination. So proceed.
I'm grateful. I will try to wrap it up as quickly as I can. But in spite of that, average 1.50 liquidity ratio in your witness in as shown here. In your witness statement, you say at paragraph 5, UDeCOTT's calculation of liquidity ratios was the appropriate method of assessing individual proponents. Don't you?
Yes.
And I'm suggesting to you that it was not the appropriate method. UDeCOTT was using a liquidity ratio that was unnecessarily high.
I don't agree.
Okay. And not in accordance with certainly average US construction company liquidity ratios. Yes?
What is the question?
The question is whether you would accept from the exercise we've just gone through, examining the liquidity ratios, that UDeCOTT was using a liquidity ratio that was, well, I would use the word significantly in excess of that of the average liquidity ratios of publicly traded construction companies in the United States. You accept that?
Yes.
Right. Do you accept that publicly traded companies in the United States, that the standards which apply to them would be international standards?
Yes.
Now, after these challenge proceedings were filed by UDeCOTT, well, UDeCOTT has external auditors?
Yes.
Yes. I'm suggesting to you that NH ought to have been awarded full marks with a score of 2 points for liquidity ratio and not 1 point as UDeCOTT did. Do you accept that?
That your statement?
Yeah, on
Yes.
reflection now. Yes, you accept it?
That we should have awarded them 2 points?
Yes.
That UDeCOTT should have? No, I don't agree with that.
Okay. Now, as to debt ratio, you have shown UDeCOTT's calculation of that at Exhibit SS2 to your witness statement.
SS2, right.
Yes?
I'm seeing SS2. Yeah, that's NH, yeah.
Right. Now, using these figures here, you determine the debt ratio of an average of 0.60 over a 3-year period. Am I right about that, or am I misunderstanding the data?
So this is SS1.
Yes, I'm sorry. It's late in the day. Sorry, SS1. Forgive me.
So yes, 0.6.
Yes, SS1 is your calculation. Okay, and this is your computation in relation to your determination of NH's debt ratio. Yes?
So, yes.
Right? And it is 0.60 using an average of 3 years.
Yes.
Right? And the years are 2020 0.62, 2021 0.54, and 2022 0.63. Correct?
Yes.
Right. And we can go back to the same document we were looking at in Mr. Conan's witness statement with the ratios set out for the construction industry in the United States. CC7.
Right. Okay.
Yes?
Yes.
And under the first row, under the heading solvency ratios, we have debt ratio.
Yeah.
Good. And again, for the comparable 3-year period, we have 0.061, 0.55, and 0.58. Correct?
Correct.
And that is an average of 0.58 for the 3-year period.
I will take your word for it. I didn't do the calculation. I'll take your word for it.
Okay. Well, does it sound right?
Yeah, yeah.
Okay, good. Would you, in doing your computations, round off the figures? So if it's 0.58, would you round it off to 0.60?
No, it depends on no.
Okay, so you leave it at 0.58. Okay. And UDeCOTT, however, utilize a debt ratio of less than 0.5 for full marks. Correct?
Yes.
And that was a more stringent ratio than what is shown as the average for the construction industry for publicly listed companies. Correct?
Yes.
And again, you have not shown at all in your witness statement, whether by reference or attachment, to any international standards in respect of appropriate debt ratios for construction companies. Correct?
Correct. Correct.
Right. And is it your evidence that you looked and you weren't able to find?
In terms of standards, that is accurate.
Yes, okay. You will accept that the debt ratio identified in respect of publicly listed construction companies in the United States is comparable to the NH debt ratio.
Yes.
Yes. In the course of today, and I'm not going to take you to it, Mr. Conan was cross-examined on the question of debt ratios. What's this put in? He was referred to a document headed debt ratio, which was a link from a website. And there's a statement in that document, and I'm going to ask you whether you agree with it. It says in relation to debt ratios, the maximum normal value is 0.6 to 0.7. But it is necessary to take into account industry specific. As an accountant, does that statement sound familiar to you?
Yes.
Yes. And therefore, the debt, I'm suggesting to you that a debt ratio of 0.6, as NH's accounts demonstrated, was in fact an excellent debt ratio.
Excellent. No, I don't agree that it was excellent.
Okay. I'm also suggesting to you that it was a debt ratio for which NH should have been awarded a full 2 marks instead of 1 mark.
I do not agree.
May I have 1 moment? I just want to check to see if there's anything that I just need to finish up. One last question. In the literature we looked at today, it was read to Mr. Conan, dealing with ratios, that if the if the current ratio is too high, much more than 2, then the company may not be using its current assets on its short-term financing facilities efficiently. This may indicate problems in working capital management. Do you agree with that?
Yes.
But UDeCOTT, having agreed with that, UDeCOTT's position was that it was giving full marks for a liquidity ratio of greater than 2. Isn't that right?
Yes.
I have no further questions for this witness. Thank you.
The cross-examination.
No re-examination of this
Sorry,
witness.
examination, sorry.
No re-examination.
So, Ms. Cely, you are. Oh, sorry, I forget. Forget it. My other panel members. That's yours.
Yeah, let me see. So, Ms. Cely, I want to take you to the tender evaluation report.
Okay.
So I think I have page 8. That's not page 8, this would be page. In terms of the compliance check, right? There's no statement in there about any of the evaluator, any of the proponents not compliant, not being compliant. There's a compliance check and you state that all the bidders were compliant. Is that correct?
Yes.
There's also no further statement of any bid being unresponsive. Is that correct?
Correct.
And so that all the tenderers were evaluated as being responsive.
Yes.
Okay. In terms of the item, I go back to where Mr. Chanona was speaking about, I think it's number 40. Want to find the so basically I'm looking for the statement that states that it was determined that the negotiations were not successful. That you could not have a successful negotiation. What was the basis for determining that the negotiations had failed?
I'm just looking to see where you are reading from. Could you tell me where we're reading from?
Find that spot. Not finding the exact location here. I think it may actually be in your statement, not in the all right, sorry, yes. Sorry, it's your statement. Item 29. The respondent therefore formed the view that the revised proposal could not be accepted and decided to abort the negotiations as the respondent determined that it was not likely to reach an agreement with KCL.
Okay.
What determined that likelihood? What signaled to the respondent that they would not reach an agreement?
I don't believe anything was signaled to the respondent.
So basically, on receipt of the first submission, it was determined that the negotiations had failed. Because there's no communication thereafter, or there's no information thereafter of any action thereafter. Is that
correct? Yes, that's correct.
Okay. And then I want to take you to, I think, let me find the correct page. Okay, in the evaluation report at item number 9, you state that the evaluation of the technical component was based on the proponent achieving an overall score of 70%, and that would be the highest ranked. In your evaluation methodology, number 7.3, it says that the proponents will be required to achieve 70% of the overall total score to qualify. The proponent with the highest score will be deemed the top ranked proponent. The overall top score includes that cost element. Is that not correct?
Yes, it does.
So that you're basically saying that if they achieve 70%, including the score on the cost proponent, that they would have qualified to become the top ranked candidate. Is that yes?
Yes.
Okay, and Kee Chanona achieved that 70%?
Yes, they did.
Okay. How many of the other proponents achieved more than 70%?
You just double check. Everyone?
They all did. Okay. No more questions. So Miss Cely. So you're relieved?
Pardon me?
You're relieved we're finished with your cross-examination.
Okay. Okay, thank you.
As it relates to the parties, in light of our statutory obligation to deliver decision by the 27th, we are giving you all directions to file closing submissions by latest 4 p.m. on Monday, the 23rd. File and exchange. So the parties are to file and exchange closing submissions. Yes, Mr. Newton.
Can I ask for 8 p.m.? Some of us, or in fact many of us, have court obligations in the course of the day, and for the other submissions many of them we've been exchanging at 8. So if it is not too inconvenient to the tribunal, if we can have additional time.
It may not sound so, but it is, because we would not get it until the morning when we file it at 8 o'clock. Because we don't have access to OPR system after hours, right? So we will give you it then pushes back our deliberations a bit. So could we aim for the 4? And
I understand the difficulty the tribunal is in, so we will abide by the 4 o'clock time frame.
Yeah. So when you file after 4, we don't get it until the next day. And then we have to consider it before we can. Sorry, Monday, see, 24th, the 24th, yes. So I said the 23rd, but Monday is the 24th. Yeah, so if you can file the submissions at that time, and then we could probably allow you all to file the bundle of authorities at 8 o'clock. But at least file the submissions by 4 o'clock.
Understood.
Yes. Any concerns of Mr. Chanona? Yes, Mr. Chanona. No, sorry.
What is the bundle of concerns?
Oh,
what
okay.
is the second thing to file?
Pardon me?
The bundle of authority, what is that?
Oh, okay. So if you rely on any legal authorities, any court decisions, you can send us a copy of it. And that would be the bundle. So the submissions may refer to legal authorities. You can file the submissions by 4, and at the later time, you can file the authorities.
And submissions is like your closing arguments, right?
Yes, yes.
Okay, thanks.
Ms. Peak, do you have any concerns?
No. We have the directions, ma'am.
Yes, okay. So you may not get the order before Monday, but I hope everybody took a note. 4 p.m. Monday the 24th.
Yes, that's very clear.
Thank you so much for your participation in today's hearing. Do have a good weekend. It's been long, but we look forward to receiving the submissions so that we can comply. Have a good weekend, everyone.
Thank you.